Welcome to the second hearing of Portfolio Committee number 8, Customer Service, for the additional round of hearings for Budget Estimates 2025-2026. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the land on which we are meeting today. I pay my respect to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the land and waters of New South Wales. I also acknowledge and pay my respect to any Aboriginal and Torres Strait Islander people joining us today. My name is Emma Hurst and I am Chair of the committee. I welcome Minister Chanthivong and accompanying officials to this hearing. Today, the committee will examine the proposed expenditure for the portfolios of better regulation and fair trading, industry and trade, innovation, science and technology, building and corrections. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome and thank you for making time to give evidence. Minister, I remind you that you do not need to be sworn, as you have already sworn an oath to your office as a Member of Parliament. I do have a couple of witnesses that we do need to swear in, though. Ms. Galuzis, Dr. Aldenhoven, and Mr. Ripbecker. As you have not yet appeared before this committee in budget estimates, you will need to be sworn in. Could I please ask each of you to state your name, position, title, and swear either an oath or an affirmation? If you could come forward, there's a microphone here to my right.
My name is Jen Galuzis and I am the Acting Deputy Commissioner, Strategy and Governance for Corrective Services, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
My name is Dr. Bernhard Ripberger. I'm the Acting Deputy Commissioner of Community, Industry and Capacity, Corrective Services, New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Hi, my name is Dr. Jacqueline Aldenhoven. I'm the Acting Executive Director of Fostering Innovation in Investment New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you so much. For all other witnesses, I remind you that you have already been sworn before this committee during this inquiry and therefore do not need to be sworn in again. Today's hearing will be conducted from 9:15 to 8:30 p.m. Sorry, 5:30 p.m. Sorry about that, Paddy.
I send my apologies for the evening session.
We are joined by the Minister for the morning session from 9:15 a.m. to 1 p.m. with a 15-minute break at 11 a.m. In the afternoon, we will hear from departmental witnesses from 2 p.m. to 5:30 p.m. with a 15-minute break at 3:30 p.m. During these sessions, there will be questions from the opposition and crossbench members only, and then 15 minutes allocated to government questions at 10:45 a.m, 12:45 p.m, and 5:15 p.m. We will begin with questions from the crossbench, and I'll throw straight to Ms. Kate Fairman.
Thank you very much, Chair, and good morning, Minister. Good morning, everyone. Minister, I wanted to turn to begin with to the parliamentary inquiry that was conducted into the Design and Building Practitioners Act and the Residential Apartment Buildings Act, and the government's response to that. And so the government's response to the recommendations, most of which I think most were noted, a couple were supported in terms of the recommendations. Recommendation 7, that the New South Wales Government publish a policy statement outlining the intention of the draft building bills as soon as possible. The government's response is that the government is committed to conducting targeted consultation on building reforms. What is going to be published, if it's not a policy statement, about the draft building bills before they're introduced to Parliament?
Yeah, so at the moment, the government is obviously proceeding with its building productivity reforms, as was announced late last year, and I thank obviously the Port Committee for doing its work, and I know the government has responded. Now, our building productivity reforms are at an advanced stage. We are currently consulting with the sector or with the industry and getting that feedback, and we hope to table that legislation to the Parliament as soon as once that's finalised.
Are you aware of the? Did you read the report of the parliamentary inquiry from the Public Accountability and Works Committee into that review?
Yes, I've been briefed on it by the department.
You saw then that finding 3 was that the consultation process by the government on the draft building bills and potential regulations has lacked transparency and consistency across all stakeholders, leading to confusion in the industry?
Yes, I'm aware of that recommendation.
And do you believe that's the case?
Well, look, what I'd also say, excuse me, Ms. Femin, is the fact that the government has obviously taken a different approach based on the soundings from the industry, and it's been welcomed by the industry. I know the Port was looking at a set of bills that was really no longer the government's obviously latest intentions to move. So,
are you aware of the statutory obligations of the Public Accountability and Works Committee to undertake reviews of those two bills?
Yeah, I think we discussed it at a number of meetings. Yes, I'm aware of that.
It was complicated.
And why did you refuse to provide the committee with a copy of the draft building bill or the draft bills that are intended to replace the 2 acts that the Public Accountability and Works Committee had a statutory review to review?
Well, one, that hadn't been finalised. And
but
that
the industry stakeholders, though, were consulted on that bill. So why on earth wouldn't the Upper House Committee tasked with reviewing those 2 bills that the bills were intended to replace? Why didn't we get a copy? Why didn't Nick get a copy?
Well, I said the draft bill that was done with the set, I was obviously waiting submissions, and obviously the department would carefully consider those submissions, and obviously appropriate changes would be made in any bill. But also, like I said, the fact that the government was not really, in one sense, proceeding with those bills. It was taking a different approach, and this is based on the feedback and the support that we've had from the sector.
So the government's now taking a different approach to the draft building bills. Is that correct? That the industry was initially consulted on?
Well, yes, the government is actually proceeding with its building productivity reforms, as was announced late last year.
And so in terms of consultation, is there going to be any transparent public consultation period then? This report says about the public policy statement, at the very least, a public policy statement, and the government has come back saying, they're committed to conducting targeted consultation, which indicates that probably not a policy statement is going to be released. Why the lack of transparency around this reform?
Well, I don't agree with the fact that there's been a lack of transparency. The government has been engaging with the sector, and I said originally it had obviously an intention to move with the building bills. That wasn't the bill that the Port Committee was looking at, wasn't necessarily the one the government was proceeding with, but I understand and acknowledge that the Port Committee had to do its statutory work, and that's rightly so. But I think in our ongoing discussions with the sector, it was clear to us that the sector wanted to prioritise certain aspects of the building reforms, and that's what we've actually moved forward with.
Could you just expand and outline what that ongoing consultation with the sector, so say the most recent consultation with the sector, has that been in the form of, for example, workshops that many industry stakeholders attend? Is that what you're referring to?
Yes, we've got an industry reference group which obviously contains a number of stakeholders. The government is currently consulting with a set of draft legislation to get feedback, and that also, as I understand it, I'm sure the Building Commissioner can confirm, that also includes one-on-one specific discussions with the stakeholders.
If you could just please provide on notice then. Well, no, firstly, in terms of that industry reference group, how many stakeholders are on that?
I might defer that to the Building Commissioner to make sure you get the exact number.
I don't have the exact number in the reference group, but it's the same reference group that's been used for the initial building bills, and we carry on with them to this day. We're meeting with them last week, this week, and next week. One-on-one meetings and workshops.
How many roughly? Are we talking a dozen, 25, 3?
More like 10.
More like 10. So you can provide the members of that group on
That's right.
notice?
HIA, MBA, architects, UDIA, similar.
How do they make decisions?
We give them a copy of the draft documentation. We give them some time to review that. We have a one-on-one session with them in the first instance. We get their feedback from that. They obviously need to speak with their members and have some discussion. We then have a second session with them in order to get further feedback. And we're in that process at this point in time. We're about halfway through that process now.
Do they all have to sign NDAs?
I'd have to check on that.
I'm pretty sure some of the stakeholders that I've had discussed issues around whether it's strata reform, whether it's building reform, they're very, very nervous about giving me anything in relation to submissions or whatever else. I think it's why it's very difficult to find any of this online, because they're consulting with the government, but they're being told to whether it's signing NDAs. I think that's probably the case. So the question is, because when we end up seeing this legislation, it's very difficult for us to know what the industry feedback is, because all of this has been undertaken under the cover of cloak of darkness.
So there is no NDA required.
Okay, all right. So so what they're being consulted on could be public.
The industry reference group has been set up to represent the stakeholder interests. That is the same industry reference group that we've used for the last 2 to 3 years, as I understand it, before my time, and we continue to consult with them and they represent through the industry.
Thank you. Minister, what timing this year do you think that the the Parliament is going to see the bill?
Look, we're at the advanced stages. I suppose as soon as possible is the general principle, but we hope to have before to table the legislation hopefully by in the first half of this year.
I have to, because a lot of various things have been extended to the end of June 2026, I think, in terms of the existing framework. That's correct, isn't it? So you really need to
absolutely.
hurry.
But I also think it's important to hear from individual associations in the industry reference group, just to make sure we are both on the right path. I mean, I think the initial commentary has been very supportive of where the government is going, based on the sound feedback that we've had. So I think it's a case of really just tying up the latter ends of the legislative process, and we have to bring it to the Parliament once that's finalised.
Thank you. So just in the short time I have remaining, so the portable bonds scheme delayed once again. The renters were promised a scheme. Obviously, it could almost be 2 years before they get a scheme after they were promised one. And when the government announced it, the government said that the harsh reality is that the high cost of moving, especially having to pay a new bond before the old one is refunded, can push people to the brink of homelessness. But it's still 18 months. What on earth is the reason for delaying the scheme so long?
Well, look, I think the portable rental bond scheme is nation leading. I would say almost world leading.
Well, it's not in place yet, so I'm not sure it is.
I think ideally I would have liked to have done it by the end of last year, but I also make this point when it comes to the portable bond scheme, Ms. Fairman. It's got over $2 billion worth of rent payers' money. There are 1 million accounts. And I think once we started what is a significant IT build, you open the cupboards. It's a lot more complex than we probably had originally thought. But I do think that, I want to make sure that once the scheme is implemented, it is tested, retested, and tested again, because giving I think the market and the sector confidence that this will work, I think it's important. I do want to take that time. I can understand the comments around some of the delays. Look, ideally I would have liked to have done as well, but I'm also not going to jeopardise $2 billion worth of rent payers' money and not doing all the tests and the retests that's actually required to ensure that we deliver what is a really important reform for the rental market.
Thank you.
Thank you. Minister, I also want to ask you some questions about the government's response to the Public Accountability and Works Committee review into Design and Building Practitioners Act 2020. Specifically, I wanted to ask you about the government's response to recommendation 2 regarding interior designers, which we've spoken to quite a bit before. So the committee recommended that the government consider establishing a pathway to registration and licensing for interior designers. However, the New South Wales government's response seems to indicate that it's not something you are actively considering. Can you please explain why?
Yeah, look, thank you. Thank you for the question. I know we've discussed, I know this topic is important to you. Now, the government in its building productivity reforms is really focused on this particular reform because it actually complements the significant planning reforms that's been done by Minister Scully. We really want to focus on streamlining the approval process. We want to obviously help improve and obviously induce greater technological advance in modern methods of manufacturing in terms of prefab and modular homes, and also trying to bring greater integrity into the system around certifiers. So that's our focus at the moment. But in terms of interior designers, I think we've had these discussions before. That is, I think where the government wants to make in future reforms in this space is make sure we actually risk target our reforms. Now, mainly looking at those where it could jeopardise the structural integrity or the safety of the buildings. I think we'll do those in those sort of steps.
But Minister, at the previous estimates, neither yourself or the Acting Building Commissioner were able to point to any safety concerns or other evidence suggesting that it would be unsafe for interior designers to actually do this work. But you're talking about it again as though this is a live issue or something that's happened in the past. It's clearly not something that's happened. So, this is a highly specialised profession. They've been doing this work safely and at a high standard until now, until this blockage. We had the previous legislation from the former government that knocked them out of the industry, but now we're seeing, your government as well taking steps to knock interior designers out of this industry. And I'm just trying to understand why, when there's no actual safety risks that can actually be given to me.
Well, look, I think the government's not trying to obviously knock out the interior designers from the industry. What we're taking is a risk approach to the building sector, because I do.
But based on what? Why do we need a risk approach based on this industry when it's that the response is actually knocking them out during a housing crisis? And when there hasn't been any indication that there is a risk within this industry?
Well, one, I think the government is not making, at this stage, any intention to make any changes to the interior design framework. But I think given the recent episodes that we've had, in particular on structural building issues like mascot towers, the government is really focused on...
But that wasn't interior designers.
Well, I totally accept that, but that's why we're actually moving into areas where we're trying to reduce defects, where we're trying to increase consumer confidence. And I totally accept your point, Chair, that interior designers are not part of the building aspects, which is actually really involved in the structural integrity and the safety of the buildings. I acknowledge the role that interior designers play, but as I said, at this stage, we're not intending to make any changes, I suppose, to status quo until we really pass, hopefully, the legislation, which I hope will get support from the Parliament around our building productivity reforms, because that's going to get more quality housing into the market quicker for the people of New South Wales.
At the moment, though, based on changes that the former coalition government made and the proposed legislation that you've got coming forward, we are restricting interior designers on the work that they have previously been doing. Currently, they're restricted from coordinating even the simplest design modifications. You're telling me that we're blaming interior designers for risk factors that have been caused by other industries, so therefore we're not going to allow interior designers to do this. don't understand.
No, look, I have to go. We are not blaming interior designers for all the structure. We've never said that. But what the government wants to focus on is really bringing the confidence back into the market. We've had a significant number of defects. A lot of owners, both in strata and also in the Class 1. I mean, this is the biggest investment they'll make in their lifetime, and I think getting that confidence will drive the demand and supply, and there is no change at this stage that the government is considering in terms of interior design.
But that's the problem. I mean, this industry does want to change. They want a pathway to registration. They want to show that that there is no risk to their industry. That they want to make sure that they can do the work that they have been doing previously and that they're highly qualified to do. The Victoria's Building Authority already registers interior designers as building practitioners, and I know you yourself have previously highlighted the need for consistency and regulation. Now you're telling me that the government has no plans to change anything for interior designers, which leaves them knocked out of this industry when we need them most during a housing crisis. Why is New South Wales not taking the same approach as Victoria and making sure there's a pathway for registration for interior designers so we can utilise the skills that they have?
Yeah, look, I said, look, I've had a number of discussions with the Association of the Representatives of Interior Designers. Our really focus is on structural and safety integrity of the buildings. I mean, I'll obviously let the Victorians speak for themselves, and the New South Wales market is the biggest market in the country, and focusing on, I said, streamlining approvals is the priority for the government at this stage, and issues around licensing and registration, not only of interior designers, of others, well, obviously the government can turn to that after we've actually passed this building productivity reforms legislation to support what I think are the most critical factors in ensuring that we continue to induce supply. So it's not that I'm saying that this is not something the government's considering, but we've had a number of discussions, and I know the Building Commissioner and the Building Commission has been obviously had discussions with the representatives, but we just want to focus on what are the top priorities in the housing challenge at the moment.
Minister, the interior design profession is approximately 76% female. It's actually the most female-dominated profession in the Australian build environment. But interior designers are not being listened to. They're being shut out of a registration pathway in favour of these male-dominated professions. Do you not see the issue here? Well,
look, the government doesn't have a gender focus when it comes to the building industry. We're focusing on the structural integrity of the sector, and I said you can't build any houses to anybody if you can't get it approved quicker. So that's why the focus in the building productivity reforms has to be in streamlining. Sorry,
Minister, are you suggesting that male-dominated fields are safer than female-dominated fields in the building space, and that's why you're prioritising the male-dominated fields?
I'm not making that suggestion at all, Chair.
So then, there's claims that this is a form of sexism. Women are being pushed out of the building industry. How do you respond to those claims?
Well, look, I have to say I don't agree with that assessment. We look at the sector and trying to get as many quality houses onto the market as quickly as possible.
But wouldn't the best way to do that would be to make sure that there's a pathway for registration for these interior designers so that we can use their skills in the building and construction industry?
But look, I think interior designers still play an important role in the sector.
But they've been mostly cut out of the work that they've been previously doing. And you haven't been able to give me any safety examples or any risk examples as to why they've been cut out of it.
Well, like I said, I suppose my answer is to go back to it. The most important focus that the government really wants to prioritise, which is based on the feedback that we have, is about getting quality structural buildings or dwellings onto the market. Once those reforms are passed by the Parliament, I hope the Parliament will support those initiatives. We can turn our attention to registration and licensing, not only for interior design, but for other professions as well. I just think...
So that's still on the table? That's something that the government will consider?
The government is always, Chair, always having these discussions with the sector, but the priority is supporting the significant planning reforms that have been passed, and that structural integrity, seamless approvals, bringing back integrity into the sector has to be a core part of how we get more quality dwellings onto the market quicker for the people of New South Wales.
I would have thought that the fastest way would be to make sure that everybody that's skilled in this space has a pathway to actually do the work that they've got experience in doing. Has your department conducted any assessment of the Victoria model and the consumer protection outcomes that have been achieved there by ensuring this pathway exists so that interior designers are able to do a lot of this work too, to make the rollout of this safe housing much faster in New South Wales?
Can I defer that to the Building Commissioner?
So interior designers play a critical role. There is an enormous amount of design work that they can continue to do, but there is a clear demarcation between what an interior designer can do and what an architect can do. Now, there's no clear scope for what a person needs to have achieved before they can call themselves an interior designer.
That's
and
why we need
therein
the
lies the
registration
problem.
pathway.
Rather than having anybody who chooses to call themselves an interior designer go about designing complex components of housing around fire and other areas like that, we limit that to people who we know are completely trained, such as architects. Now, there is a pathway for interior designers. They just need to do further study. I know that they could proceed through an architecture pathway if they wanted to beyond that, and then they're able to do any and all the work available. But at this point in time, there's a cap because there's no clarity on the exact specification required to call yourself an interior designer.
Yeah, there's a lot to unpack in that and a lot of problems with that statement, but I'll get further into it later. It's time for some questions from the opposition.
Thank you, Chair.
Sorry.
Good morning, Minister.
Good morning.
Minister, what is the average rent for a home in Sydney?
I think it's about $800, the last data that I've got.
And an apartment?
Look, I think I want to get you the exact figure because I've actually got this. I recall it's probably about $740. Would that be about right?
It would be. It's about $750. And
Yeah.
did you know that that's up 7.1% in 2025?
Yeah, look, we all know the housing challenges that is facing not only in New South Wales and across the country.
We do all know them, but you're in government and rents are continuing to soar under your government. So have you failed the renters of New South Wales given these extraordinary figures?
No, absolutely not. The government has made significant rental reforms in terms of no grounds evictions. The planning reforms that's made by Minister Scully has been to try to get more dwellings onto the market. I mean,
The problem is that it's not working, obviously.
Well, but if you're suggesting...
I mean, if this is success, we're on a bad track.
Well, I said rental price, obviously, a sense of market conditions, and you can't rent anything that's not available or built, and that's why the government's reforms in getting more high-quality housing onto the market is where you go. But
the government isn't doing that. The failure to achieve the housing targets is a matter of unfortunate national importance.
Yeah, look, I think it is a challenge, but that's why the reforms that the government has done are aimed at improving the planning process. Also,
sorry, just on the reforms, I mean, one of the things that's already been raised is the portable bonds scheme. Mm-hmm. Is there a delivery date for this? Because we were told it would be in 2025.
Well, look, I said at the moment we're at an advanced stage of the build. I've actually seen it in place. Obviously, at the moment we are moving towards the testing, the user acceptance testing. So we're at the testing stage.
But why wasn't it achieved in 2025?
Well, look, I think...
That was 18 months after the original date was set, so it's taken more than 18 months.
Yeah, look, I accept that. I acknowledge that. It is, I said, an extremely complex IT, but once we open up the cupboards, I have to also reinforce the point. This is not putting two Lego bricks together. This is actually quite a complex system to build.
Sure.
Yes.
But is it a priority if it's not being delivered to the timeline that you had been
given?
Well,
like I say, it is a priority, but it's also the fact that, as I mentioned, there are over $2 billion worth of renters' money. There are 1 million accounts and growing. We want to make sure that I'm happy to always say...
But under the government, we've got increased rents, like record increases. 7.1% for apartments is quite huge. $750 a week in a cost of living crisis is very, very problematic. Your government promised that there would be a portable bond scheme to assist renters, and it hasn't been delivered. So how are renters better off after 3 years of your government?
Well, absolutely, renters are much better off because now no grounds evictions means they can't actually be moved out of their home.
Just on that, no grounds eviction means that a landlord can provide their own evidence without any other particular document clarifying their need to evict someone, and you just have to take the landlord's word that they needed to evict someone, and that's considered no grounds.
Well, no, that's not correct. I think, there are reasons where someone can be, obviously, the lease can be told. What that is, you're selling the property, your family are moving in, obviously you're doing major renovation. There are also significant...
Yeah, but who determines what major renovations is? The landlord does by providing a letter that the landlord wrote.
Yeah, but it's also, I said, written evidence. I mean, we've had this debate in the Parliament.
It's written
about
evidence.
It. Well, it's an evidence. I mean, what you're virtually saying, what you're also accusing Miss Munro is that every landlord is a cheat and a charlatan, and that's not true.
No, I'm not saying that,
Well, you
Minister.
are.
What I'm saying is that renters can have no confidence under your government that they're better off given the huge increases in rentals. There's no portable bond scheme, and a no grounds eviction can include evidence which is the landlord's own evidence without additional requirements. How is that good for renters?
Well, look, I said the government has done more for renters in its first 3 years than what the opposition did in 12 years.
I've literally just explained how those things haven't actually benefited renters.
Well, they have.
How have they?
Well, it's given greater clarity and certainty to the market with the reforms. I mean, we've now limiting, of course, for example, you need to have a fee-free way to pay your rent. Rent can only be increased once per year, and if there's a dispute with that, obviously you can take that to the tribunal. We've banned background
We're at
fees for background checks.
$750 a week on average. I mean, that's just the average. Obviously, there's more people who have to pay a lot more per week for an
that's
apartment.
That's right.
here.
Nobody's disputing the housing
So when you've got a couple of
challenge.
dollars of a transaction fee, it's not really material.
Well, I think every dollar counts, and given people are struggling as well.
Okay.
But what you're also suggesting...
Have a coffee on the minister.
What you're also suggesting, Ms Munro, is that the Liberal Party's position is to cap rent in the market. Is that the position of the government?
Minister, you're in government. If we were in government, we would be doing a very good job on this. But unfortunately, you're in government, which means I get to ask questions of you and the promises that you made at the election that haven't been delivered. And you're trying to claim that renters are better off when the policies that you wanted to enact, we also had a policy of a portable bond scheme, but it's not been delivered under your government. So it's a broken promise to renters.
Let's go through your record. Let's go to the opposition's record.
Here we go.
There's been a point of order taken. Yes.
Chair, it's not courteous to the witness under paragraph 19 of the Procedural Fairness Resolution to talk over the top of him before he's been given the opportunity to answer a lengthy question.
To the point of order, I did not ask the Minister about the Coalition's policies. In fact, I was asking the Minister about the government's record.
Look, I mean, I'm not going to uphold the point of order, but I will say this, is that we were sort of getting to a point where there was a lot of talking over the top of each other, and I just want to remind both the Minister and the member that makes it very complicated for Hansard as well, so please just keep that in mind.
Thank you. Well, look, I'll move on to rental bond board vacancies, because I think this is also material. Obviously, it oversees the rental bond system, and it includes lodgements and custodies and refund. So the board currently has 2 positions that have remained vacant for almost 18 months. Why have these board positions been left vacant?
Like I said, I recall, I mean, the Fair Trading Commissioner will confirm this, we've actually done a recruitment process to make sure we get the right candidate for the bond board positions.
Can I just ask you, Minister, does that take 18 months?
Well, I said the recruitment process is done by the department, and of course we'll make sure we get the right...
Do you think an 18-month recruitment process for what is apparently a priority area of your government is acceptable?
Well, I think you could always be shorter, but it's certainly...
But have you spoken to the Rental Commissioner about that process being shorter?
Well, I said, look, the board is still operating as it is required. It's not like the board is not operating, Ms Munro. I think we've got to make that point.
Okay, but are you familiar with the 2 positions that have been vacant?
Look, I've been briefed about it, yes.
So what are those?
As I said, we've been briefed about it. I can't recall the technical details of it.
Okay, well, let me inform you that the two vacant positions are the stakeholder representative positions to give key stakeholders a voice. So those positions have been vacant for almost 18 months. Do you think that that means that this governance body is working in the interests of the people of New South Wales?
Well, look, I see we get soundings from community representatives in a range of forums. I mean, the Rental Commissioner is out and about on a consistent basis. So,
right,
yes,
but this is a very specific governance mechanism designed to give stakeholders a voice. It's positions that have previously been occupied by the Property Owners Association of New South Wales and the Tenants Union of New South Wales, and they've been vacant for almost 18 months. So is that acceptable to you?
Well, I've said community members and stakeholders can still actually advocate to the government in a range of forums.
Is that what you've said to the Tenants Union? That they can still advocate in a range of other forums, they don't need to be in this formal body that is about rental bonds?
Well, the Renters Union can actually still advocate, and they have been. They correspond. I correspond and engage with the tenants units on an ongoing basis. Look, the Fair Trade and my commission might confirm this, but as I understand it, there may be a conflict of interest for the tenants unit to be on the rental bond board, given they are recipients of grants from the time. Is that correct, Fair Trade and Commissioner?
Correct, Minister.
Okay, so the Tenants Union of New South Wales can't be on the rental bond board because there's a conflict of interest.
That's how I understand. Is that correct, Fair Trade and Commissioner?
That's right. So, Ms Munro, I chair the rental bond board. There's two things to say is that those two positions have now been filled and we're onboarding. So, Mr Jeremy Gill and Michelle Adair are the two successful candidates.
Good to hear.
In relation to the point that the Minister rightly makes, the duty of the board is to give advice in relation to grant applications and advise the Minister, because the Tenants Union is often an applicant for those applications. There's a conflict of duty there, which is why we moved to change those positions out.
Right. So in about 18 months, Minister, have there been any independent members of that board?
Look, the composition of the board, I might get some advice from the Fair Trading Commissioner.
So those particular positions have been vacant, but we have had the other positions in.
So they're not independent stakeholder representative.
No, those positions have been vacant.
Yeah.
Yep.
So they're the only independent stakeholder representative positions on the board.
That's correct.
Okay, so the Minister has been getting advice from this body without any independent stakeholders from the community.
So I might just take that on notice, because my recollection is we may have met only once in that time and there were no decisions made. It was more of an update on finances, grants and so forth. So I'll take that on notice and come back
Minister,
to you.
does that concern you that there's only been one meeting and in that meeting there were no independent stakeholders anyway?
The Rental Bond Board is one source of advice that the government gets. The government, through the Rental Commissioner, is engaging on an ongoing basis.
So what is the point of the board then? Is there a point then to have the independent members?
Well, yes is the short answer to
Why
that.
Is
but
that?
I think, because the Rental Bond Board provides one specific set of advice to the government in the financing of the rental bonds.
And why are the independent members useful?
Well, like I said, we want to get a representative of all the sector, but I think
you want two in this case,
what you're
but we
suggesting,
didn't have those.
What you're suggesting is that the Rental Bond Board is the sole source of advice for
I'm not
the government.
suggesting that. I'm suggesting that it is an important place for advice and that there have been two key stakeholders absent.
Look, it has a very narrow role in what it does. The work of fair trading through the Rental Commissioner, through the reforms that we've done, with stakeholders, with advocates, with the community,
just to
has
be clear,
been really
is it
good.
important to have these independent stakeholder representatives on the board?
Well, yes, it's under the statute.
So why wasn't it concerning to you that those roles hadn't been filled for almost 18 months?
Well, I said we were going through the recruitment process, and I'll go back to it. The board has a very narrow role.
Were you aware of the vacancies? Were you aware of the vacancies 18 months ago?
The board has a narrow role in the provision of advice to me. There are other sources of advice that the government
Minister,
takes. So
but I'm talking about the rental bond board. Sorry, can I just understand, were you aware of those vacancies 18 months ago?
Look, I said the department has briefed me up on this issue ongoing. I can't recall the exact date.
Did you request that the department actually speed up this process of recruitment?
Well, the recruitment process is done by the department. I was aware of this. I can't recall the exact date when I was briefed. But I said, you go back to it. You're focusing on 2 members of a very narrow board role, and somehow this is the sole source of advice for the government when it comes to reform. Well, it's actually not.
I think the Property Owners Association and the Tenants Union would be very, very concerned to hear that response. I'm sorry, I'm mindful of the time. I am actually going to throw to my colleague who is online, the Honourable Nicole Overall.
Okay.
Thank you. Good morning, Minister.
Good morning, Ms. Overall.
Program and legislated asbestos register introduced in 2015 by our former Nationals Liberals government, Supreme Public Health and Safety and Environmental Risk as a 20-year program with almost $280 million budget and receiving bipartisan support. It's all about to be quietly axed. So is this to occur on February 28th, 2 days' time?
Look, I said, I'm not sure, Ms. Overall, where you got the 20-year program, because that's not the advice that I have. I just want to correct that for the record. Yes, it was implemented by the former government at a time when this issue was live. So I think I want to correct you on that. Now, you'd be well aware that since its inception in 2015, a number, I think about 71...
Minister, I don't have a lot of time. It's difficult to do this online. So the question is this program and the register being axed on February 28, 2 days' time?
Ms. Overall, the bill is currently before the Parliament.
It is before the Parliament.
So once
Can you confirm, is that the date, or is that...
No, the Parliament's got to pass the bill before we can actually act on this. I can't act without the approval of the Parliament. I mean, the bill needs to be debated. I understand it's going to the
February
upper house.
28th is not correct then, that this is when the program is to be axed and the register withdrawn?
Now, look, I can't withdraw the things until I get past the Parliament, so I'm not sure where you're getting the 28th.
That's the case, thank you. Have you been advised that the program does need to be cut and the register withdrawn because and it needs to happen quickly because there's a risk that impacted owners will register before the program closes, posing a financial and administrative burden on the government?
Look, I'm not aware of that, no.
So you haven't been briefed?
No, look, I said
advice in that
not that
regard.
I'm aware, no, I can't recall, but I think you've got to look at the history of the program. I say it's been in inception since 2015. 71,000 homes have been inspected, and a number of these have been remediated. As the Vetting Training Commissioner can confirm, so I think in the last two or 3 years, we've barely had, I think, 1 or 2 houses registered. So I think, in all fairness, the program has run its course, its natural conclusion.
And there's lots of questions around that as well, particularly on the basis that if impacted owners, and there's a concern about them registering, the information that suggests that there are more properties that will need to be dealt with. But how much remains of that original almost $280 million budget, as it's only halfway through what the original provisions were for?
Yeah, so firstly, I'm not sure where you got the $280 million budget from. So
It put by the Minister for the Environment in our upper house, 276 point something million, I think.
Okay, look, I'll take your word for it. Look, I think what I'd also say is, as I said in my second reading, Miss Overall, that any future cases for remediation support will be considered, and resources will be made available on those who are eligible for the program.
Through what program and what plan?
Well, but it'll be...
What are the arrangements? What are the actual arrangements around that?
Yep. So the arrangements would be that if there is an eligible property in the future, they would make an application to the department, and that will be considered on a case-by-case basis.
So funds will be set aside?
Well,
in order for that to happen?
Well, as I said in my second reading, case-by-case basis, those properties that are eligible will be considered for support.
But if there's no register that's going to be publicly available, there's no program because it's been cut, there are no experienced staff members because they've been moved aside or axed as well, how is this going to be administered and overseen?
Like I said, all considerations, all eligible properties will be considered on a case-by-case in going forward, and resources will be set aside for those who are approved for the
Well, let's go back to the resources then. If you can't confirm the $276 odd million, perhaps the your commissioner from Fair Trading can, and how much of that is actually remaining? Is it almost $100 million? Can that be confirmed?
Well, I think, Ms. Overall, the budget itself is actually not relevant because as the facts state, the program, since its inception, since 2015, has run to its natural conclusion.
No, it has not run to its natural conclusion, Minister, and I beg to differ on that, and also with the information that's been presented when you want to talk about the history of the program. And if you want to talk about the history and its natural conclusion, when PricewaterhouseCoopers did their original findings and report, there were between 272 and more than 500 properties that were potentially identified. As you have stated, 159 properties have been put forward on the register. The concern now is what is going to happen into the future with this. Now, if you cannot say how much remains of that almost $280 million, what's going to happen with that? Will it be redirected into these programs or this case-by-case basis of assisting future impacted homeowners, or is it just going to go back into consolidated revenue for the government to use as they will?
Like I said, I'll make the point that the demand for this program is not very high. We've got to have a proportionate response to the situation that is occurring and has occurred. And I said there will be resources made available for future cases where property owners are seeking support regarding loose fill asbestos. I don't think you can
put forward, Minister, the manner in which and how and under what guise that is all going to occur. But again, because I'm not aware of the time, I'm not sure of the time here, I'll ask you a final.
Sorry, the Honourable Nicole Overall, that the bell has actually rung, but we will come back to you. Thank you. The Honourable Mark Latham.
Thank you, Chair, and good morning, Minister and your officials. It's always good to see a Minister from South West Sydney.
Absolutely.
We've lived for a long while. God's country, absolutely. Minister, are you aware of the emergence of a new cohort of law firms, basically the equivalent of ambulance chasers, encouraging body corporates to make exaggerated defects and compensation claims on new apartment buildings? And what are you doing to overcome this threat in legal costs for the New South Wales building industry?
Look, Mr. Latham, I'm not sure about the emergence of a high number of law firms, but I think...
Well, they're out there.
Yeah, well, I'm sure they're making money. I suppose that's been a practice, I suspect, in every sector where law firms chase, obviously, financial goals. But I think what you're referring to is the case of, obviously, a particular significant builder and their singular situation about, obviously, lawyers, providing advice to owners' corporations to take legal action regarding building defect. Is that correct?
Well, it's more than one builder. Yeah. It's emerging across the industry, and as an emerging problem, what are you doing about it? Yeah,
look, I said one where obviously I've had correspondence and engaging with obviously one in particular, the Meriton Development Company, which is obviously a very big, one of the biggest, if not the biggest, Class 2 builders in the country. Now, we've had a number of correspondence with that particular builder. I know the Building Commissioner has been supporting and also providing advice where appropriate to that situation. And I understand, the Building Commissioner confirms that we are having discussions with the sector about how we obviously improve this process.
And are you aware of the scale of the problem? The builder you're talking about is facing a $120 million claim for defects on an apartment block on the North Shore. They can carry that because of their size. But the potential liability for small to medium-sized builders is obviously a major problem. As the warranties are now starting to come off, are you worried that a number of those smaller to medium-sized builders would be going broke, which is a big setback for the viability of housing supply in New South Wales?
Yeah, look, obviously, in terms of cash flow and financial tightness of the sector, we all are aware and sensitive to the issues, and that's why I think some of the reforms that the government's doing is about reducing costs for the sector in terms of the way, for example, gets its plans approved, and minor variations don't have to go back or restart a DA. So these things will help the cash flow of builders, in particular smaller builders in the sector.
Why didn't the government adopt the PAWC recommendation number 4 for a Queensland Labor-style model of a low-cost tribunal to resolve these defect disputes, cutting out the legal costs of going to court?
Yeah, look, we're aware of the Queensland model, but I am also mindful that we should work towards a model that works in New South Wales. Now, that's not to say that I'm disregarding the Queensland model. As I mentioned, the Building Commissioner is and has been meeting with the sector regarding these measures, but I'd also say that whatever model you implement, it doesn't prevent an owners corporation taking legal action if they have a disagreement.
Yeah, sure, but it's faster and cheaper through a tribunal, Mr Sherrod. Would you agree with that?
We've spoken with owners corporations. We've offered to do mediation, dispute resolution with them in a number of cases, particularly the matter that you're talking about. They've chosen to continue with the legal action. That is at their discretion. The issue of dispute resolution has been raised a number of times by a number of organisations, both big and small. And to that end, we're moving towards a industry roundtable, which has already been booked, which is setting up to understand what role dispute resolution may play. We've spoken with our counterparts, both in Victoria and Queensland, about their models as recently as last week. And we're developing our own sort of high-level constraints paper, if you like, around that. We'll meet with the industry about it and have a discussion. And once we come up with some observations or opportunities, we'll present those to the government.
Okay. Well, Minister, given that obviously a company facing $120 million liability in New South Wales through the courts would think it's a lot better to go to Queensland and invest there because they've got a faster, cheaper tribunal process. Aren't we losing housing investment as a product of the competitive advantage that Queensland has got?
Well, look, I think the city market would always, I would say, be the most attractive market across the country.
It's not. Do you talk to builders?
Yeah, all the time. I mean,
Okay,
I see.
Don't they tell you Queensland's much more attractive on several fronts?
No, not necessarily. I don't think so, Mr. Latham. Look, I think the market also is a multi-factor variable equation about where people want to build, what the demand's got to be there. I mean, population, all those things matter, and of course the cost of financing is part of that. But yes, I am aware of this particular issue, in particular with this particular builder. But what I also say is that in this, that's certainly is a statistical outlier in terms of what the owners corporation is claiming in terms of the value, but also there may be instances as well, Mr. Latham, that the owners who are obviously invested all their hard-earned money into the buildings may have a right to actually ensure that defects that are present need to be rectified for those who are actually responsible. So consumers have to be part of this discussion and this debate as well. We can't, I don't believe, that we should move a set of legislation to one particular circumstance, one in particular, and what I call is an outlier, which we both would agree on.
But it's your evidence that you're not worried about New South Wales losing housing investment to Queensland?
No, I'm always worried about the New South Wales housing market, and that's why the government, across all its
not the market,
portfolios,
the investment side of the market.
Yeah, well, absolutely, and that's why our streamlining process with approvals, getting confidence back into the market with the reforms that we've done with the Building Commission, New South Wales, with its work on identifying defects, with our work on the building productivity reforms. I think in one of the elements of the building productivity reforms, Mr. Latham, in terms of the approval, we're now only going to consolidate the approval process. Now you only need one set of plans for the same building rather than two. And for some of these buildings, as I recall, we're saving up to $327,000. I think that's not an insignificant sum.
I hope you have a watching brief on the defects issue because it's emerging.
Absolutely.
But if I can take you to a separate matter, a change of pace, Minister, on corrections.
Yes.
Can I ask, please, about Naveen Akram, the younger of the terrorist murderers at Bondi, Given his injuries at Bondi, Akram was transferred to Long Bay Hospital for treatment. From Long Bay, subsequently went to Goulburn, I understand. But at Long Bay, Akram was visited by the Muslim chaplain, the cleric Ahmed Kalani. Is it true that Naveed Akram requested the visit by Ahmed Kalani and received from him a copy of the Quran?
Look, I'm loath to talk about specific cases, but in terms of the individual you mentioned, I understand that's been reported in the media, and that, yes, I understand the Commissioner may confirm that that individual has received a copy of the Quran. Is that correct, Commissioner?
Okay. Was this appropriate given Naveed Akram had used the contents of the Quran to justify his support for ISIS and his murderous shooting at Bondi on the 14th of December?
We do run, Corrections does run a chaplaincy program. I'm loath to talk about specific cases.
Why not?
The chaplaincy program goes through a multi-vetting process. Those who are part of the chaplaincy program are obviously assessed appropriately, and that any contact between that, and I might defer to the Commissioner to outline the finer details of how the operations of that chaplaincy program may actually work.
No, I'm not interested in how it operates. I'm interested in the specific matter, which is so high profile. The Minister has to talk about it, quite frankly. Did correction staff overhear the Akram Kalani conversation at Long Bay, such that Kalani said Akram's actions were consistent with the Quran and the call to jihad?
Well, look, I'm not aware of that. I might.
You haven't been briefed on it, but Commissioner?
Commissioner, do you know, in terms of the conversation between the individual and the chaplain, can you confirm? I think Mr. Latham is asking.
I'll repeat the question for the Commissioner. Did correction staff overhear the Akram Kalani conversation at Long Bay, such that Kalani said Akram's actions at Bondi were consistent with the Quran and the call to jihad?
Yes, that's correct, Mr. Latham, and the matter was investigated, and I'll call forward Deputy Galusis in relation to that investigation.
Please. Mm-hmm. So you're confirming the conversation was overheard by staff. What was the nature of the investigation, please?
If I can just clarify, the conversation was reported by another inmate to staff rather than being overheard by staff directly, and that report was made to our professional standards and investigation unit within Corrective Services, where it was then investigated by an independent investigator in terms of whether we could corroborate if that conversation did occur. The independent investigator interviewed the relevant parties. That conversation was recorded by body-worn camera. That was also reviewed, and the conclusion of that investigation is that that allegation could not be substantiated.
How did the other inmate overhear the conversation? Were they in the hospital bay?
They didn't overhear the conversation. What they alleged was that they had a subsequent conversation with the chaplain, and he relayed his conversation with the first inmate.
Okay, so we'll come back to that. Thank you, Chair.
Thank you. The Honourable Tony Mihaly.
Thank you. Thank you, Minister. Good morning. I'm just going to ask you a couple of questions in relation to New South Wales trade and investment strategy.
The New South Wales trade investment strategy,
Yes, okay. Please. So the 2035, you state, so it's the New South Wales trade and investment strategy 2035. You state that of the 142.5 billion in goods exports, just over 33 billion was derived from coal exports, with I think 20 billion destined for Japan alone. And that coal has accounted for an average of 38% of the value of New South Wales good exports over the past decade. So you agree with those figures? They're in your strategy, right? Minister, your diary disclosures show that you've had proactive meetings with representatives of governments from New South Wales trading partners, including China, Japan and Korea. In those meetings, and I note you met with the Japanese Economic Ministry there of Natural Resources and Energy. In those meetings, did you advocate for the continuation of New South Wales high-quality coal exports, or did you signal support for phasing them out?
Well, no, I didn't signal any support for phasing out. I'm loath to obviously disclose private conversations that I have with anybody, but what I think in a
But they're not private conversations. You're representing the New South Wales government as the Minister for Trade, and you're meeting with officials from other countries. I mean, you must have recorded minutes of these meetings.
Well, look, I said, Ms. Mahalik, I think I'm loath to disclose private conversations I have with anybody, but what I can say is that the New South Wales government obviously is aware there is a transition transition to energy, and that the New South Wales economy will continue.
But do you let them know that at this meeting?
About
Given their
what?
big, well, did you let the Japanese Ministry for with Natural Resources and Energy, you met with a whole plethora of staff from that particular ministry.
Yeah.
Did you let them know that you're phasing coal out?
No, well, we're not phasing coal out. Coal will continue to be part of the energy source of our trading partners, and New South Wales and Australia is a reliable, trusted trading partner, and will continue to support our trading partners in their energy needs.
Minister, have you read the Net Zero Commission's coal mining emissions spotlight report?
No, I don't recall that. I hadn't been fully briefed on that, and that
Right.
would be obviously a matter for Minister Sharp, given I understand it would be in her portfolio.
Well, but remember, the Net Zero Commission writes to every single department and agency and tells you to reduce your emissions. So that's the power that was given to the Net Zero Commission. Are you aware of finding 4 then? Finding 4, there's only 5 findings, so please, familiarise yourself with them. There's only 5. Number 4 is continued extensions or expansions to coal mining New South Wales are not consistent with emissions reductions targets in the Climate Change Act or the Paris Agreement temperature goal it gives effect to. So that's finding 4. Have you or your department assessed the impact of what that means for your trading partners?
Sure. Look,
Should the government accept those findings?
No, like I said, the government will consider any reports or inquiry findings that's presented to them. We'll consider it carefully. I'll reiterate the point that New South Wales and Australia is a trusted, reliable trading partner, and will continue to support
But
all
you've
our
got
trading
these 5
partners with
findings
their
that the
energy
government's
needs.
going to come back. So right now this is going to go to Cabinet, and there'll be a decision made on whether you accept the Net Zero Commission's findings.
I said one. I'm not going to talk about cabinet deliberations.
No.
I might defer to the deputy secretary in terms of that particular recommendation you're talking
That's fine.
about.
We can discuss that in the afternoon. Can I, Minister, ask you? Are you aware that in May 2024, Minister Sharp wrote to Minister Scully prioritising the net zero transition in the Statement of Expectations to the Independent Planning Commission? I raised that with her the other day. You aware of that?
Yeah, look, I understand that's the case. Yes, I'm aware of it.
Did you? I didn't see a letter prioritising trade, industry, and investment from you.
In what sense? To the
Well, if the Minister for Environment, Climate Change wrote to the Planning Minister to ask the IPC that determines coal exploration licences in New South Wales to prioritise net zero, don't you think it would have been appropriate for you to have written to prioritise trade, investment and strategy?
Look, can I just defer? I mean, I can't remember every correspondence that I've done. Can I just ask the Deputy Secretary to provide some advice?
Sure.
Thank you very much, Minister. I think that two things to note in relation to the planning authority's consideration of economic development and growth. Mm-hmm. That is a core requirement of any planning authority in making their consent decision under the planning legislation. And second of all, the Minister Scully's Statement of Expectations to the Independent Planning Commission, which is, I think, the commission you're referring to, actually notes that the IPC is to take into consideration all government strategy and policies.
Of course,
so our view was that
statement. Thank you. Yeah.
Having
I appreciate that. I just want to know why you have one minister writing specifically to ensure that net zero is included, whereas another minister who has responsibility for trade, industry, investment for New South Wales didn't do that, and that's the question. So that's fine. If you don't have a response to that, Minister, the expectations finish in June this year. Do you think you might write a letter then to the Minister of Planning?
No, look, I think the government's trade investment strategy is clear. It has significant objectives, and I'll reiterate the point in obviously discussions and in a broad sense, the New South Wales economy and the New South Wales government will continue to support its trading partners with its energy needs in all forms of energy sources.
Okay. Well, Minister, I'll just move on very quickly. I've just got a couple of issues and I don't have much time. Automatic mutual recognition obviously now has been in effect since 1st of July 2025. Have you met with any stakeholders and including RTOs for any feedback on how that's travelling for real estate agents in New South Wales?
You mean you're talking about the AMR?
Yeah.
Well, we passed that legislation recently.
Yes.
And look, I can't recall every meeting that I've had. I'm pretty certain if I haven't met with them, I know the department obviously been liaising and consulting with various representatives of the whole sector.
Okay. What do you, are you getting, the feedback that I'm getting from some of the stakeholders is that there's real concern about cowboy real estate agents coming from other states that are less qualified, have less work experience, because as you know, we have better education and work experience standards than other states, and that there are indeed problems arising within the real estate industry. Have you had any of that feedback? Are you across that?
Yeah, look,
Is the department collecting any data on that?
Look, one, I would say, as I understand the AMR, the Fair Trading Commission may confirm this, you can only practice what your licence holds in your corresponding state. That is, if, for example, if you're in Queensland, you can only do X, Y and Z. In New South Wales, you can only practice X, Y and Z. You can't practice
we don't
what
have
you're
that.
not
It doesn't
qualified.
include Queensland. Remember, Queensland is not part of this. So,
But I'm just saying that as a hypothetical, that is, you can only, as I understand the AMR legislation that was passed, you can only actually practice what you're licensed to do in your home state. You can't add on things that you're not qualified to do. I also understand that those practitioners also must pay into a compensation scheme in the event there are claims for misconduct. So it's actually just about increasing the supply of practitioners who are doing what they could do in their home state, not actually practicing things they're not qualified to do in New South Wales. Is that Fair Trading Commission? Is that correct?
Yes, that's absolutely right.
And you're keeping some sort of data in relation to this, Minister?
We are. So I can tell you that since the 1st of July 2025, we've received 167 applications from real estate agents under the AMR scheme, and of those, 87 have been eligible. So we've...
Where are they mostly from? Which state?
I don't have that detail.
Maybe if you can take that on notice. If you could break down the states where they're coming from, that would be great.
I can certainly do that. And the other point that I make is that any individual that's subject to disciplinary or legal proceedings in the other state is not eligible in New South Wales. And then the final point I make is just...
Thank you. I'll save that. Sorry. I'm sorry, I've got limited time with the Minister. Minister, can I just also take you, and I think you've had a bit of some questions on this already, but I do want to ask you about... termination, so no fault eviction scheme. I've asked you previously about how you're collecting data, and NCAT we know only collects data in relation to termination, non-payment of rent, and then there's termination other. I've written to the AG, he says there's no capacity to change the way they collect that information from NCAT. Is there anything that you as the Minister can do to ensure that you're collecting proper data in relation to whether the no-fault eviction scheme is effective in New South Wales? Yeah, look,
one, I mean, the no-fault evictions or the government's reforms obviously is being implemented, and I've requested the Rental Commissioner to continually to monitor the
But how are they going to do that? If the Attorney General is saying that they can't change the way NCAT produces their data, how will you ensure that, what can you do to change that?
Well, I'd say that the Rental Commissioner is working with the sector to continue to monitor the workings of the reforms, and that would of course involve analysing the data. And there is, as I understand, there's also a compulsory data collection on the reasons for evictions.
Well,
Thank you. Sorry,
that's right.
we're off to the other side.
Thank you. Thank you. Good morning, Minister.
Good morning, Ms. Smith.
I would like to turn to underquoting, and I might quote from the SMH before we start, and it's so Sydney claims the dubious status as the underquoting capital of Australia, ground zero for questionable real estate tactics. Do you agree with that,
Well,
Minister?
but that's why the government is actually moving significant reform in underquoting. Mr McDonald, the government's put a lot of work in this space. It's reform, which I think, in all fairness,
Well,
I
that
would have
brings
liked to
me-
not have done if that had been done by the former government.
That brings me to my next question then. So you say you're moving forward on reform. Has a bill or exposure draft been prepared?
Yeah, look, the legislation is at the latter stages of consultation. As you'd be well aware, there are essentially three core elements around underquoting to obviously take away the incentives for agents to underquote. One is to significantly increase the penalties of up to $110,000 or 3 times the commission, whichever is greater. Property prices must disclose a price or a price guide. And the third element and the third pillar is that these prices that are advertised must be substantiated by evidence. That is, you can't just say it's worth X million without saying, well, how did you get it? So all those, I think, will actually give the sector greater transparency, and we hope to obviously improve the level of conduct in this space.
Well, I'm glad to hear that, Minister. Have you engaged or consulted or with stakeholders, or have given them has there been consultation?
Yes, absolutely. Well, we've been doing it for the last few months. We're at the latter stages of that consultation process.
In that consultation process, can you say what organisations that you've consulted with?
Look, I understand there's an industry reference group. I might ask the Fair Trading Commissioner. We do have a stock.
I can come back in the afternoon to that one. So, so now that you're in the final stages of your consultation, and when will the bill be introduced?
Look, we hope to table the legislation in the first half of this year. We're just going through the latter stages, and we're also getting the feedback from stakeholders is important. But the pillars, as I've outlined, are the core elements of what will be in underquoting.
And do you have like you said, the first half? Do you have when in the first half are you talking about?
Oh, well, look, I said as a general principle...
It's imminent, is it?
No, it is, I suppose, imminent. As a general principle, once we do reform, I want to do this as quickly as I can, but I'm also mindful there is a consultation process that should always take place to ensure that we get the feedback and also the support for the reform.
And, Minister, will there also be a public consultation period before the bill is, brought to Parliament?
Well, we're doing the consultation process as we speak.
I'd like to believe that, but in the past, statutory review criticised lack of transparency in consultation. So what have you done differently this time?
Well, I mean, this was announced late last year about what the government intention was to go, and during that time there's been work on the writing of the legislation. As you'd appreciate, we had obviously the December and the January, which is not the ideal time to consult, given a number of people may be away for personal reasons. So that's why we've done the consultation throughout that period, but also currently now, and we're at the latter stages of that, and we hope to bring the legislation.
And if you're in the latter stages, Minister, and during this consultation, have you had any feedback that it doesn't go far enough? And if that's the case, will you be? Are you amending?
Well, look, I said we're obviously receiving that feedback, and obviously we welcome all the feedback that.
But are you putting that feedback into?
Yeah, that's a natural pathway. But I'd also say this, that improving industry standards is, yes, there's a role for government, but there's also a role for the industry to ensure that their members continue to have higher levels of professionalism and standard of conduct. Regulation does work, and that's why we're taking in particular the financial incentives away for underquoting. That is, you're either going to be fined up to $110,000 or your commission, whichever the one is greater. So you actually can't see this as a cost of doing business by selling an extremely expensive property, and the fine is, or the penalty is actually less than your commission. So whichever one is greater, I think it's a pretty powerful disincentive not to conduct this particular sort of behaviour.
So at the last budget estimates, we spoke about prosecutions and Operation Sunlight, and I'm wondering how many underquoting prosecutions have occurred since our last budget estimates.
Yeah, look, can I defer that to the Fair Trading Commissioner to give you an exact number? I just want to make sure you get the right figures.
So thank you, Minister. Since the last estimates, we have suspended the licences of 3 entities specifically for underquoting and price misrepresentation. And we have also established, as you mentioned, a number of compliance operations. So Operation Sunlight is the one where we have issued 50 warning letters to real estate agents, but also a new thing that we're doing is our anywhere, anytime inspections, where we have fair trading staff out in force that can turn up to any real estate agent across the state at any time and inspect the books for underquoting.
And so you said 3 entities, was that right?
Yes, licence suspensions for 3.
Suspensions. So on that, why suspension and no prosecution?
So it's a very good question. As a regulator, we have a whole suite of regulatory options available to us, one of which is prosecution. We are considering prosecutions in matters. I think, as the Minister said, we have much stronger underquoting laws that are imminent. And it's a real question for us as a regulator whether it's the right thing to do to commence expensive, protracted prosecutions under the existing law when we have much more forceful laws around the corner. So we always have to consider what is the best regulatory approach to take in the circumstances, and they're some of the contemplations that we're having.
So, Minister, based on that,
Yep.
would you say suspension alone is considered a sufficient deterrent?
Well, there are many ways to deter. I said the suspension. I think the increase in the financial penalties is a significant pillar.
So we can look forward, like once the bill is that you'll be strengthening what is currently in place.
Absolutely, and we've made this point publicly. As I said, it's about transparency and accountability, giving consumers, home buyers or renters, maximum information, and that agents need to substantiate how they got their price guide, which means that you can't just advertise, call us or price on application. You need to give a price or a price guide and then substantiate that with a publication and information statement.
Mm-hmm. And has underquoting reduced since 2023, since you've been in government?
Well, look, I'd have to get some advice on the stats on that, but underquoting is a significant issue. It's been around for quite some time, but that's why the government has moved quickly with powerful, significant changes to the underquoting laws to actually penalise those who are caught in this, I think, really unfortunate and really deceptive sort of conduct, which punishes, home buyers or in the market.
Mm-hmm. Thank you, Minister. And just to confirm, so you've done 3 entities that have been suspended, but no prosecutions.
That's correct, and I just want to clarify the point that those suspensions may then lead to further disciplinary action, including permanent disqualifications.
Okay. Thank you. I might move now to the Strata task force that you've... Can you confirm the total funding that has been allocated?
Look, I understand it's, if my memory is correct, it's $8.4 million over the forwards.
And the staff, can you confirm full-time equivalent staff?
Yeah, look, I understand at the moment we've got 17 investigators and 17 inspectors.
And how many inspections have occurred?
Look, I'll have to take that on notice.
I'm happy
Fair Trading Commission, yes.
Yes, no, I'm happy to do that. So
I could ask in the afternoon, okay. Sorry. And of that, how many enforcement actions?
Look, can I defer to the Fair Trading Commission? I just wanted to make sure you get the right number, that's all.
So in terms of the inspections, we've visited 24 strata managers under our Anywhere, Anytime strata inspection program, and we've issued 33 fines, 76 warning letters to them. In terms of some of the other actions that we've taken disciplinary action now against 13 strata managers, and 9 of those have been in the last 2 years. And we've got further disciplinary action ongoing against 4 strata managers.
Mm-hmm. And the Strata Task Force has been, how long have you had that in place, Minister?
Look, I think the budget was allocated last year.
Say 12 months.
Yeah.
And would you say what was the measurable improvement has occurred in strata compliance since since?
Look, absolutely. I think the fact that we've not only created the task force, we've resourced it properly. One of its core functions is compliance and enforcement. The other is also around educating the sector. It's got an educational role because one of the best ways to, I suppose, reduce misconduct is to inform people of their obligations, of their role in this particular sector. So it's got a multitude of roles, and we hope that in the long term we'll see much more improvements and we'll see fewer agents caught doing the wrong thing.
So, but if I was to measure that, like, how has it improved since before the task force was in place?
I think some of the measurements we're looking at would have to be long-term changes to the conduct of the industry. I mean, these sort of reforms will take time to seep through to the sector. Obviously, there's also a role for those associations who represent, for example, strata managing agents to inform their members about their legal obligations and their level of conduct. So it's not just the strata property task force doing all the heavy lifting. Everybody's got a responsibility here, both the Owners Corporations Network, obviously the strata, the SCA, the Strata Managers Association, the property industry, and of course
Minister,
the government.
but how are you measuring it? Like, you can tell me all of this, but like in terms of outcomes, I don't get what.
Yeah, look, I mean, what we would like to see, I think in the long term, Mr. McDonald, is fewer agents caught doing the wrong thing. Of course, those who are caught doing the wrong thing will make sure that they are prosecuted appropriately to send a pretty clear message that this sort of behaviour is not acceptable. So I think there are many ways to measure the effectiveness. There are obviously some shorter term ones, but the longer term ones I think is really about industry change, behavioural change, and these things cannot be measured instantaneously because the reforms do take time to be implemented. Those in the sector need time to understand their obligations, and we'll continue to monitor the effectiveness of the reforms that we're doing.
And of the, so you said 8.4 over the forwards, so
that's
I
correct.
assume, say, 2.1 per year.
We can use it as an average, yes.
Of that, say, 2.1, how has that been spent to date?
Oh, well, like I said, I suppose the way it's invested, Ms McDonald, is the way it supports its core functions. I said there's compliance and enforcement. Of course, there's an education and information aspect to it. And, of course, there's also the policy contributions and the legislative contributions to the work of the Strata. So, I mean, the money is obviously used for these particular core functions of the Property and Strata Task Force.
And have underquoting complaint levels or reported breaches changed since your task force commenced?
Look, I might have to defer to the Fair Trading Commission to give you an exact...
Because that would be a measurable outcome, wouldn't it?
Yeah, but also you could say that if there are fewer complaints about underquoting, then perhaps the reforms and the message the government is getting out has actually led to some positive changes. So I think we just need to take a broad view of what is a measurement of success. And certainly any complaints about underquoting will be investigated by Fair Trading.
Okay, thank you, Minister.
Thank you.
I think we'll go to the Honourable Nicola Overall.
Sure. Great, thank you very much. And Minister, I'd just like to draw your attention to the fact that you raised previously with me in discussion of the history of the asbestos program about the time frame. Just very, very briefly, and I'm happy to provide you with more information if you're not able to provide us with the necessary information, that it has variously over the years from 2014 been referred to as multi-decade and long-term management, everything from the department's loose fill asbestos implementation task force reporting, New South Wales Treasury and Program budgeting statements, the New South Wales Parliamentary Inquiry into loose fill asbestos insulation, etc. So you might like to receive some more information on that history of the program itself. But in the meantime, you talk about case by case, what's going to happen, that it's not going to be February 28 that it's closed. How then have affected homeowners and the public been advised of this decision to cut the program and the register?
Well, look, I mean, I've tabled in Parliament and I've done the second reading. I mean, you can't get more public than that. I mean, the words that I've stated about the government's decision.
Minister, with all due respect, you rushed that through Parliament. It was simply a line item in your proposed bill about what was going to be occurring. In fact, I refer to Schedule 11. The bill will remove references to the Looseville Asbestos Insulation Register under the Home Building Act 1989. That's not really providing fulsome and comprehensive information to the public about why a critical program and register of this nature is being done away with.
One, can I just make the point that there's only been one property that's joined the program since 2024. So the demand is
159 since 2015, and more that were identified in the PricewaterhouseCoopers report. So you're suggesting that that report now that was adopted is wrong?
I've never said that. What I'm merely stating are the facts that there have been, I say, 71,000 properties that have been tested for this program. As you're right, the number is about 150 or so has been remediated. But I also say the fact since in the last 2 years, since 2024, we've only had one property join the program. As I understand it, I recall that particular property does not want to be part of the actual remediation program.
There are reasons around that as well, Minister. I hope that you are aware of. There's also just been a property just last year, I believe it was. I don't have that date in front of me. There in Holbrook, which was identified 8 years after other properties in that same area were identified. So are you suggesting that more properties, more contaminated properties, that's not going to occur into the future? There won't be identification of such properties?
Well, I said all eligible properties for in the future we considered on a case-by-case basis, and resources will be made available for those properties that are eligible for support. Like, I mean, it's you know, I said the facts are clear. The program, it's a good program. I don't deny that at all, but it's run to its natural conclusion. We've had property.
So that's your entire evidence for that argument, Minister, that there's been one property since 2024. So that leads you, with no evidentiary basis really, that it is run to the course of its natural life, even though these reports, task force, etc., suggest that it is a multi-decade long-term management issue, that you are putting the public safety at risk. Why then are you, at the very least, not keeping the asbestos register, as they still have a program and a register in the ACT, for example? Why are you not keeping the register at the very least?
Well, I said the program, I don't agree with your assessment, your characterisation. Under this program, implemented by the former government, which I think has been welcomed, has done 71,000 tests. A number of houses have been remediated.
Across almost 1.3 million properties across New South Wales that could potentially be impacted.
Well, I said it is. Oh, sorry, I missed you. You went offline, then I couldn't hear you. Did you want to finish your question, Ms. Overall? You cut off.
Okay, thank you, Minister. What about the future potential impacts on future homeowners, people like tradespeople, emergency services personnel that may need to access properties, and because there will not be a publicly available register, there will be no information available as to properties that could be or have the potential to be contaminated?
Look, I got it myself. I think there might be a misunderstanding in the scope and the intention of the register here. So the register itself is a voluntary register where those property owners come forward to the department to say, look, my property has these particulars, and then we obviously go in and test it, and they become. So it's not meant to be the central source of every single property across New South Wales that has or hasn't got this loose. It's not. That's not its intention.
But it is a publicly available source of information that, as you say, people can go to. And I believe, and again, I don't have those figures before me, but there are something like thousands of views of that website every single year. Can the Commissioner confirm that's the case?
Commissioner?
Thank you. So what I will say is that the register does not contain So first of all, the register currently contains 3 properties on it. It does not contain the list of the 159 that have been found, because as the government remediates those properties, they're removed from the register. So there are currently 3 properties. One will be taken off the register when it's remediated in April. There'll be 2 remaining. You cannot, as a member of the public, see those properties listed. You actually need to know the address of the property to input that address, and if it is the property, then that property will come up. So I just want to be clear about the register and its purpose and how it's used. That's the first thing. And you know, this is a program, at its inception in 2015, of course, there was a lot of interest in it. You know, there was 105,000 notifications to us with 71,000 homes tested. But the reality is that when PwC did that modelling back in 2015, and the amount that you're talking about was what was provisioned as a liability based on the absolute upper limit of homes that could be identified. That has not come to fruition. We are sitting there now, 10 years on, as the Minister said, there's been 1 property identified in the last 2 years. It doesn't make a lot of sense to keep this open with dedicated staff, dedicated services to run a platform when we're just not seeing the numbers anymore. So that's the reasoning for it. But obviously, if for some reason property owners are coming forward, there is a scheme, we will look at ex gratia payments. But in terms of keeping that property open, that program open, it doesn't make sense with the facts and the numbers that we have before us anymore.
Thank you. Sorry, Ms Overall, the bell has gone.
The bell has rung.
Yeah,
so
thank you. The Honourable Mark Latham.
Minister, you're saying you weren't briefed on the interaction between Kalani and Naveed Akram at the Long Bay?
Look, I was made aware of it, and I said, as Ms Galoutsis has said, the allegations were investigated. And they were found not to have been substantiated.
Okay. Did you raise any objection to the fact that this bastard who'd been party to killing 15 people at Bondi, including a 10-year-old girl, was given comfort with the attendance of a chaplain and the provision of a Quran that he used to justify this massacre?
Well, I said I was made aware of it after the fact.
And how did you respond?
Well, I said an investigation. I was obviously concerned if that were the case, and that's why the investigation took place with the department, and those claims have found to be unsubstantiated.
Are you comfortable? Well, no, we do know that the chaplain attended and gave him comfort and gave him the Quran. Are you comfortable with that?
Well, I said we have a general chaplaincy program where inmates...
I'm not asking about general, I'm asking about specifics of what happened at Bondi, which is unique.
Oh, look, it's a tragedy what happened at Bondi. Our chaplaincy program is made available to all inmates. And
no, it's not. If you're a category AA inmate, there are specific guidelines as to whether you have access.
Well, I said all inmates that are at the highest category will continue to have a high level of security assessment. That's correct.
Well, what happened here?
Sorry,
Did you see the independent report?
No, I said...
Order, thank you. Thank you. The opposition has 1 minute.
Thank you. Minister, are you familiar with Brian Cornwall, who tried to get his builder's licence in October and has been waiting until this week to get a response?
Look, I don't have obviously a recollection of every single application that's been made.
Were you aware that yesterday in budget estimates it was brought to the attention of Minister Dibb and on Tuesday, and that he then suggested that obviously it's a matter for you and the Building Commissioner, and I'm wondering if you were briefed about that?
Look, not about specific case, but in terms of the licensing timeframes, yes, I have been briefed about it.
So is there a limit to the timeframes?
Well, look, I suppose I know the estimated timeframe is a lot longer than we would like, but that's why the government...
But what is that?
Well,
is there an average? Is there a limit? Is there a goal, a target?
Look, we'd like to obviously assess and approve licenses as quickly as we can, but
why can't you? Because this gentleman received a phone call after the budget estimates went to air and there was a media story about it. Then he received a phone call 20 weeks after he'd applied, and answer was given that the Commissioner's office was waiting to speak to his reference, but his reference was called 10 minutes before he was called yesterday. So is that acceptable?
Look...
Sorry, the member did start the question actually before the bell rang, so I'll allow the Minister to ask the question, but I won't allow the member to ask any further questions.
Look, I said I'm aware of the media reports regarding this individual that's licensed. And I said the government, at the moment, excuse me, the estimated assessment time is approximately about 20 weeks. That's not where we would want it to be. And that's why the government has allocated close to $5 million to recruit more people into the licence applications to approve these things quicker.
Thank you. Government questions?
Can I ask, Minister, are there any matters on which you'd wish to elucidate?
No, I think I'm
very fulsome responses.
Thank you.
Thank you.
In that case, we will break for morning tea and we'll be back at 11:15.
Go.
Welcome back to budget estimates.
That's
Thank
right.
you, everyone, for returning in your time. I'm going to throw straight to Ms. Higginson.
Thank you very much. Good morning, Minister.
Morning, Ms. Higginson.
Minister, the CAS Act requires certain classes of inmates to be provided with support persons during disciplinary proceedings for correctional centre offences. The Ombudsman found that all findings of guilt made against inmates were contrary to law, including because support persons were not provided. Both the Ombudsman's legal advice from 2024 and Crown Solicitor advice to the Commissioner in early 2025 confirmed any decision of guilt made against vulnerable inmates during a proceeding without a support person would be unlawful. Yet on 17th and 19th of September last year, your Chief of Staff wrote in emails that she believed we were, quote, in a position where the legislation does not support Corrections Services New South Wales saying staff members are required to act as support person for an inmate if they don't want to do it, and asking if alternative models can be explored. Does it concern you, Minister, that your Chief of Staff is encouraging continued non-compliance with the CAS Act, resulting in a practice contrary to law?
Well, look, I'm not sure I agree with that characterisation, Ms. Higginson. What my office and myself as Minister in the reforms in corrections is obviously to prioritise the safety and the well-being of inmates and of officers as well.
So Minister then, but so just on that basis, I accept that that's possibly some thinking behind the email and the correspondence, but it's contrary to the law. Inmates, if they require and ask for a support person, they're meant to have one. But your Chief of Staff is saying we need something different. We don't want to do that. They shouldn't have to do that. That's the law. Does that concern you?
Well, no, look, I think I said I'm not sure I agree with your assessment. I mean, any correspondence that my office has with the department is always about looking at options to improve the safety and the well-being of our facilities. Like correctional facilities are actually highly complex and they're volatile environments, and we always need to look at ways to stabilise environments.
But Minister, this is a very, very discrete, specific requirement at law that inmates are required at law where they request, and in certain circumstances, vulnerable inmates that are facing disciplinary proceedings when they are inside prison, to have a support person. It's really very simple. It's the law.
No, well, I think there might be a misunderstanding in your interpretation of the correspondence.
No, the Ombudsman found that it was a practice that was not happening, and all those findings of guilt where it hadn't happened were contrary to law. This was after all of that, and this was in September last year.
So I think there are a couple of issues that what we're talking about here. I mean, if we can just stick to the Ombudsman's report that you're referring to, yes, I'm aware of it and I'm aware of the recommendations, but I'd also point out that the government has accepted and has accepted and support in principle the 34 recommendations that has been outlined in the Ombudsman's report.
Minister, how can you say that when the government then ran off and actually created laws to change the entire system in terms of the standard of proof? On that, I just want to ask you, if I can then, based on those recommendations, how did your position change in relation to the Ombudsman's finding? Because on Monday the 29th of September last year, you approved a letter sent by the Commissioner to the PSA General Secretary Stuart Little in relation to their concerns around the inmate disciplinary proceedings. In that letter, the Commissioner argued that the concerns from the PSA had risen from a misconception. All that happened on a Monday the 29th of September. By Friday the 3rd of October, you stood up and announced a bill changing the standard of proof and departing from the Ombudsman recommendation. How did your position change?
Look, I said the standard of proof is one element of the inmate disciplinary process. I said the government and myself as Minister will always take soundings, in particular from our workforce. I said sometimes things in theory and things in practice do diverge, and that upon obviously hearing what happens in practice. The government...
But for months and months, Minister, your department and Corrective Services New South Wales were working around the clock in a brilliant way. It's very clear from all those SO52 documents. They were doing a remarkable job to implement the findings of the Ombudsman, very serious findings. And then, in the space between Monday and Friday, you changed positions on the standard of proof. Was there cabinet approval to do that?
Well, as I said, one, can I just say, in the Ombudsman, so I said the standard of proof is one element of the 34
yes, so
recommendations.
on that one element, what changed your mind so quickly?
The government obviously took soundings and obviously met with stakeholders, in particular from the workforce and the workforce representatives. I think there's also, we need to also clearly delineate the standard proof for what is obviously administrative matters on a civil standard, so the balance of probabilities, and also those beyond reasonable doubt. Now, serious misconduct or serious allegations can still be referred to the police, and
yes,
that the criminal standard...
Look, I'm aware of that, but Minister, can you just tell me what change? What was the change of approach? I've looked at those documents that have been produced under the standing order. Did you discuss the inmate discipline system with the Premier?
Well, it's a decision of government.
Did you discuss it with the Premier?
Well, look, naturally, I discussed with all my colleagues about this decision.
So you did discuss it with the Premier?
Well, it's a government decision.
Did you discuss it with the Premier, Chris Minns?
Well, he's the only Premier.
That's right. Did you discuss it with
the
Premier?
Well, I said, look...
Did you discuss it with people from his office? I just need the answer. I've only got a very short period of time.
This is the decision of the government and the decision of the Cabinet. All those in the Cabinet obviously will
debate. Did you meet specifically with the PSA solicitor and former industrial officer Jim Minns?
No, I don't recall meeting Mr. Jim Minns.
Did you discuss it with him in any way, shape or
form? No, not that I can recall.
Did people from your office discuss it with him?
Well, I said...
He is the PSA officer responsible.
Yeah, but I look, my diary disclosure is clear. I actually met with the PSA and the PSA General Secretary, which is the most senior person in that organisation. So
why did you change your mind and the position within that course of a week?
Look, fundamentally, Ms. Higginson, it's about creating stability and safety at the correctional facilities. The government has adopted 34 of the recommendations from the Ombudsman's report. There is a review mechanism for inmates who believe that they have not been or they believe that the assessment on inmates could be correct. We've got a statutory review of the legislation. We've had these debates in the Parliament. I'm comfortable as Minister, and the government is comfortable with where we've reached in terms of the changes to the inmate discipline through the CAS Act.
Thank you.
Thank you, Ms. Higgins.
Thank you.
Thank you, Minister. Just returning to the interior designers that we spoke earlier this morning. This lack of recognition is not just an interstate inconsistency. It places Australia behind Asia-Pacific neighbours such as Malaysia, Indonesia and the Philippines, where interior design is increasingly treated as a regulated profession, essential to building quality, consumer protection and international trade competitiveness. You've indicated earlier that creating a registration pathway might be something that the government will look into in the near future. Given the risk of being behind the rest of the world and given the risk of slowing down the construction industry more broadly by holding back, and a lot of these interior designers have done very long degrees, they're highly qualified. Will you commit to starting that process sooner rather than later so we can make sure that those that are qualified and are skilled are being able to be put back into this workforce?
Well, look, certainly in terms of the interior designers, the government is open to continue the dialogue with the industry representatives. I don't, and I've never denied the contributions that interior designer makes to the sector. We are always engaging with representatives to determine the best path forward. But I'd also make this point too, Chair, is that if we want to move to the formal registration process, it could also limit what interior designers can actually do, and they may not necessarily be the interests of interior designers either.
Well,
so
at the moment they're so limited that there's most of the things that they were doing they can't do. So most of them are finding other employment now because of the major changes that have already gone through. But once again, Minister, your ministerial diary disclosures don't show any meetings with the Australian Design Institute or similar organisations representing interior designers. You said that you're open to continuing conversations with them. Why haven't you met with them?
Look, I'm always happy to meet with meeting requests that are sent through, Chair. I mean, obviously, when those requests are sent through, we would always consider those and meet as many people as possible. So, and I'll also go back in terms of the interior design and what the Building Commissioner said. Obviously, there are aspects of the building space that interior designers are able to do, but then we get to the much more riskier aspects of, where it comes into the structural safety and integrity. We want to make sure that those who are only qualified to undertake that task are actually allowed to do that task.
So, Minister, so you are willing to meet with the Australian Design Institute?
Absolutely. Look, they just need to put in a meeting request. I'm always happy to have an ongoing dialogue.
Thank you. Thank you, Minister. Just moving on, Minister, last year the New South Wales Government released the New South Wales Plant-Based Protein Manufacturing Prospectus, and you noted the growing demand of these products and the potential economic opportunity for New South Wales. I'm wondering how this prospectus has been received and whether there's considerations for more expansions in that space.
Look, I don't recall this prospectus is actually under my jurisdiction. It may be with the Minister for Agriculture, would that be correct? Yeah, I think that's with Minister Moriarty.
Okay. You are quoted in the media release, I believe. I'll get a copy of that and just clarify with you in a moment.
Sure, that's fine.
But Minister, I also know that you attended my cellular-based meat tasting session here in New South Wales Parliament, and thank you for attending that. I appreciate your time and interest. I'm just wondering, what did you think when you had that the cellular-based meat?
Oh, delicious. I'd also say that I recall being to other organisations that did do a plant-based meat, and I think it's great.
Can you see a real potential for a growing market here in New South Wales for the cell-based meat industry?
Yeah, look, I hope this. If there are a number of organisations based in this particular sector, I hope the demand grows not only in New South Wales but across the world and also across the country, because I think that growing demand will filter down to obviously creations of companies, of jobs, and all the on-flow effects of economic activity.
And are you interested in meeting with the company that produced that cell-based meat or other companies similar in this space to discuss, what sort of avenues with the New South Wales Government they can help to achieve that?
Only if they bring some samples, Chair.
You really like
I'm happy to meet with them.
Like
That's just a side joke.
Yeah, all good. Thank you. I'm sure that they're happy to oblige. Minister, I do want to talk about some isolation practices, moving over to the correction space.
Sure.
Under the Mandela rules, solitary confinement is defined as the confinement of prisoners for 22 hours or more a day without meaningful human contact. The total amount of confined hours, and that's Rule 44. Is the Minister aware that the New South Wales Crimes Administration of Sentences Regulation actually departs from this internally accepted definition of solitary confinement?
Chair, thank you for the question. Look, can I just clarify that in New South Wales we don't do solitary confinement. It's actually prohibited. The New South Wales Corrective Service does do segregation of inmates under obviously exceptional circumstance, and mainly for the safety and the well-being of either that particular inmate or the inmate population in general.
But I mean, obviously, so the broad definition of solitary confinement also includes a list of things like segregating an inmate from other inmates, confining an inmate to a cell, keeping an inmate alone in a cell if a nursing officer considers that desirable. So, I mean, these are kind of what are broadly considered forms of solitary confinement. So how can you say that we don't allow solitary confinement, but at the same time there's just a new definition that New South Wales has picked up that still allows it to actually occur?
Look, I'm advised that we actually don't define solitary confinement in the legislation, but segregation of an inmate does happen, and purely for safety issues. I just think if there is intelligence within the system that a particular inmate maybe endangered to themselves.
So, Minister, are you saying that nobody's ever segregated for anything other than safety? They're never segregated as a means of punishment?
Well, what I said, there are a number of circumstances when an inmate, for their own safety or the safety of the wider population, is segregated. In terms of its finite details, I can ask the Commissioner or the Deputy Commissioner to provide details of
And I'm happy
when
to
it
talk to them
happens.
this afternoon. But I guess it's just very strange. I'm not talking about having a definition in the Act. I'm talking about the Mandela rules around solitary confinement and what that means. And you're saying we don't do solitary confinement.
No, we don't.
But then you're also giving me examples where you do.
Well, I said we do...
Under a different...
Well, I'm obviously, under the CAS Act, we do segregation. That is, I said, mainly in exceptional circumstances for safety and well-being of that particular individual or the general population, if they were to mix with the general population.
Thank you. Ms Boyd.
Thank you, Chair. Good morning.
Good morning, Ms
Minister
Boyd.
and officials. Is it still the New South Wales Government's official position that a New South Wales port should be selected as the preferred location for Australia's East Coast submarine base?
Sorry, I missed that question.
Is it still the New South Wales Government's official position that a New South Wales port should be selected as the preferred location for Australia's East Coast submarine base? The nuclear
Those
ones?
decisions are a matter for the Commonwealth, determines where the Commonwealth wishes to locate this particular facility. I'm not aware that the New South Wales Government has a role or a right to actually select this location.
Well, let me refresh your memory. So in the last term of government, as in the documents that were provided to us under a recent SO 52 from your department, there was a submission made by that government arguing very strongly that any East Coast submarine base be located in New South Wales. Is that still the preference of the Labor government?
That's the former government's position. I said the position of the New South Wales government is that these decisions are a matter for the Commonwealth, not a matter for the New South Wales government.
So there was a briefing note that was prepared for you by the department in 2024, by the looks of it, which talks about this recommendation that New South Wales has to the Commonwealth that New South Wales Port be selected as the preferred location. Given that you were briefed on it and given speaking notes in relation to it, it clearly is seen as something within your remit. Is it the continued position of New South Wales?
The New South Wales government has done no work, as far as I'm aware, in relation to this issue.
Have you read the documents that were returned in the standing order, the public documents that were returned?
On this particular, I've been briefed about it, and I understand that the position you're referring to was done by the former government.
Yeah.
And it's not, the government has not done any further work on this particular issue.
Okay, but in the notes that you were given, which refer to the New South Wales Government's submission to the Defence Strategic Review of the Commonwealth, it's giving you very specific instructions on how to respond to certain things. And in particular, it provides you with information in relation to Port Kembla being the favoured location of New South Wales Government. And I believe that was made quite clear by Mr Perrottet when he was around. There's been no departure from that, and you have been given speaking notes that clearly refer to that as being the preferred location. Are you claiming that you don't have a position?
I said no, the government, as far as I'm aware, has done no further work on that issue. I mean, the position of the former government doesn't mean it's the position of the current government, and that the location of the East Coast base is a matter for the Commonwealth.
Yeah.
But in this particular departmental brief, I might ask the Deputy Secretary if she can further enlighten the committee on this issue.
Could I will maybe come back to you in the
Sure.
afternoon, but Minister, whether or not Port Kembla or Port Newcastle is chosen as a site for a future nuclear infrastructure and submarine base is clearly going to have a massive impact on the other businesses and industries around those ports. It is your responsibility and your portfolio, isn't it, in relation to the trade and what happens at Port Kembla or Port Newcastle?
Well, I think the impact when the Commonwealth makes that decision or its location, it's not just my port, it's got the other portfolios as well. I mean, the New South Wales government does not have a role or has a is the decision maker, and when these are located, I think once those decisions are made, we'll,
Yeah.
I think, all be in a better position to determine the impact and what changes need to be made.
So when Port of Newcastle was, when the arrangement was entered into with Port of Newcastle to effectively allow it to become a broader, more diversified port, were you consulted at that time by the Treasurer as to the implications that would have in terms of making Port Kembla then the preferred location for a nuclear subbase?
I'll have to ask you to clarify what... is this going back to the former governments?
No, this is your government. The Treasurer has entered into an agreement with the Port of Newcastle to allow it to diversify away from coal and be able to, have basically a full-scope container terminal. By doing that, New South Wales has selected the Port of Newcastle as being the future port for where that sort of trade will occur. That necessarily then precludes Port Kembla from doing that. So presumably then Port Kembla is still being the preferred location for the submarine base.
Look, I'm not sure I agree with that conclusion or the correlation that you're making. Trade diversification is certainly an objective of the New South Wales government, and in terms of the working of the ports, and that's a matter for Minister Graham and Minister Aitchison and the Treasury.
But it's either or. You can't have a submarine base at a place that you also have a diverse container port, and you can't have it where you have things like hydrogen hubs because it's dangerous. All of these considerations come into play. You need to know where your subbase is going before you can work out what to do with the rest of the ports and freight and trade infrastructure in the state. Isn't that correct?
Look, Ms Boyd, no decision, as far as I'm aware, has been made by the Commonwealth regarding the East Coast location of submarines. I think it's, it's all hypothetical at the moment. Once those decisions are made, we'll all be in a better frame of mind to determine what's the best action to take.
Thank you.
Thank you. The opposition?
Thank you, Chair. Minister, since the last time we saw each other, the government has cut South by Southwest Sydney early. The Innovation and Productivity Council has been put on ice, and now we've found out that the Techstars program has been defunded, where the most recent cohort had 5 founders from culturally and linguistically diverse backgrounds. 3 were led by women. What do you say to the founders who are hopeful of getting into Techstars this year?
Look, I'd say that New South Wales is the place to be, and the government's reform, the government's changes is all about preparing the New South Wales economy for the digital future.
So
and if I just go back to...
So they don't have this program anymore, but New South Wales is still the place to be.
So you're referring to Techstars?
Yes.
Okay, well, we should always just get to the facts on these things. Techstars was a contractual agreement signed by the former government with the organisation.
Which you've chosen not to
Well, it
extend
was
or
done
renew.
for a 3-year period.
Yes.
Both parties are meeting their legal contractual obligations.
Yes. But why
and-
did you cut it?
Well,
if it's in line with the aims of the innovation blueprint to get more women founders, diversity, culturally and linguistically diverse founders involved?
One, no funding has been cut. The contract has been met by both parties. That contract is ceasing. And I'd also say...
So why aren't you renewing the contract?
Well, if the former government thought this should be a long-term program, then they should have entered into a much longer agreement.
We're 3 years into your government, Minister.
Well, a 3-year contract...
It's actually up to you to make a decision about what you want to do with the contract,
right.
if you want to extend it. So
Well,
if you want to play semantics, that's fine, but why did you decide not to renew the contract?
Well, one, I said the contract was signed and the contract has been met. The government has taken a different approach, and I do value the work...
Okay, so what is the different approach?
Well, I said the government obviously values the work that's been done by Techstars. I mean, the Deputy Secretary has made public commentary to that front.
So have you. That's why I'm trying to ascertain why you cut it and if there's anything to replace it.
Well, one, we haven't cut it. The contract has met its end as stipulated in the agreement between the former government and the recipient. The government obviously has the innovation blueprint for which $80 million has been allocated, one of which is also the fact that there's $4 million for the Diversity Accelerator program.
So how much of that has been spent?
Well, I said the government obviously has got that program.
What is that program?
Well, the Diversity Accelerator program.
Yeah.
Let me go back one step.
Like, I'm aware it has a website, but there's no. What is that program? Has money been spent?
Let me go
on
back
that?
one step. What I'd also say about Techstars, yes, it did provide support to female founders, but that was not always its intention at the start. That was a much later part in the Techstars. So what we've got is, I said, $4 million towards the diversity program, focused on, I think, in particular, not only female founders, but those in other disadvantaged groups.
Okay, but what is the program? Is that program working? Is that something that founders can get involved with at this point?
Yeah. Well, look.
What can they do? How can founders get involved with this $4 million program?
Yeah. So the $4 million Diversity Accelerator program is about actually supporting those groups that have often been overlooked.
Okay,
as
so
you'd be aware.
If somebody from one of those overlooked groups is watching you right now, how can they get involved in this program?
Look, as I said, so I think it's important to outline the criteria or the intention of that Diversity Accelerator program. It's female founders, as you're aware. Female founders do not get as much capital as they should.
I'm aware, Minister, and founders are aware of that also. So how can they get involved in this? Does this program actually exist?
Like I said, so part of that is not only for, but also those in the regions as well, and those are from cold communities and also Indigenous programs. Now, the program itself is being designed. I might ask the Deputy Secretary to outline the further criteria on that.
Look, Minister, can you just tell me if any money has been expended and is that program open?
Well, that program, the designs of the program is being finalised.
Okay,
and it'll be announced.
When will it be announced?
Well, I said once the design of the program has been finalised, we'll obviously open...
So of that $4 million, is that $4 million that was budgeted for the 25-26 budget, or is this into the forward estimates?
Look, I understand it's in the forward estimates.
Okay, so it's what, $1 million a year, or...
Well, on average, you would say that, but there are also other...
So I presume nothing has been spent this year?
Well, I said we want to make sure that the allocated funds that we've got go to the recipients that need it most.
Okay, so is that $4 million for founders specifically, or does that include the running of the program and costs associated?
I said the $4 million has been allocated to the diversity program to actually support those groups that have been often overlooked in the funding.
I understand, but you can't tell me any details about how that $4 million is actually going to be spent.
The design of that program has to be, I think, clear and tight to ensure that the recipients who obtain those fundings are actually the ones that we intended to make.
Okay, all right. Were you consulted on the scrapping of South by Southwest Sydney?
Like I said, South by Southwest Sydney obviously has been in Sydney, I think, for about 3 years now. The organisers and the government came to an agreement that it should not proceed.
Were you consulted on that agreement?
Look, the department, I see, was part of a decision-making process.
You weren't involved in that?
Well, I said that the department was involved in the decision-making
Okay, but it sounds like you didn't have any personal input as Minister.
Well, I said that the funding for South by South is actually with Destination New South Wales.
I know, that's why I'm asking if you were consulted. I'm not asking if you made a decision.
The department was consulted in the decision-making process, and it's a decision was a matter for Minister Camper.
Okay, but he didn't have the courtesy to ask you personally, Minister to Minister.
Look, the decision was made in agreement with, I think, TEG, the organisers, that South by Southwest would not proceed.
I don't think that they would say it was an agreement that they came to in any sort of spirit of collegiality. I'll move on to the Innovation and Productivity Council. I'm just wondering when we can expect the biennial 2026 New South Wales Innovation and Productivity Scorecard.
Yep. Look, the Innovation Productivity Council obviously has made a good contribution to the sector at the moment.
But just on the scorecard, can we expect that?
Well, the government is actually currently doing a review of how to better engage with the sector, which involves obviously the potential future work of the IPC.
Sorry, just on the...
Yes, there's been a point of one. Yeah.
I'm trying to follow what the Minister's saying. Questions are being asked. I don't think it's particularly courteous under the procedural fairness regulations to not allow the Minister to at least begin to answer his questions before he's then interrupted and another question or an interpretation of that question or indeed an answer to the question is being given by the Deputy Chair.
Thank you. Look, it's dangerous. getting close to that, I think. There has been, quite a lot of sort of back and forth quite quickly. So I just use this opportunity to remind the member to allow the minister to complete his answers where appropriate.
Okay, so I'll just be clear about my question, Minister. When can we expect the biennial 2026 Innovation and Productivity Scorecard?
Well, look, I said the government is doing a review of the IPC and how it can better engage with the sector. Once that review is complete, we'll determine how best to utilise the resources, the skills and the expertise of the IPC to develop these and other metrics that will help inform the government on how best to continue to grow the sector.
So where have the IPC failed to engage or inform?
But it's not about failure. I never said that it has. What the government is doing is looking at ways to better engage with the sector and the role that the IPC will have. I don't think any...
So how many members of the IPC are there at the moment?
Well, at the moment, I said the government is doing this review of the IPC and the work in general of the broader sector. Once that work is complete, then we'll determine the makeup of the IPC.
Well, the IPC is your singular legislative responsibility as Minister for Innovation, Science and Technology, and it is a legislated body, so it has to exist. So how many members of the IPC are there currently?
Well, at the moment, no board members have been appointed because there's no need for that to be appointed.
So you have no members of the IPC at the moment?
Because the IPC, I said the review that the government is doing to ensure that we can find the future direction of how best to engage with the sector. Once that's finalised, I think we'll have a greater focus of where to actually go.
Okay, so you've scrapped the IPC without the review findings at all, and now there's no Innovation and Productivity Council currently functioning. Is that what you're saying?
Well, no, I haven't scrapped it. I think that's a mischaracterisation.
You just said that there were no members.
Well,
you just told me is it correct that there are no members, like you just gave evidence to the committee of?
I said the IPC hasn't been scrapped.
So are there members of the committee at the moment?
Yeah, there's been a point of order. And I think I know what the point of order is. I think we're getting close to that point again where we need to allow the minister just to provide a short answer.
I'm just trying to understand with clarity, are there members of the IPC at the moment?
Look, at the moment, the government is taking this review on how best to engage with the IPC. I mean, there is no, I think, operational purpose of the members of the IPC when the government is reviewing how best to actually improve its engagement. So once that review is finalised, we'll be in a better position to determine how we proceed.
When will that review be finalised,
Well, look,
Minister?
I think, once that review is finalised, the government will be in a position to make that announcement.
Sure, but do you have a deadline or a timeline on that?
Well, we're working on this at the moment. And
yeah, but surely you've got a timeline. Surely you have asked your department to give you an end date as to when you should receive this information so that the IPC can function or not.
Yeah, like I said, we'll consult with the sector to make sure that we get it right. I mean, I don't think there's no need to rush this. I want to get this right, and the changes that the government will, if the consultation comes back.
Do you value the work of the IPC?
Well, yeah, absolutely, and that's why we're trying to find ways to actually make sure it continues to play a vital role for the future.
So how are you comfortable with not rushing a process and you have no IPC at the moment, and yet they've given so many reports to government that Investment New South Wales refer to consistently, that your other trade statements and industry statements refer to? Like, how... I just don't understand why you would do a review that has no deadline. You have no members of the IPC, and you now currently exist without any formal advice from a body that has existed ostensibly since the 70s.
Well, I think in one sense, its long existence means we should always be open to change.
Sure, but that doesn't mean you scrap it without the review.
Sorry, there's been another point of order.
Chair, I think it would assist with the fair and orderly conduct of this inquiry if the Minister were given a reasonable opportunity to answer the question. And I just note on the last question, the question was longer in length than the Minister's response. So
well, because he needs some more information.
Order, thank you. Yes.
So can you
order, thank you, Minister. Look, on this occasion I am going to uphold the point of order just because there's been quite a few, and just to remind the member that if she wants to make sure she's not continually interrupted, to keep that in mind. Thank you.
I'll move on. Thank you, Chair. Minister, at the last budget estimates, I asked about the pricing of desks at Tech Central and eventually received an answer that the information was commercial in confidence. Given the desk space is now apparently available, could you please tell me what the rates of desks are and how many are available at Tech Central?
Look, I think I might have to refer that to Deputy Secretary. That's a finite question on, obviously, a monetary value that I don't have on top of it.
Perhaps I'll ask you a question then about, do you think it's appropriate that that information is public so that founders can look online and see what desks are available and at what price point?
Well, look, I think the pricing information I might refer to the Deputy Secretary.
I know, but I'm actually asking your opinion as Minister as to whether you think that information should be...
Yes, there's been a point of order.
The Minister is entitled to refer the question and the answer on to a Deputy Secretary for a response under the procedural fairness resolutions. It is not fair that he's continually interrupted when trying to provide an answer. He is entitled to take the question and refer it to a Deputy Secretary.
He is entitled to take the question and refer it on. However, I do understand, obviously, we're very limited with our time with the Minister. And so if the member does want a specific question directly from the Minister, I'm happy for her to direct the questions to the Minister.
My question is that will the Minister provide advice as to whether he believes that it is fair and reasonable that rates for desk space at Tech Central are publicly available so that founders can decide whether they want to apply?
Yeah, look, I said, we would encourage all our founders to come to Tech Central. I think it's the right strategic move. In terms of what you're asking, whether it's reasonable, yeah, look, I can't see it's not unreasonable.
So you would expect that? You would
well,
expect
look, I think it's not unreasonable, and we'll continue to obviously consider those things.
Minister, you recently led a trade delegation to China, which suggested through media reports that officials did not take their mobile phones due to security concerns. Is that accurate?
Yes, that's correct.
And is that also what you did? You didn't take a personal mobile phone?
No, I didn't take.
And why didn't you do that?
What do you mean?
Why didn't you take a personal mobile phone?
Based on security advice.
Okay, and what was that security advice?
That security advice was that communication, we should be circumspect about our communications, and it was not appropriate to take your personal mobile phone.
So when a deal is done for batteries to be imported to New South Wales, was there any security advice delivered on that matter?
I think that transaction is a private transaction that the government was not involved in.
So do you think that when you've got $130 million worth of batteries coming from China, that you have any responsibility as Fair Trading Minister to ensure that those products are safe for use?
Well, I said that the government had no role in the transaction regarding
I'm not talking about this specific transaction. I'm talking about more broadly. If we've got batteries coming in from a country that you don't even feel comfortable taking your mobile phone to, that you have some responsibility as Fair Trading Minister.
Well, I said all goods that come into the country obviously would need to meet the specifications of the product requirements. I mean,
do you think it's responsible to lead trade delegations to a country that you're not comfortable bringing your phone to and bringing back technology that could potentially be a sovereign security risk?
Well, wait a minute. I think you're conflating a couple of issues that actually are not accurate. I said the contractual transaction, the commercial transaction of the batteries is a matter for the private organisations. I'm leading a trade mission to our biggest trading partner, and we should continue to engage with our trading partners to ensure that we provide the economic opportunities for the people of New South Wales.
I think Japan's our biggest trading partner, but...
No, it's actually not.
Okay.
It's our biggest export market and a product, but it's not our biggest two-way trading partner.
So e-micro-mobility vehicles sold in New South Wales must comply with testing, certification and marking requirements, which are changes that your government has recently brought in. Do you think it would be appropriate to have a similar scheme for batteries that come from countries that you don't feel comfortable taking your own mobile phone to?
I said in terms of the e-bike mobilities, obviously its usage and its power to matter for the Minister for Transport, which the Minister has outlined.
But no, you've got, as New South Wales Fair Trading Minister, there's a published register of certified products, there are information standards that you oversee. So do you think it would be appropriate for you to lead a similar process for batteries from China?
Well, I said all products that come into to be used in South must meet the electrical safety standards, which I know the Fair Trading Commissioner have discussed
I know, but
about.
I'm talking about cybersecurity standards now, and standards that you may want to consider implementing, given you are going to countries that you don't feel comfortable taking a mobile phone to, or your entire delegation.
Well, look, I said I think you're conflating a number of issues here.
I don't think so, Minister. These are pretty clear issues about national security and your responsibility as Fair Trading Minister. So I'm trying to understand what how the contradiction exists in your mind.
Look, as I said, there is no contradiction. I don't agree with that characterisation.
Do you think that batteries pose a cybersecurity risk to the people of New South Wales?
Well, like I said, all products that come into the country must meet our product safety standards. And for fair trading, the electrical component is about electrical safety and the safety of the product in itself. I said electrical components, as I understand it, are actually not necessarily connected or directly correlated with cybersecurity.
Well, software and hardware actually go hand in hand. So, of course, electrical components are responsible for the software that is required to operate. So there is absolutely an overlap here. Is this something that you've asked your department to look into?
Well, like I said, the role of fair trading in terms of electrical products is to ensure that it meets the electrical safety standards, which I think is...
Yeah, but I'm not talking about the electrical safety standard. I was using that as an example of how you are, in fact, responsible as Fair Trading Minister for goods that are coming into New South Wales.
Well, I think you are misunderstanding my role as Fair Trading Minister. I think the importation of products to the nation is obviously a matter for the Commonwealth.
Sure,
in terms
there
of
are standards associated with individual products that you oversee.
Well, yes, and that's around electrical safety, which is what we have done in this case in terms of the e-mobility devices, which needs to meet those standards.
Minister, I'm terribly sorry to interrupt, but I don't think we're getting anywhere, and I just wanted to ask one final question. Sure. I'm curious about your involvement in the approval of the CDC $3.1 billion data centre approval.
Yeah, what's your question?
What's your involvement in the
approval?
approval?
I think, Investment New South Wales, through obviously the IDA, for which I'm a member of, we're trying to...
So was that process the relevant process for approval for this project?
Well, approval of projects is a matter for the Minister for Planning.
But was this an IDA project?
Well, I said, the CDC, as I recall, the Deputy Secretary was not in the original tranche or the first tranche of the IDA process or the EOI.
Thank you.
Minister, at the last budget estimates you referenced the anticipated publication of the thematic review of Aboriginal deaths in custody and indicated that would be finalised early this year. Can I get an update on the progress of that thematic review and when you expect it will be completed?
Look, the advice that I've got is that that thematic review has been a long time research, partly also quite an academic research process. Now, I think it was due to me, I think mid this year. Is that correct, Commissioner?
Yeah.
Yeah, you're getting that. So that has moved from your the last budget estimates. You said it would be finalised early this year.
Yeah. Look. In all honesty, too, Chair, like North Canada, I would like to have had this a review done sooner, but I understand there were some contractual issues involved within the research. That was done with, I think, a number of universities to make sure that the literature reviews, the analysis was actually accurate.
Given the delay in receiving the review, will you be considering the findings and recommendations as a matter of priority?
Oh, look, absolutely. Everybody is aware. And is in one sense, concerned about the overrepresentation of our Indigenous population in our justice system.
Well, I mean, more than that, I remind you that in October last year, the New South Wales State Coroner published an open letter about the, and I quote, profoundly distressing milestone of recording the highest number of Aboriginal and Torres Strait Islander deaths in custody in a single year. I'm assuming that this will be an urgent issue for you going forward.
Look, it has been. I mean, I think there are given that the thematic review is taking a little bit longer than I would like and the government would like, once I was getting concerned about the number of deaths in custody, I instructed the Commissioner to do a special Commissioner's review about deaths in custody, in particular. I focus on Aboriginal deaths, and those findings are being finalised, and we're considering our options and how to obviously reduce the risk of self-harm in our facilities or unnatural deaths in custody.
The Honourable John Dowd, AOKC, sent a letter on the 9th of December regarding in-cell online counselling. I understand that the Community Justice Coalition has repeatedly followed up in regards to that letter, but they're yet to have a response from you. Is there a reason why you haven't replied to that letter yet?
Look, I have to admit, I don't recall the specific details of that correspondence. I'm happy to defer to the Commissioner or his deputies about the contents of that correspondence and what exactly the CJC was actually requesting.
And I'm happy to sort of fill you in on that as well,
Okay,
Minister.
sure.
So essentially they were talking about the fact that, there's research that shows that counselling, and particularly in-cell counselling, can reduce the rate of recidivism by about 35%. And so they're calling for this service to ensure that there is this in-cell counselling available so we can actually protect victims going forward from domestic violence. And I know the Community Justice Coalition distributed a report that found like this online counselling could actually help protect an estimated 500 victims of domestic violence each year. I believe they're putting forward a very compelling case for online counselling. And it's very easy, obviously, when there's existing in-cell computers already capable of actually supporting those programs. Is this something that you are open to looking further into to make sure that these programs are available to protect victims of domestic violence?
Look, one, can I just say I have met with the CJC, and I'm sure I've met with Mr. John Dowd, and I do value the contributions that they make in obviously trying to make improvements to the system, but I think certainly any ideas that can improve the system, improve rehabilitation, reduce recidivism, of course the government would consider that, because it's
And so
no organisation has a monopoly on all the good ideas.
Thank you. In your letter, in one of your earlier letters to them, you had you talked about the technical issues being the concern as to why this program hasn't been made available. Is that something now you're seeking to overcome to make sure that this program is available?
Yeah. Look, I understand as an online program, there are some security issues that corrections need to manage. I said the intent of the CJC is honourable. I understand it has very good intentions.
I think we both agree there, but I'm just trying to understand if this is something that you as the Minister are dedicated to making sure that we actually overcome any of those technical difficulties. I understand their letter to you that wasn't responded to addresses those technical issues and how we can easily overcome them. Will you reply to their letter and really look into those technical issues and how we can overcome them?
Look, I understand.
I
understand, Chair, that the department is currently preparing a response to the CJC, but I do want to reiterate that an online forum does pose security risks for the system, and we do need to consider how we mitigate those issues.
And I think that's exactly what they've done in that letter that they're waiting for a response from. Yes. So I encourage you to have a look at that letter as well to work out how to overcome them. As of this month, I'm informed that over 50% of people in custody for domestic violence are currently on remand. Are there any preventative interventions being delivered during remand to actually reduce future harm to victims of domestic violence?
The short answer is yes, and I also have to make the point, Chair, that offenders, those in remand, are alleged offenders. They're actually different to sentenced inmates as well. So the programs that we have for sentenced inmates, the crimogenic programs, are not appropriate for those on remand because
are we providing counselling to those on remand?
Look, yes, my understanding is there are a number of programs that are focused on, in particular, the remand population around DV. I might ask...
And so does that, and as far as you're aware, and I'm happy to sort of talk later this afternoon. As far as you're aware, does that involve specifically counselling being available?
Yes, I can outline some of these programs, Chair, if you allow me.
Just any ones that are specific about counselling.
Yeah, look, I think there's a remand domestic violence, so we've got a remand addictions, we've got connect and seeking safety programs.
And they all provide counselling. Can you confirm that, Minister?
Look, I might ask Ms. Galoutsis to
that's all right. I might talk to you this afternoon.
Sure.
I won't get you up for the last few seconds.
But in short, there are programs for
with counselling,
with remand inmates to ensure that they can obviously change their behaviour. We're trying to change their behaviour in this particular instance.
Thank you. The Honourable Mark Latham.
Thanks, Chair. Minister, just to clarify, when you were told of the comfort that was given to Naveed Akram with the chaplain and the Quran, did you raise any objection to that?
Like I said, I was made aware after the fact that happened, but certainly when the allegations were made regarding the conversation was had, an investigation was conducted, which
But you raised no objection at the time?
At the time of?
Finding out that this had happened?
Well, I said, but I was concerned, obviously, about the allegations that were made, and the investigation has found that those allegations were not substantiated.
And have you read the investigator's report?
No, I've been provided advice on that.
Okay, and if I could run through the sequence, Kalani, the chaplain, met with Akram and gave him the Quran. Did that was that consistent with the category AA inmate guidelines about chaplain availability?
Look, I understand that's the case. Like I said, every inmate can request visitation rights, and those inmates who are obviously a high risk classification go through extra security vetting to ensure that those visitations are actually appropriate.
Well, wouldn't it have been reasonable for corrections to say, listen, mate, you've just been party to killing 15 innocent people at Bondi Beach, including a 10-year-old girl. You are one of the biggest bastards and most hated figures in the history of this state. You're not getting any comfort from anyone. You're on your own.
Well, I said inmates are entitled under the CAS Act, which I have to implement. They can access chaplaincy support services. Now,
but should he have? Should he have?
I said inmates are entitled, and those who are on the high risk classifications do go through extra security and vetting process. But I'd also make the point that this issue is also due. We're currently before the courts, and I just think we need to be circumspect about.
Well, you must be the only person in the state who thinks that way. But who made the decision to give him the access?
I said that these are operational matters. I might
ask the Commissioner who made the decision to give this guy the access.
I did. And
on what basis?
On basis that all inmates in New South Wales have a legal right to religious and spiritual support.
Did it worry you a copy of the Quran would verify the fact that he undertook this action in the name of ISIS with the jihad teachings of the Quran?
It would worry me if we weren't following the legal rights.
And can I ask then what happened, that Kalani on that same day had a discussion with other inmates as to what he'd said to Akram? That's the allegation that was made?
Well, they have access to civil chaplaincies.
No, I'm not asking that. I'm asking what happened after Kalani met with Akram. Kalani then went and spoke with other inmates about the nature of his visit?
It probably refers to your previous question when those allegations were made, and that as a result of those allegations that we undertook an independent investigation.
Right, and what was the specific allegation that was passed on to staff?
Well, I think Ms. Galoutsis had answered that.
Was it just that that Kalani had said that Akram's actions were consistent with the Quran and the call to jihad, or was it also that Akram's dead father had died a martyr?
I might ask Ms. Galoutsis to come forward just to talk around that investigation and those particular allegations.
I don't have the particulars of the allegation with me. I'd have to take that on notice in terms of the second part of your question, second part of the allegation.
You've got no recall of this very important matter?
I could get that before the end of this session, but I don't have it to hand.
We'll come back after lunch about it. The inmate that Kalani spoke to, was he Islamic?
I also don't have that information to hand. I don't believe he was. No.
And what was the status of the staff member or guard that was told about it by the inmate?
What was the status? What do you mean by that?
What level was he in the system?
Oh, I'd
Was
have
he
to
just
take that
an
on
ordinary
notice
prison
as well.
guard? Was he higher up in management?
I'd have to take that on notice.
You'd have to
as well.
take that on notice. And who was the independent investigator?
In terms of the person that we engaged, his name is Murray Chapman.
Murray Chapman.
Mhm.
And what are his credentials? And is that normal practice to bring someone in from outside rather than an internal investigation?
It is for matters relating to chaplains because they are not employees of corrective services. They are contractors, so they don't fall under our normal professional standards and investigation process, and we are able to engage an independent person to undertake that investigation.
Right, and what makes Murray Chapman independent and qualified?
I'd have to take that on notice as well. I don't have his CV with me, but he was...
And you mentioned earlier on he had a body cam for interviewing who? Kalani and the inmate. Is that right? And the staff member. Are they the three who were interviewed?
So the body-worn camera related to the conversation that the chaplain had with the inmate that you're referring to.
Who was wearing the body cam, sorry?
The staff member.
Right.
So when Chaplain Kalani visited inmate Akram, there was a staff member that was wearing a body-worn camera during
Mhm.
that interview, and that was reviewed as part of the investigation, that footage.
Right, and what was the exact finding of the investigation?
That the allegations could not be substantiated and that what was alleged to have been said could not be heard and could not be substantiated through the investigations or the
But
recording.
was it left open that it was possible or just ruled out entirely?
Ruled out entirely.
Ruled out entirely. And has there been a review of Kalani's standing as a chaplain in the system?
No.
No? The Minister said earlier on that these chaplains put through a heavy vetting process. Did the vetting of Kalani include the court evidence from Justice Rothman on the 11th of April 2023 in the sentencing of Hamid Al-Qazi to 15 years imprisonment for terrorist offences, where he rejected Kalani's evidence that, and I quote from my engagement with him, I've never seen him do anything or indicate support for any violent extremism, that Kalani was effectively dismissed by Justice Rothman as an unreliable witness in this particular matter.
What was the question?
Well, in the vetting of Kalani, was this court case and the view of Justice Rothman taken into account that he said someone wasn't extreme when the courts dismissed that. He had been engaged in violent extremism and the promotion of it through ISIS and received 15 years imprisonment.
I'd have to take that on notice. I'm not familiar with what you're referring
thank
to.
you.
Yeah.
Ms Boyd.
Thank you, Chair. Minister, on accessibility standards, I understand it's been over a year now since the Building Commission of New South Wales roundtable was held on the livable housing design standards for minimum accessibility. When I've previously asked you about this in estimates, you've told me that there's been reviews and things were happening. What has happened since that roundtable? What's the progress?
Look, the government obviously is considering looking at livable housing. We understand this is also a particular important issue for a number of people in our community with mobility challenges. The Building Commission continues to engage with the sector to ensure that any reforms or any changes that we make don't delay or prohibit the supply of quality housing to the New South Wales economy.
Okay, that's the same argument, though, that we've been having for the last, well, with you for the last 3 years, but before that I was having it with the previous government. And there has been plenty of evidence to show that actually providing new houses for people who, 20% of the population that need to be able to live in them, with these minimum accessibility standards, it's just not, it makes no sense, the idea that it would impact. So has that been resolved?
Look, there are varying views in terms of the cost implications and the impact on different builders of different levels. So you could appreciate, I know that the advocates obviously set a number of what the impact will be. The industry has a slightly different view.
Yeah.
But what the Commission the Building Commission has done is actually get its its own independent set of analysis and figures to determine the cost implications for the sector if livable housing were to proceed forward in a mandatory perspective. Now, that study or that analysis is about to be complete. Once that is complete, then we'll get all the stakeholders in to determine how best to proceed. So I'd also make the point too, Ms Boyd, that whatever the cost implications are for livable housing, we have to be also...
Sorry, cost to who?
The cost to the industry and the sector itself. And we have to be mindful that its impact is not equal across the sector. So a bigger builder or bigger developer with a much substantial cash flow or much more financial flexibility can absorb some of these cost implications, but for a smaller builder, it may actually, those implications could maybe actually impact on the feasibility of them being able to build quality housing for the people of New South Wales. So I'm mindful of those disproportionate implications.
Let me ask you the same question I asked the previous government. What is it that makes, given that New South Wales and Western Australia are the only states not to have adopted this very, very modest set of accessibility requirements for new builds, what is it that makes the New South Wales economy so fragile that it can't possibly do this without there being some massive cost on the property industry?
So look, one, I would say we are in the midst of one of the biggest housing challenges that the economy has seen for some time.
But that's not just in New South Wales.
But I think New South Wales is a much more acute market given its...
But also you recognise that people with mobility needs also need to buy houses.
Yeah, look, I acknowledge that, absolutely, that, building livability housing does obviously impact those with mobility challenges or older Australians.
We're talking about 20% of the population. And whenever we have these accessible housing discussions, we talk about affordable housing as though it doesn't include that 20% of the people. They need affordable houses too, but at the moment they don't have houses they can actually live in because there aren't these accessibility requirements being put in place for new builds. If your government is doing what it says it's doing by trying to put as much supply in as possible, why wouldn't that supply be accessible for people with mobility needs?
Well, I think that we're working through the issues around livability housing. The government is open to how it can best implement this particular aspect of the building sector. I also think that in a way it's always more productive and more efficient if we can find a ways through the reform process to incentivise and to create, I think, greater volunteering of the sector to move towards this. I think everybody knows that obviously livable housing is a good objective to proceed with.
Well, it's been a very long time, and New South Wales is very far behind everyone else.
Well, I think, as I recall also, the Building Commission might confirm is that our other states, whilst they've adopted, they've actually delayed their implementation. Is that right, Building Commissioner?
I'll come back to you in the afternoon, and we can have the same argument we had about that last time. But just in this last little time that I have, just back on the submarine basis. So given that you said that there's no further work has been done by your government in relation to the preferred location, then presumably the preferred location of Port Kembla as the New South Wales government's official position still stands.
No, I don't agree with that assessment. I said the decision for the East Coast base is a matter for the Commonwealth.
All of the planning decisions in the state that go around that are all designed around Port Kembla being the preferred location?
No, look, I don't think that...
We don't have a plan
I said the decision,
takes it into account.
No decision as far as I'm aware has been made regarding the East Coast base by the Commonwealth. Once that decision is made, I think we're all in a better position to determine how best to proceed in going forward.
Opposition? Thank you, Minister. Minister, do you have 100% confidence in the Governor of the Goulburn Correctional Centre?
Well, look, I think, of course, I have trust in all our hardworking officers across the correctional system.
And does that include Silverwater?
Well, I said, our officers work in a very volatile environment. I'm not going to, disparage people who are in the system who are working very hard to keep our community safe.
And so that would also include Long Bay then?
Well, I think, all officers obviously must conduct themselves in the most professional manner. I said I have total confidence in the operation of our system through the delegated powers to the Commissioner.
Thank you, Minister. And do you have 100% confidence in the GPS electronic monitoring system?
Well, look, our electronic monitoring system is one of the ways we keep our community safe.
Mm-hmm. And so when private electronic monitoring companies were banned last year, how many of those monitoring functions were transferred directly to corrective services?
So I think you're talking about the private contractual. As I recall, there was only a very small number of offenders on that private contract. And so I recall also those offenders would go before the judge to determine whether they would obviously come into custody or they'd be obviously on the bail monitoring.
Okay, so then because you now have the electronic monitoring, have you had to employ additional staff to absorb the functions no longer available through the private?
Look, corrections will always invest in the staff that's required to keep our community safe in any of its functions.
Mm-hmm. And did you have to have additional costs as well as extra staff?
Look, I'm advised in the particular cohort you're referring to, Ms McDonald, in terms of those bail offenders, they're actually not a part of corrections supervision. Is that correct, Commissioner?
Okay, all right, I'll move on then. Okay. How many electronic monitoring devices then are currently active in New South Wales for parolees and people on community corrections orders and ICOs, including, say, sex offenders and domestic violence offenders?
Look, Ms McDonald, I'm advised that for the 25-26 year, as of the 1st of Feb this year, we have on average a number of offenders that are on an EM or electronic monitor, about just over 1,300.
1,300 people? Yep. And do you know how many devices were replaced in that last financial year due to, say, malfunction or technical fault?
Look, I'll have to take that on advice. That's a very specific, finite number.
Okay. And I can give you one instance where at least one parolee has required 8 replacements due to faulty equipment in just the past 18 months. So if you've got 1,300 people, and that's just one, I'm sure there would be a lot more.
Well, look, I'd be concerned if our EMs weren't functioning.
Yep.
But, it's a very effective program. But I'd also say...
I agree, Minister.
Yeah.
When it malfunctions, what is the average time between, say, a device when it's detected to when it's being replaced?
Look, the first thing I would say is that EM is one of the functions of keeping our community safe. It also is in addition to and complements our supervisory and our contacts that our community corrections officers make to those on EMs.
Mm-hmm.
But in terms of the specific question, in terms of the timing, I might defer that to the Deputy Commissioner. He may actually have a really good answer for you.
Well, I might ask in the afternoon because I do have separate questions.
Sure, of course.
Because I kind of counted, and you kind of answered my next question about supervision measures applied in that interim period. Are police notified automatically when a high-risk offender's device becomes non-operational?
Look, when there's a contravention of the EM conditions, then corrections will notify the police immediately.
Yep, okay. And are you aware if device faults have increased, decreased or remained stable?
Well, look, I said I'd have to take that on notice, but I said if our devices, our EMs are not working, I'd be very concerned, and I would expect to be briefed appropriately by the Commissioner or his deputies.
And some of the devices, well, not devices, but they're set up to, say, monitor where people can go in, say, an LGA.
Yes.
So what percentage of alerts are false, caused by technical issues or faulty GPS mapping, such as, if someone... they might not actually be in the wrong
Yes.
LGA.
Yeah, look, firstly, if there are breaches of the EM conditions where an offender is, breaches a distance or close to where the victims may be, corrections immediately notifies the police to ensure that that particular offender obviously is contacted, and obviously appropriate management will take shortly. But in terms of your specific numerical question, I'm happy to defer to the
I've
Deputy
got
Commissioner.
some separate questions for this afternoon. Can you confirm whether GPS devices maintain accurate tracking when a person goes into buildings, maybe say such as a shopping centre, a large shopping centre?
Yeah, look, I think certainly our GPS tracking is obviously connected. I think, on the whole, I think it works very effectively. But when there are instances, I think very, very few instances of these happens, then of course there'll be other actions that community corrections can take to ensure that the offender is located appropriately.
So just say an offender was wearing a tracking device, and they enter a large shopping centre, and one of their conditions is that they can't go near a childcare centre or a creche. When they're in that shopping centre, and say there is a creche in that shopping centre, can the device easily locate them and sort of warn them, hey, you don't go to that level? Or
Yeah, look, in short, an offender that's on an EM has obviously restrictive geographical boundaries, but if you're talking about and that does include their proximity to places like where children are located, or where their victims are located, or in certain areas. But once there is a breach of those geographical boundaries, an alert will be made to our staff, who will immediately contact the police to ensure that that offender is managed appropriately.
So it kind of doesn't answer my other. Does the device, can it tell you which floor you're on?
Look, I mean, once a breach is made, if for example, if the geographical boundary limitations does include, that is, an offender can't go to a shopping centre, but once they cross that street, corrections will know straight away, even before they get to the shopping centre. So in that sense, it's the system does work, and I think it works quite effectively, and that, once a geographical boundary has been breached, then the police will be notified.
So is there testing done on these monitoring devices to test how accurate they are in high-density commercial precincts?
Look, I would expect that to be the case, yes. Commissioner, did you or the deputies want to confirm that?
Yeah, look, I can, before I call the Deputy Commissioner up, there is a dedicated working group that has been established to review the technology and the procedures, to explore alternatives, solutions, and enhance our tamper detection and develop strategies to mitigate any of those potential risks. But happy to explore after lunch in more detail around the operations and the questions that you may have in that area.
So, Minister, are you satisfied that the current technology provides sufficient protection for children and victims of domestic violence in indoor public spaces?
Yeah, look, our EM monitoring system is an effective way. Are we looking at always to improve the system? Absolutely we are. I mean, keeping our community safe is the top priority of this government.
Mm-hmm. And I'm not sure if you're aware, I used to work in community corrections, so I understand,
you know it well, then.
Say, measurable targets. So I was just wondering, in the current 12-month, or what is the current 12-month reoffending rate for people exiting custody?
You mean the recidivism rate? Look, I recall the number, but I don't want to give you an inaccurate one. If you bear with me, I might be able to find it, or would you prefer me to take that on notice?
You can take it on notice if you like. And I might... Well, if you... could you outline maybe a trend in the 12-month?
So look, I'll just get back to you, Ms. McDonald. Look, I understand that the recidivism rate is currently about 62.7% for those in custody. And I know, does that assist with
Yep,
your question?
it does.
Okay.
And would you say that's, say, the quarterly trend in, say, the reoffend or recidivism rate since 2023?
Look, I don't have the trend, but I understand that it has increased marginally.
It has increased. So you're saying it's higher than it was in, say, 2023?
Yes, I understand that to be the case, but I think in any statistical analysis you always got to look at trends and not necessarily be guided by a one-off statistical anomaly.
Mm-hmm. So what proportion of reoffending involves, say, property offences, violent offences and serious drug offences?
Look, I'd have to take that on notice. I don't have that breakdown, that metadata breakdown of reoffending.
And do you know what proportion of reoffending occurs within the first 90 days post-release?
Look, I'd have to take that on notice. I don't have that breakdown of that specific data.
And so what is the government's measurable target for reducing the 12-month reoffending rate?
Yeah, look, the government, I think it's in everybody's interest to reduce recidivism, and that's why we have a number of rehabilitation programs, obviously addressing things like literacy, employment skills, social skills, family connections. Investing in rehabilitation means a safer community and fewer victims in the future.
So, Minister, that's sort of ways, but what's your measurable target?
Yeah, look, we have a target, as I'm advised, that by 2030 we want to reduce reoffending by about 8%.
By 8%. And so you've made that public now, but is it publicly reported?
Yeah, look, I'm sure our reoffending or reducing reoffending targets are publicly available. It might even be in the CSNSW annual report. Is that correct, Commissioner?
I believe so.
Yep, okay. And is the performance against reoffending formally reviewed at, say, your cabinet or premier level?
Look, I think, these are policy statements that corrections continues to develop. Any change in legislative reform would also go through the normal cabinet process.
Mm-hmm. And you said before that reoffending has increased. So what corrective action has been implemented?
Yeah, look, I said, it is a complex area to try to reduce it. I think
Which is precisely why we need measurable targets.
Yeah. And that's why programs, I said, Miss McDonald, in particular, when those who are coming into custody around rehabilitation, I think, things like identification can help.
Yep.
We obviously have housing programs that are available for post-release. I think, community service workhouse employment rates, but I also would make the point at the recent report on government services, there has been an increase in the number of community service work hours for offenders post-release, and also the employment rates of offenders is also above the national, which I think are good signs, but there's certainly more work to do that we want to do on this space.
And do you have a published reduction strategy or delivery plan?
Look, I'm sure there is public information available about the programs that we run. I'm happy to defer to
I know I'm going to ask in the afternoon
of course.
session. I've got a whole list of questions. Sure. So and you've mentioned program and participation in programs. From a practitioner's perspective, as you said, participating in programs is critical for rehabilitation. How come the annual report does not seem to include that data?
Include what data is this?
The program participation data.
Well, I think programs, as I understand it, is actually voluntary, but we will encourage every individual in our country to get onto these programs, because I'd also say that an engaged inmate is a safer facility for all inmates and officers as well. And in addition to that, of course, to try to part of the rehabilitation to secure employment, to be engaged in the community and live obviously much more meaningful lives prior to their entry into the justice system.
Sorry, I didn't mean to interrupt.
So you
said you encourage participants. Do you have information on, say, the current program participation rates?
I'll have to take that on notice. I don't have that specific number with me.
And what percentage of, you probably take this one, of eligible inmates complete accredited behavioural programs prior to release?
Look, I'll have to take that on notice.
On
Ms.
notice? Okay. And when you're measuring the programs, are there programs that demonstrate significant reductions? You know, like once if people participate in them, you can see that impact.
Well, look, certainly every program goes through an evaluation, but I think if we go back to some very core fundamentals, are those who are less likely to reoffend post their release, are often in stable employment, have got the skills, have got literacy, have also got social and so they're the pretty core common factors that reduce the recidivism rate. So in corrections, we look at those programs that can actually obviously improve or make reductions in recidivism, and each program naturally always goes through an ongoing, because we want to make sure that we're always looking for the next big idea that can keep our community safe.
And do you know whether access has increased or decreased? Access to the programs, has it increased or decreased since 2023?
Well, I have to take that one on notice, but we encourage inmates to get involved in the programs because it's.
And do you know what the average waiting time would be? Say once someone is, say they're eligible for a program, to when they actually participate in the program?
Look, I have to take that on notice, or I can ask the Commissioner to provide you with much more accurate times.
Okay, and so this is about being in the community. What structured through care model operates during the first 90 days post-release?
Like I said, it depends on obviously the needs of the inmate.
Whether they're low to medium, high risk?
Yeah, look, I've seen we have a number of programs depending on the risk classification of the inmate that's done post-release. We also work with a number of not-for-profits and community organisations to ensure that some of the issues a particular inmate or post-release may be facing are much more acute. So, not all inmates may have, for example, access to houses. Some do. And
that was going to be my next question. Do you know what proportion of individuals who reoffend were homeless or unstable in their housing?
Look, I don't have that factor, but I do know it's obviously a contributing factor. These are obviously very detailed operational answers, but I do think our officers, our seniors, may be able to provide you with that advice.
So what we say over, there's about $2 billion invested annually in corrections. Yes. What measurable reduction in reoffending has been achieved?
Well, look, I said, corrections, of course, does not determine who comes into the system. That's a matter for the courts. And once inmates are within the system, we continually make sure that they are appropriately risk allocated and obviously risk managed. And in terms of the post-release, and of course, we all want to see a reduction in recidivism because it just means fewer victims and a safer community. And part of that is the programs that we run, whether it's skills programs. I've seen it myself in my visits to our facilities. I think there are some really good stories that corrections does with offenders to actually get them skilled up, get them qualifications, improve their literacy, improve their communication skills, because those core fundamentals will mean, I think, contribute to a lower recidivism rate.
So, Minister, if reoffending is rising and there's no measurable reduction target, how is community safety improving?
Well, look, I said that the government's done a number of significant reforms. I said that there is a target, as I mentioned to you, that by 2030 we want to reduce recidivism by 8%, and for our Indigenous population it's by 10%.
But how are you doing it?
Well, I said what we're doing. I said once an inmate comes into corrections, what we do is make sure there are rehabilitation programs available, and we'll continue to measure the effectiveness of those programs.
So can you point to a clear and measurable improvement in reoffending outcomes under your government?
Well, I said I can say that the ROGS report that I just mentioned,
not decreasing.
I think there's obviously higher than average rates in employment, which I think is a good thing. because an engaged individual is obviously is less likely to commit an offence. And I said the community service work hours are good indicators, but we would all agree that continual improvements can and should be made.
Thank you. Mr Latham, you've got 1 minute and 45 seconds.
Yes, thank you. To Ms Galusis, can I just clarify that the body cam was worn by Mr Chapman in conducting his interviews with the relevant parties? Is that right? It wasn't worn by the staff member?
No, it was worn by the staff member when Chaplain Kalani was meeting with inmate Akram.
Right, okay. Was it worn during the staff member's conversation with the inmate who subsequently spoke to Kalani?
No, it wasn't.
No. So what are we saying then? The body camera just didn't pick up enough volume from the conversation? I'm assuming this is a guard.
The body-worn camera footage was reviewed as part of the investigation, and that was part of the evidence that was used to determine that the allegations couldn't be substantiated.
Did it pick up enough volume from the conversation between Akram and Kalani?
It was reviewed by the investigator, so I assume that he had sufficient information.
Right, so you're assuming that the body cam was a recording of the conversation between Akram and Kalani?
Yes, that was part of the information that was reviewed, as well as interviews with the staff member who reported it and the relevant...
Right, and I'm assuming the staff member stuck to his story, didn't he?
Yes.
Okay, and did the inmate change his story?
The inmate, from memory, I'd have to take that on notice, but wasn't able to corroborate what he had told the staff member.
He backed down from his earlier statement of the staff member?
And I don't want to provide too much information just in relation to the privacy of that inmate as to why he couldn't corroborate that story.
Is there a suggestion he might have been threatened or under duress?
No, not at all.
Is it possible to provide a copy of the independent investigation of the committee?
I can take that on notice if we can do that.
Okay, thank you.
Thank you. Minister, I'll refer you to the recently launched pilot support program for women leaving prison. I understand that a significant amount of the funding for that program, 5.7 million over 3 years, has come from the Ian Shirley Norman Foundation.
Yes.
And I believe there's a partnership between Corrective Services and Embrace People and Place. I'm just wondering, given this program, it relies so heavily on non-profits and philanthropy, whether the government will commit ongoing funding so that this program doesn't sort of collapse after 3 years.
Look, can I just commend the Ian Shirley Norman Foundation? I was up there it's in
Minister,
Port Stephens.
I've only got a minute.
Yeah, okay.
Can we just talk about the funding and whether the government will commit to that funding?
Well, I said, obviously, once the program is evaluated in 3 years' time, the government will make considerations.
Would you consider doing that review earlier? I mean, obviously, with just 3 years, it limits the ability for women to be accepted into the program as it progresses. And then, a lot of the program is also about follow-up care. That would collapse for women who are already in the program if we wait until the program's completed after 3 years. Would you look to reviewing the program, check its success earlier than that so that there can be funding
I think
arrangements?
it's a 3 year program. We obviously would be monitoring the program ongoing on a yearly basis. And if there are significant signs of success, yes, we would, of course, continue to consider whether additional resources should be made available, because it does reduce recidivism and keeps our community safe.
So is the intention to roll out the program for women across New South Wales if this is successful?
Yeah, look, if the program is successful, which I sincerely hope it does, I think we would want to consider how we could roll this out across the state.
Thank you. The opposition.
Thank you, Chair. Minister, the Tech Central strategy states in Outcome 1, Build Sustainable Leadership, that a dedicated delivery group is needed, and then attributes ownership to the majority of the strategy's outcomes to Tech Central governance. Could you please explain to me what is Tech Central governance?
Yeah, look, firstly, Ms Moran, can I just go back to your previous question about the pricing? I'm advised that pricing is actually publicly available. In terms of the pricing at Tech Central. And I also understand that...
where is that?
What's that? Look, this pricing is available on the HUN website, and on top of that, Fishburners also is providing on their website on the pricing of those desks as well. So just wanted to close that particular loop.
I would appreciate perhaps on notice the actual links to those. Thank you. But yes, just to Tech Central strategy, what is Tech Central governance?
So the Tech Central governance structure is a work in a collaboration between Investment New South Wales and also players within Tech Central, which includes our university sector, includes representatives of the Tech Council of Australia and industry players.
Mm-hmm. So it's a formal body?
Yeah, it'll be a formal body that
It will be a formal body?
Well, it's a formal body that we're trying to create with representatives to ensure that the implementation of the actual...
Right, so does it exist at the moment?
Well, we are at the latter stages of trying to formalise. Can I also maybe just refer you to our document on page 15? I think that may also provide you with a bit more information as well.
Yeah, I don't think it does, but okay, I'm just trying to ascertain whether that exists or not, but it doesn't seem like it does exist.
Well, I said we are at the final stages in agreement with our industry partners to create the governance structure to ensure that the implementation...
So when will that be announced?
Well, look, I think we're at the latter stages, and I might ask the Deputy Secretary if she's got more accurate time.
Do you have deadlines that you've asked your department to abide by when it comes to delivering projects?
Look, I think
do you ask your department for dates?
Well, look, I think we're delivering projects and reform on an ongoing basis.
I know that, but I'm asking if you're actually, if you have dates in mind for the delivery of anything in your portfolios.
Well, I think it depends on the actual particular project.
But you haven't given me any date, not even indications of months, not even a quarter, even a half.
Well, it depends on what program we're actually looking at.
Well, I've asked you about specific programs and you haven't been able to give me any details. So I'm asking if you actually have any dates in mind when you consider these projects and whether you think it's acceptable that either there are no dates or that you just think we shouldn't know and the public shouldn't know what those dates are.
Look, I think, the department and myself obviously driving significant reform in this sector. And, I encourage you to look out forward to our announcements. I mean, today we released the recipients of the MVP program, which is a great program.
That is so far beyond the questions that I've been asking. Could I just ask on the submarines? You said that you had done no work in relation to submarines. Have you done any analysis or have you asked your department to conduct any research on the benefits of a submarine base in Port Kembla in New South Wales?
Well, one, the decision has not been made regarding the East Coast location.
That
I think
wasn't my question.
any work is done at boxing at shadow. So once that decision is made, we'll all be in a better position.
So you haven't done any analysis on whether that should be a part of your government strategy to bring in investment and jobs into Port Kembla?
Earlier point of order that the member can't both ask questions and then answer them. Right?
I'm not answering the question.
Order, thank you. Look, I think the member has placed her last question, and the minister has a chance now to respond to that.
Yeah, look, Ms. Murray, I have nothing further than what I've stated to Ms. Boyd and yourself on this issue.
Thank you.
We now go to government time. Are there any government questions?
No, there are no questions.
Thank you. Well, that brings us to the end of our time this morning. Thank you. Order. So, Minister, that concludes our questioning of you. So thank you again for your attendance this morning. The rest of us will break for lunch and we will return at 2 p.m. Thank you.
Thank you very much, colleagues.
so it's a good discipline to sign up for 3.
Thank you, and welcome back to budget estimates for the afternoon session, and thank you all for returning this afternoon. I will throw straight away to our crossbench members. I'm not sure if Mr. Latham's ready. If he's not, I can throw... Yep.
No,
okay.
always ready, Chair. Don't worry about that. Always ready. Thank you, Chair, and thank you to the officials here this afternoon. Could I please ask Corrective Services, is Naveed Akram still receiving visits from chaplains, and is it Kalani? And how often is that occurring?
Just in relation to receiving visits, I can confirm that he has not received any visits from the chaplain at the moment, or the chaplains at the moment, but he's entitled to, as I referred to before, to receive visits from the chaplain.
So the status is that he asked for a visit after the 14th of December, and there was the one visit from Kalani, and then that's been it. This accused terrorist hasn't asked for any more visits.
To my knowledge, there's been no more requests to date today.
Right, and we saw some controversy about family members who are they now banned from visiting him? That's in the media today. What's the basis of that ban, and what was the intelligence you had that led to it?
Firstly, I just want to acknowledge the good work of my staff. That's the first thing I'd like to put on record. That was part of our routine searches that we do right across the state at all of the correctional centres when we have visitors coming into a correctional facility. We search the visitors, we search the vehicles, and as a result of searching the family members of that vehicle, there was some contraband that were found and some items of concern. As a consequence of that, the visit was not approved to proceed.
Okay, what sort of family members? Immediate family?
Immediate family.
Immediate family. And what's the nature of the contraband that caused the concern?
The nature of the contraband was a small knife and some literature in the vehicle, but and the matter was referred to the police.
Extremist Islamic literature, is that what you're saying?
It was reported as that, but not confirmed as that, or not accepted by the New South Wales Police that was the case.
Right.
There were some drawings and there were some writings, and police attended the centre, and they were allowed to go. There was nothing further.
And what was their intention, to get the knife in to the
I have
prison?
no idea.
No, but they found the knife and that was enough.
They found the knife that was in the vehicle.
Right. What can I ask? What sort of knife? Ranging from a butter knife to a machete. Where was it?
No, I explained earlier that it was a small table.
Small table.
Yeah, like a table knife.
And could I ask, is it possible for the committee to receive the guidelines about chaplain visits? Because I read something, I don't know if I hope it's right, about AA extra security prisoners don't necessarily have an automatic right to a chaplain's visit. Are there firm guidelines that we can access and understand the situation with regard to Naveed Akram, please?
I thought I explained that earlier, Mr. Latham, that they have a legal right to access.
Okay, well, if everyone's got a legal right, why have you got guidelines about their rights?
There are.
Can we get a copy of those, please?
I'll take that on notice.
Okay. And what exactly did, in the allegation, what was it said that Kalami told the inmate exactly? Was it the two things I mentioned earlier, that Akram was given comfort, he'd acted consistent with the jihad teachings of the Quran, and that his father had died as a martyr, or was there more than that in the allegation that was investigated by Murray Chapman?
Yeah, I thought that has been answered, Chair, in relation to...
Well, I'm just seeking clarity. There was a bit of confusion about body cam and all that. I'm just wondering, is there confusion as to what was the nature of the allegation that prompted the investigation?
And what's the confusion and what's the question in relation
the question
to the body
is,
cam?
in what the inmate initially told the staff that was passed along and provoked the Murray Chapman investigation, what is it that Kalami has exactly told Akram in that visit after the 14th of December?
I might ask DC Galouris to come forward just to talk in relation to the investigation and what we can say on that.
What's the allegation exactly that prompted the investigation?
I think you asked that in the previous session, and I said I would take that on notice and provide a response.
You'll come back, okay.
And I'll come back to you.
You weren't able to find it over the lunch break?
No, sorry, but it will come back.
We're going to have lunch. And further, has Akram been making other requests for visits by people other than his legal advisors?
I don't think it's appropriate for me to speak about individual requests from any inmate.
Why is that?
And when there is a request for visitors, I know you have an interest in Akram in particular, but when there is, what I can say is when there is a request for a visit, there's an assessment process that's followed in relation to that to see whether or not they're an approved visitor, and then the processes in relation to the management of that visit.
Right. Well, we know his immediate family members were turned away yesterday. Had they been in there earlier to see him?
No.
No, this was their first attempt and they failed.
That's right.
Okay. Has he had any friends or associates? You know, the interest in him in large part, because he was part of this Darwood radical centre at Bankstown and radicalised by Hassan, the preacher there. Have there been any other clerics, preachers that have been in to see him other than official chaplains of the corrective services?
No.
No. Okay. Okay, well that concludes my questions along those lines. Thank you, Chair, and thank you to the Commissioner and his staff.
Thank you. The Honourable Rod Roberts.
Yeah, thanks, Chair. Good afternoon. My question's also related to corrective services. I've got concerns about the increasing numbers of inmates at the moment. How do you propose to deal with that?
As what we do, we're very well experienced in this field. The inmate population fluctuates over time, and we've got plenty of cells available to us to. I agree with your, concern around the increase. We've had a significant increase since the 23rd of December, but we're able to manage that within our existing stock.
You do that through surge bedding and that, don't you?
That's right.
But you don't have any... Where do you get the staff from? So you've got increased numbers, you're doing surge bedding to accommodate them.
Yep.
Where are you getting the staff from to supervise it?
Yeah, we have the staff. The staff allocation is always appropriate to the size of the facility, and that if we have to bring additional staff on or additional shifts on for a particular operation, we do that accordingly, depending on wherever the demand is.
And where do you get those additional staff from?
From the existing staff that we have. We have also casual staff that are available on the roster, and we call people in if we need to meet the...
So they're doing overtime in that,
yes,
basically?
Yes, yeah.
To meet the increased demand. What about, do you have planned for increased permanent numbers?
At the moment, we've got, if we exceed our state population, then we actually do that through the demand funding to get additional staff to meet that requirement.
Are you doing that at present?
Yes.
Well, while we're on that and the amount of prisoners, we've seen what's happened at the Cumberland Hospital recently, which is not under the control of corrective services. I want to make that perfectly clear, so there's no accusations or allegations there. But clearly that's a basket case, that particular premises at the moment. I believe, or I have concerns that there may be an increase in transfers out of Cumberland into more secure premises that you are responsible for. And if that's the case, what strategies do you have for managing prisoners with complex mental health issues?
We manage all types, and we don't control the demand or who comes into our facilities. But we've got very qualified staff that can manage all types, and we can appropriately manage any person that may have mental health issues or any other issue of concern. We do that through our risk assessments and our assessments as they're inducted into our reception.
Well, certainly, but as you've already said to us, there's a limited number of prison officers at the moment.
Yep.
You're seeking more, but you have a limited number.
Yep.
If we increase the amount of prisoners with complex issues, where are you going to get the additional people from that are trained to look after them if we have an increase in those?
Yeah.
They can only do so much.
Well, there's a multidisciplinary team that sits as part of the assessment process when people are brought into custody, and we can draw across many of our areas to make sure they've got sufficient staff, including Justice Health are a part of that, the psychologists and prison officers and commissioned officers. So we have sufficient staff to draw upon for the reception processes.
I note there's 20 seconds left, Chair.
If you've got more, I'm happy.
Oh, well, I do. I've only got a couple more.
Continue, and then once it's
Lovely.
I'll
All
allow
right,
you
thanks.
to continue.
Look, I'm aware that you're in a dispute at the ARC at the moment.
Yep.
Is that right? In relation to dealing with inmates that have that are at risk of self-harm. What's happening in relation to that? Should inmates that are at a higher risk of self-harm receive additional support and services provided by you and your organisation? What are we up to there?
I'll refer this matter on to Deputy Taylor because he's oversighting in relation to the matter that's before arbitration in the court at the moment on that matter.
Yeah, Mr. Roberts, that matter is before the IRC. We had the arbitration last week, and the Commissioner is yet to decide on that. So I certainly don't want to interfere in that process, but I will say the nature of that dispute, as you mentioned, does relate to the management of people at risk. We manage people at risk following a particular approach all across the state. The centre that we're in dispute in has a different management practice that has emerged at that centre. We're seeking to introduce into that centre the same tried and tested practice that exists at 33 other correctional centres across the state. That is the nature of that dispute, but it's sub judice, so I just prefer to leave the comments there.
Sub judice? Is it a closed court? It's not a closed court down there, is it?
The Commissioners reserve their decision, considering our submissions.
Well, why then is this one prison, this one facility, an outlier from the other, what was it, 33, I think you said?
Yeah, well, it's 34 correctional centres. Yeah, that's the nature of the dispute, Mr. Roberts.
Yeah, but why? Technology. You guys control these prisons.
Yeah.
Why is it different than the rest that you have?
Yeah, that's the nature of the dispute. There's a different practice in there about what we have technology across the state that manages inmates in cells using closed circuit, television.
Yeah.
And there's a different practice in the centre that's nature of the dispute.
Why? You're in charge of it. Why is one different than the other 32?
That's the nature of the dispute. Yeah.
Yeah, but no. I know what the nature of the dispute is. You've told us that,
yeah,
right?
There's
One's
a practice,
an outlier to the other 32.
Yeah.
You two gentlemen are in charge of the corrective services of New South Wales.
Yeah.
Why is one different than the other?
Probably we can answer that by the difference in the dispute is that we're seeking to enhance technology within our facilities, and there's a better way of managing those risk inmates in an efficient manner, safely, through the use of technology. The dispute itself centres around the introduction of the technology, and we are managing it. That's why we're in dispute, because we weren't able to get resolution at the local level, and when it gets escalated it ends up in the IRC. So it's really centred around enhanced and better use of technology to make our environment safer for all of the people in our care.
Yeah, good, and congratulations to you for that. But you've got that in 32 other complexes. Why was this one so different?
Well, I think
it's your technology. You've rolled it out across the board to 32 centres. What, you neglected the 33rd one or what?
No, it's around the time. I mean, you've got old aged infrastructure and you have facilities that get prioritised, and we actually do that in a planned way. It's just that's where it's fallen in the list. So whether it was 33 or number 10, it doesn't make any difference. It would have been the dispute. Would not have mattered.
Righto. Well, I've got one last one, Chair, if that's all right. Go for it. The BOSCAR figures for 2024 I'm relying on. 49.3% of adult offenders released from sentence custody reoffended within 12 months. 4,750 of them. The programs that you run, are they independently evaluated to determine whether they're effective, especially with persistent offenders?
Yeah, certainly. And I'll ask Deputy Commissioner to come forward, but in short, yes.
Thank you, Commissioner. Yes, as the Commissioner said, we run a range of programs, from intensive programs to moderate programs to more lifestyle-based programs, and we do undertake to evaluate those periodically. Over recent years, the Bureau of Crime Statistics and Research has evaluated a number of them, particularly all of our intensive programs. They have independently evaluated. We have an internal research and evaluation team, and they also undertake evaluations of our programs, all of which are published on our internet, available for the public.
I know, that's how come I've got the figures of 49.3. This is, you're not telling me anything. Do you have them independently done by anybody other than your own internal stuff and Bosca? Do you have it done anybody else?
So we've had evaluations by different universities. So the Matilda Centre at the University of Sydney has evaluated our suite of EQUIPS programs. We have over the years had universities evaluate other programs. So we do engage independent universities and experts to evaluate our programs, as well as Boxar and our internal team.
Okay then, well, you said Boxar looks at and has done independent evaluation. What have they told you about the success or otherwise of your programs?
If I had to summarise what they've told us, it is that our intensive programs are largely effective at reducing general reoffending, not always as effective at reducing specific reoffending, for example, sexual reoffending or violent reoffending. So what we are working to understand is what is it specific to that type of offending that we need to do different in the programs to try and bring down those rates of reoffending. But overall, they have found that it has an effect on general reoffending, which is positive.
So the ones that aren't general reoffending, the more specific types, you acknowledge there's an issue there, and we're working on trying to improve that?
Yeah, always looking to improve. So along with outcome evaluations, we also undertake process evaluations, so we can understand the fidelity with which we're delivering the programs, any elements of the program that are more effective than other elements, how we can improve. And over time, we're always reviewing and accrediting our programs to improve them and make them more effective. I think the other thing to recognise is that programs on their own can't do all the heavy lifting in terms of reducing reoffending. The drivers and the causes of reoffending are complex and multifaceted, and it's the whole service delivery that has to work in unison for us to be able to effectively reduce reoffending. So the other things we're looking at is the climate in which our programs are delivered, if we can work with staff in the broader prison to work more rehabilitatively with people in those programs, so that we're constantly reinforcing the skills that people are learning in those programs. And then the other factor is when people are released from custody, the conditions to which they're released. So whether they're released to stable accommodation, if they're able to get employment. So we also have to make sure we're working to supplement what they're doing in those intensive programs with all of those other social drivers of crime.
That's it for the moment. Thanks, Jeff.
Thank you. I've got a follow-up question around the pilot program to support vulnerable women leaving prison. I'm not sure if somebody can answer that. It's essentially about the program's capacity for assisting individuals, and thank you. If I can find out how many women can actually receive support through that program each year.
So the program, which commenced late last year, the Minister was at the opening of the facility which will be run, is in a start-up phase. So part of the way in which the pilot works is for the employees of Embrace to actually meet with potential candidates whilst they're still in custody for a period of up to 6 months, to work through some preparatory stages to assess their interest and willingness to provide information and so forth. So that process is just at the very beginning phase. The facility itself has a capacity of around 40 beds. The intention is to work through an appropriate cohort, build up the actual program that's going to be delivered in a sustainable way. So the idea is to have something between sort of 10 and 15 residents for the first period.
And what's the length of that period, sorry?
So it will depend on a couple of circumstances. So one is that the program is targeting people, women being released on parole. We know that the likely participants will actually have fairly short parole periods. The intention of the program is not necessarily to move those women on just because their sentence is finished, but it does change the dynamic in the way in which the program is delivered. The intention of Embrace, if I'm speaking for them, is to have a continuity of care. So again, the program is intending to work with the residents whilst they're at the facility up on the Central Coast, but then move towards building connections in terms of long-standing
And that's sort of a
accommodation.
2-year process, is that right, roughly? Or?
Yeah, roughly. But as I said, the principle is around through care. So they're really looking to build sort of permanent linkage to accommodation and employment. And again, it's at a very early stage, so we'll be learning as we go. And I think earlier the issue was raised about evaluation of the program, and so that's going to be built in as it unrolls.
Great, thank you. Opposition.
Thank you, Chair. This is for the Fair Trading Commissioner, I believe. It's about the statutory review of the Gas and Electricity Consumer Safety Act 2017. So the statutory review into the Act reported in 2023, but it doesn't seem like there's any action that has been made public. And I'm wondering if there is any information about an intention to expand the definition of gas to include hydrogen.
It's quite specific, Ms Munro. I might have to take that on notice.
Okay. If possible, it would be great to get that before the end of the day, just to have some more information and have a conversation about that if need be. Thank you. And obviously, if there's any information about why or why not, according to the response that you get, that would be helpful. Thank you. I also had a question about the Public Forums Incorporated, which was publicly reported earlier this week or last week, 2 weeks ago, about the Hizbut Tahrir organisation, and I understand that there is an investigation going on into that. What would an outcome, what kind of outcome would that investigation require for the incorporated entity to be disbanded?
There is an investigation into that particular incorporated association, particularly in relation to the allegations that the association's links and the public officer's links. Mm-hmm. One of the possible outcomes, if I'm satisfied it's in the public interest, is for the incorporated association to be deregistered. And as you would know, people seek to have incorporated association status to limit their liability, to allow them to enter into contracts and buy and hold land. So there are implications flowing from a deregistration.
So when you conduct an investigation, and it doesn't have to be specific to this particular matter, but what is the threshold that an organisation has to meet before they're considered undesirable in terms of their holding of an incorporated classification?
So the test is cancellation can happen or deregistration can happen if it's in the public, if I form the view that it's in the public interest for it to happen. Mm-hmm. And so obviously we would need to apply the facts of each individual case against that threshold of public interest test mm-hmm. to determine the outcome.
Okay. So to determine that outcome, will you make the findings that give you whatever determination you make public?
Will I make the
will you make the findings of the investigation public, no matter which way you determine?
I'm not required to do that under the legislation, and given the sensitive nature of this matter, I'm unlikely to do that, but we will certainly be advising publicly whether the incorporated association is deregistered or not.
Okay. And is there a timeline on when that investigation will conclude?
It isn't under active consideration at the moment. Mm-hmm. I don't have a timeline for conclusion, but look, I would expect it to be, it's a couple of months proposition.
Oh, really? A couple of months?
Yeah.
Okay. I mean, it seems like a pretty cut and dry case to me. It's a terrorist-linked organisation. So what do investigations typically require?
So look, there are some complexities with this one that I really don't want to compromise the investigation to go into, but I can assure you that we are considering it, and we're getting legal advice on it, and we will process it in a timely manner.
So how does this organisation operate now that it's under investigation? Is it able to still operate as a normal incorporated association, or does it have any restrictions placed upon it?
Well, it hasn't been deregistered, and so the matter is under active review. So there's no change to its status currently.
So they can operate as they have been doing for as long as the investigation goes for?
Well, they haven't been deregistered yet, so yes.
So yes, okay. And has this caused you to investigate other organisations or conduct searches into the public offices and the background of public offices associated with other organisations, incorporated associations?
There is one other organisation in particular that is also the subject of review by Fair Trading.
Okay, and what is that organisation?
That organisation is Al Medina Dawa.
Okay. Are those investigations happening in tandem?
They are.
Okay. Okay, thank you.
The gas and electrical safety
Oh, yes.
is actually probably more with Building Commission.
Okay, thank you.
And we are discussing whether hydrogen will be a gas, and we'll be putting that to the government for their determination shortly.
Okay, and do you have any information about what is the proposal?
I don't have any further information at the moment.
Okay. Have you been engaging with particular stakeholders on that matter?
I believe the team has been engaging with stakeholders on it.
Okay. Do you have a timeline on when that advice will be provided to government?
See if I can get you one.
Okay, thank you. I had a question about the Moree Bail facility, which was raised, I believe, at the last budget estimates by my colleague Damien Tudor-Hope, relating to the overall cost. Is there an overall cost for CapEx on the Moree Bail facility?
Yes. If I may, Ms Munro, I'm happy to take that on notice, but can I make the point that it actually is not an adult facility, it's a youth justice facility.
Okay.
And was the subject of questions the other day and responses at Minister Dibbs' estimates.
Right, okay.
Off the top of my head, I can't recall a figure. I was up there 3 weeks ago visiting the facility. Happy to take that on notice.
Okay, that would be helpful. Thank you.
Or I may refer you to the response given to Minister Dibb.
Understand.
Thank
you. Would you like to continue? Up to you.
Okay. I'll go to, I was questioning electronic monitoring, so I'll go to that. Thank you. So when I asked the Minister about devices, and he mentioned that there were approximately 1,300 offenders and parolees in the community that were subject to electronic monitoring. Do you know how many devices were replaced in the last financial year due to malfunction or technical fault?
Yes, I can answer that. So in the last financial year, with one smart qualification, there were 1,020 component replacements. So in some of those instances, it wasn't required for the entire device to be replaced. What would usually happen is we'd swap a device, take away the one that had a fault, and replace that faulty component.
Yep.
Some of the reasons for the replacement include damage, general wear and tear to some of those different elements. So typically the damage or the parts that need replacing were the physical components, so where straps and pins are attached, rather than any sort of more technical malfunction component.
And as I mentioned before, the there was one instance where one parolee has required 8 replacements due to faulty equipment in just say the past 18 months. Do you have any sort of comment, or are you aware of?
So I'm not aware of that specific instance. The information I've got available is that we don't actually record data in relation to specific individuals. As I've said before, there are different components that can require replacement. Again, they're generally, if we want to sort of distinguish parts that need replacement versus malfunction, that tend to be more around parts that need replacement. What we sometimes see is that the ability of the person wearing the device to comply with the requirements is not necessarily consistent with our... So, for example, if there are repeated instances of the device not being correctly charged, we will go and replace the equipment to make sure it's not a fault. So in some of those instances where there are offenders who've had to have several devices, it's generally on checking the equipment. The equipment itself hasn't been faulty.
Yep.
It's more to do with the way in which the equipment is being used.
Yeah. And say that there is, in the circumstances of that it is a faulty device that's being detected, what's the average length of time from when it's detected to when a new device or replacement device is fitted?
Yeah. Again, I'm not going to talk about an average time because, as you'd be aware, there are different categories of people that are wearing these devices. Some of those are in the more high-risk category, and some of those are in a sort of lower-risk category, so people on the works release, where there are other measures that can be put in place. In the higher-risk category, the replacement is virtually immediate. And in addition to that, we take other measures to ensure that the community is safe whilst that particular piece of equipment might not be functioning. But generally, it's a function of their location and the risk rating as to how long it will take to replace their equipment. But it's a very short period of time.
Yeah, okay. And to your knowledge, have the rate of, say, device faults increased, decreased, or remained stable since?
It's decreased in the last 12 months.
Decreased?
Decreased.
Okay, that's good. And are you aware of, say, what percentage of alerts are, say, false positives caused by technical issues or faulty GPS mapping, such as an incorrect LGA sending up a red flag?
I'd have to take that on notice and just clarifying because there are different types of alerts that the system receives. Some relate to, as you say, sort of potential malfunctions. Some relate to movements by offenders into zones that they're not required to. So we can break down some of the different alerts, the statistics around different alerts, but I'll have to take that on notice in terms of the detail.
And I think I asked the Minister and I wasn't sure on the answer with regard to GPS devices maintaining accurate tracking inside buildings, say, such as a Westfield shopping centre.
Yep.
Are you able to clarify or provide more information?
I can provide some information. I would again note that there is some reluctance to discuss the technical limitations of this equipment for obvious security reasons. There are some limitations around continuity of GPS signal, as anyone who uses a phone would know. But we have multiple additional safeguards that address those circumstances.
Okay. And say, like if a person with a monitoring device enters a shopping centre, are they easily locatable? Like if they had to ring, say, the person who's supervising them to say they're in a shopping centre, they're on whatever level, there's a creche on that level, they shouldn't be on that level?
Again, I'm not willing to discuss in too much detail how accurate the signal is, but again, there are alternative safeguards if, for example, signal is lost in what circumstance.
Yep.
And again, the protocols that are in place relate to the nature of the person that's being monitored.
Okay.
So again, in higher risk scenarios, there are a range of emergency protocols that would swing in if signal's lost for any period of time. But again, as you're obviously aware, there's a whole range of work that's done prior to approving someone being in a facility or a shopping centre where there might be access to the types of things that they're not supposed to have access to.
And I would also ask the Minister about the accuracy, or do you conduct testing on the accuracy in, say, high-density commercial precincts?
Yes. So again, what we do, depending on the nature of the person who'll be wearing the device, the type of order, there is testing done on the types of locations that they will be in usually, so particularly around their own accommodation or place of work. And again, there are measures that are put in place to mitigate the risk of offenders going into areas where we know there are issues with signal. So yeah, all that is done.
So would that sometimes mean that you would have, say, members of community corrections also, like if say someone is on electronic monitoring, but they also have a schedule, so you know they're going to be somewhere, you might have people there as well?
Again, without wanting to disclose too many details about, if you like, our enforcement of compliance, there is capability for both overt and covert surveillance of people on electronic monitoring. Again, I'm not necessarily saying it's community corrections staff that do that, but we work very closely with police in particular.
Okay. But you're comfortable that you could accurately pinpoint where someone is with all the, say, covert?
I would say that the way in which we use electronic monitoring in conjunction with other forms of supervision, with the information that we have available, our understanding of the people that we're working with, our collaboration with other partners, we can be confident that we are managing risk as much as can be. Noting that some of the limitations of electronic monitoring is we know what the offender is doing, but we don't know what everyone else is doing around them. Confident that we can manage the risk. I'm not going to say that we can pinpoint where they are.
I'm going to throw to my colleague who's online, the Honourable Nicole Overall.
Thank you very much. Thank you, Chair. If I could go to the Fair Trading Commissioner, please, read the acting of the Loose Fill Asbestos Program and register. Was the Minister briefed that there's a risk that impacted owners will register before the program closes, with that potentially posing a financial and administrative burden on the government?
Sorry, can you repeat the question?
Was the Minister briefed that there's a risk that impacted owners will register before the program closes, posing potentially a financial and administrative burden on the government? Was he briefed about such a thing?
No, not that I'm aware of, no.
That you're not aware of?
So I should say that I wasn't directly briefing the Minister on this particular matter, but the Minister was briefed on the closure of the program, and he was given all the facts, the risks and the mitigation strategies.
So he could have been provided that information then?
So as I said, I wasn't personally the one briefing him. It was a member of my team, and he was given the facts around the program closure and the risks and the mitigation strategies.
So have you yourself or anyone in your department been provided with such advice or information about the risk of impacted owners potentially registering before the program closes and what that might involve?
Well, as I said, we haven't had an impacted homeowner register with us now for over 2 years.
That's not the question. The question is, have you or anyone in your department been provided with information or advice that suggests that there is a risk that impacted owners could register before the close of the program, and that poses a financial and administrative burden potentially on the government? That's the question.
So I can't answer for anyone in my department, but I can tell you that certainly whenever we look to close any sort of program, we look at the likelihood of other claimants coming forward, we look at history and patterns, and then we put in place mitigation strategies, and we've done exactly that in relation to this program.
So you're suggesting there that you could have received such advice?
So I have not so I'm not sure what, I'm a little bit confused. Are you asking me whether I've received advice around the potential for more people to come forward before the program closes?
Yes.
Is that so? And I think my answer to that question is, of course, we would always consider when looking to close any program that other people may come forward, and we have a pathway if that would occur. But as I have said, we haven't received any new applicants now since 2024.
Point of time, but the public also isn't aware of the closure of the program. So on that basis, what's the date proposed for the closure of the program?
So the closure date is a matter for the government.
Is there a closure date for the program?
As I've said, that the closure date is a matter for the government.
Are you
Thank
aware
you. Sorry,
of
Ms Overall. Sorry, the
date?
bell has gone. I know you can't probably hear it online, but the bell
I
has
can't.
rung. Thank
Sorry,
you.
Chair.
No, that's okay. That's totally fine. Thank you. I've just got some questions to follow up in regards to isolation practices, and I know that the Minister talked a little bit about this morning, and he said that solitary confinement is not allowed, but obviously confining an inmate to a cell would be in some circumstances considered a form of solitary confinement. I'm just wondering if you could talk me through that in a little bit more detail.
Okay, just before, Chair, I hand over to Deputy Taylor. An inmate will only be placed on a segregated custody order, where there's no other reasonable way to manage that individual.
So it's never done as a form of punishment?
No, it's separated in it, and the segregation orders are designed around, the safety and the security and the risk that that person is posing to the correctional centre. And those segregation orders are only for a short period of time, generally speaking, but it depends on the individual circumstances and what risks that they actually pose, either to their own personal safety or safety of other persons or the correctional centre in itself. But I'll hand over to Mr Taylor for some more information around that.
Thank you.
Chair, so you're correct. Under the CAS regulation, solitary confinement is a prohibited punishment in New South Wales, but to the Commissioner's point, there are two reasons why inmates may be separated, and one is a segregated custody order, and that is for the safety of other persons or also for the good order and discipline of correctional centre. And under the Act, there are defined periods that can occur, and also a whole regime of review of those orders, including to the Serious Offender Review Council, and for extended periods of separation, the Minister is notified.
And what's the definition of an extended period?
So a period that is more than 14 days is reviewed external from the correctional centre by someone in my team, and then beyond that period, it's reviewed every 3 months again, and when it exceeds 6 months under Section 18 of the CAS Act, a notice goes to the Minister. But I would like to point out that the important thing for these separation orders for segregated custody and also for protected custody is that whilst the inmates are isolated from other inmates, there's no reduction of diet. They're not deprived of any other rights or privileges that are incidental to the order, so they continue to have all available access that they need to legal, to chaplains, to support staff, particularly our Aboriginal inmates, and to our Aboriginal programs officers, access to phone calls, access to visits. So all those things that are otherwise available in custody that are not affected by the order, under law, we continue to provide. The only time when an inmate is confined to cell is can be as an outcome of an inmate discipline action, which I know Ms Higginson was going to this morning. Through
wouldn't
the
that
end of
be
that
considered-
process, inmates can be confined to cell as one of the
And wouldn't
outcomes
that be considered then a form of punishment?
under inmate discipline. It's
Yeah.
one of the sanctions under inmate discipline, but it's not solitary confinement. It's defined under that part of the act.
How do we not consider that solitary confinement if they're in their cell on their own? I mean, what's the difference?
Well, I take you to clause 164 and solitary confinement, and also that we continue to provide all the other rights and privileges that inmates have access to under
So
law.
if someone's segregated to their cell, they can then make a phone call, they can go and see a visitor potentially during that time.
That's right.
And that's considered the difference between solitary confinement and being punished by being held in their cell on their own.
Yes.
I've got some further questions. Last budget estimates, there was a question on notice, and it was question 168, but it referred to allegations about corrective service staff approaching inmates individually and asking them to sign waivers allegedly containing agreements that inmates would not pursue corrective services or DCJ. The response I got at the time was that this was being investigated by the Department of Community and Justice. I'm just wondering if somebody can provide me any update or the status of that investigation.
That probably falls to me, Ms Erstein.
Yep,
it's
great.
a very legitimate question. Can I attempt to come back with a response this afternoon?
Yeah, sure, that's fine. We can get to that in the next round if you're comfortable with that. And I've just got some questions around that, so if you want to sort of familiarise just in regards to any outcome of that investigation. I've got some further questions to the Commissioner in regards to last estimates. Former Deputy Commissioner Grant referred to an individual employee within corrective services leading consultations with women in custody to try and understand what they thought would make a difference in relation to the development of a women's strategy. As far as you're aware, did these conversations include discussions about the impact of corrective services policies on the lives of these women specifically?
Yes, thank you, Chair. I'll take this opportunity to bring Deputy Galusis up. Thank you.
Thank you. Yes, what former Deputy Commissioner Grant was referring to was the process we undertook, thank you, for the development of our women's strategy. So if I can, just to give you the context, when the Commissioner commenced in the role last year, he gave me a very specific brief around developing a 10-year women's strategy that was essentially fundamentally different to the way the system works at the moment. So not just tweaking programs and services, the development of a whole new operating model for women. The strategy is now in draft form, and the approval process is well advanced. If I could just say as well, the reason why we had to develop the women's strategy, and I'm sure it's well known to the committee, but it's around the significant overrepresentation of Aboriginal women in prison. It's the extraordinarily high rates of remand among women. 60% of women in custody are on remand. It's the different pattern or the different way in which women interact with the correctional system. So they tend to come in more frequently for much shorter stays and cycle through the system with, I think, a third of women spend less than 30 days in custody. So that really challenges our traditional model of service delivery for corrections. So in answer to your question, yes, those consultations with women were exactly about the impact of our policies and practices on their experiences of corrections and the way it supports them to establish themselves in the community when they're released.
And so will that draft include any of the records of what inmates actually communicated, what was important to them during the consultation, or just more the outcomes?
So we have a consultation report that's also draft and pending approval that summarises the themes of the consultations with the almost 500 women and stakeholders that we consulted with.
So that will sort of that summary of the discussions and feedback from the women, will that be published publicly?
It's pending approval.
But the proposal is for it to be public.
That's right. Yes.
Great. Thank you. That's from
I'll
me.
just,
Yeah.
just add, Chair, that I just want to acknowledge Deputy Commissioner Galusa's leadership and work in that there. The strategy is, I believe, the best strategy in the nation that we have, and it's very, very important to me, and she's doing an excellent job leading that work, that we have to, and it's part of the capability reform that I've been employed to do across the system to ensure that we manage people appropriately in our care, particularly with the various cohorts that we manage, but women in particular. We have a male system that sits over a female system, and they're managed by numbers, not by needs. And the strategy in itself, and I've read the draft in detail, and I think that when it is released publicly, it'll be well received. It's really, really good work, and it will allow us to change the system significantly to try to reduce the footprint for the women that are in our care in the secure custodies and put them into less restrictive environments, and enhance our capability within the community, so that they can be managed appropriately. So there's many facets, but the women's strategy itself is one of the principal factors in changing how we manage the correctional system in the future.
Thank you. I've only got 2 seconds left, so I'll go to Ms Higginson, but just noting that in the next round I want to ask some more questions about Aboriginal women in custody as well, and particularly pregnant women as well.
I think that would be good.
Thank you, Mr Higginson.
Just following up on that, thank you, Chair. Can I just ask when did you anticipate the strategy will be released and available?
It's imminent. It's very, I would say, very soon.
Okay.
Yeah,
thank
absolutely.
you.
I think
And you'll publish that on the website. It'll be available.
That is certainly the intent. Yeah.
Thank you very much. It's so long time coming, isn't it? Thank you. Yeah. Can I just ask? I just want to ask you about that awful incident of the sign that was placed in the kitchen area of MSP's facility, the MPC. I mean, I'm happy to table the document, but I think it's been made fairly public. It was an awful document about hurt feelings report, full of sarcasm, full of cruel, nasty words. I'm thin-skinned, I'm a pussy, I have confused hormones, my man rod is not as firm as it should be, more commonly, and so forth. This was apparently placed in the kitchen area or on the fridge or something like that within the MSPC, and apparently by staff. Can you give us an update? How does that happen in a centre in these times? Did you investigate, and has anyone been held responsible for that? Thank you.
Yeah, Ms Higginson, so the sign in the event that you referred to was part of the inspector's report out at Long Bay. At the time, I understand that sign was identified and removed by the inspector. It was brought to the attention of the governor, and it was investigated locally. I understand the source of this document, which is outrageous, was not able to be identified, so there hasn't been any outcome or any consequence other than its removal. But certainly the Commissioner and I and all of us are outraged by that. We have 10,000 amazing staff across the state, and it's single individuals that participate in things like that let us all down.
But let's be frank. It was there in a facility, in a centre, and it was there for some time. It was there when the inspector was there. The inspectors don't just rock up. There was some degree of impunity around this, that there was permission to have something like this. That is clearly cultural. So I don't think it is fair to say it's an individual. Other people saw it over and over and over again. It was in a public place. So, I hear what you're saying, but I can't accept it, and nor should the Commissioner. It is evidence of something much deeper than one of the wonderful 10,000 people that work in corrective services. It was there, and if the inspector hadn't walked in, in full knowledge, it would still be there. I mean, and that's a real problem. It's appalling. As you say, you can see it for yourself. So have you done anything in terms of, rather than, like, finding a single person or groups of person is helpful or part of the issue, but have you done something to try and establish within every centre that this kind of thing is just grossly inappropriate and unacceptable and harmful?
I agree with all your comments. Before I bring forward Deputy Galouris, with work that we have done in around changing the culture, and part of that is why I've been employed, to look at the system, change the culture and bring us forward as a respected corrective services industry in the country, and I will do that. Changing the culture takes time. It's not something that can be done. If we were able to identify this individual or persons that were responsible, they're not the people that I want in my employ. That's for sure. I've made that clear. There's a lot of work that we have done following the Astle inquiry, and I might just ask Deputy to come forward just to talk about some of those pieces of work. But this work will remain and will continue to be ongoing. Part of the capability reform is important. There's three aspects that are important. One is around redesigning the structure, which I have done. And we've now got that, which will be implemented in July. The second element of that is the leadership, and ensuring that we've got the right leadership in place. And there's a recruitment underway now in relation to all of the executive positions, because of my expectation of what I expect from leaders, and having an ethical framework around making sure that we are able to apply that. And thirdly, there's the work practices that we apply, and looking at all of the work practices from taking it from the front gate to the back gate. So there's an enormous amount of work, and it's very, very disappointing. Whilst we welcome the inspectors and independent reports because it's important, but it's something that we will not tolerate, and we have to change over time.
Thank you. Can I just ask about that particular Inspector of Custodial Services report? It was found that the Metropolitan Special Program Centre was covered in cat hair, cat faeces, mould, rust, ligature points, broken tiles and cockroaches. Found that most of the facilities were too small to facilitate access for inmates with disabilities. The doors were too small for wheelchairs, for example. Are you recommending to the Minister that that centre is closed?
Well, there's a couple of points to that question. One in particular, when that inspection took place, that facility had been closed, that area had been closed, and unfortunately the maintenance wasn't kept up. So the maintenance team and the program have gone in and cleaned the facility up and brought it back up to standard. But we look at, as a part of the capability reform, what's important. I often refer to the 5 pillars that we manage in a correctional system that doesn't change. And that is, you have mainstream, you have protection, you have women, you have First Nations, and you have the aged, frail and vulnerable people. And that part of the capability reform is to have a look at our existing facilities and make sure that they're fit for purpose, and that we have the right cohorts in the right mix, which also includes looking at our complexes. So we have the complexes across the centre, have we got the right cohort in it? So there's a large amount of work that's happening at the moment to try and right-size that. So in short, we try to place the people in the most appropriate accommodation that we can.
So who would be the most appropriate people to go to the MSPC?
Well, the MSPC, it's generally general population that we take in there, you know, so...
So you think that it's now had a clean up and it's a suitable facility, notwithstanding all those significant issues that the inspector pointed out?
Well, I can assure you that the facility has been cleaned up, and that we make every effort to make sure that we only place the people in there that are suitable.
I just want to, something I mentioned earlier to the Minister, you wrote that letter that was signed off on the 29th of September last year indicating that the PSA's General Secretary's concerns surrounding classification and support persons arose from a misconception. What steps have you taken to avoid any further misconceptions that the union may hold about the way things are being managed and processes and procedures are being followed within corrective services?
Yeah, thank you. It's a good question. I go to great lengths to make sure our communication is always improving. I have regular meetings with the union other than the structured meetings that we have, and I have met with them infrequently because I need their assistance in relation to the reform program. So it is not unusual for me or Mr Taylor or other representatives to meet with either a select group, a whole group, or regularly. So I've met multiple times with Stuart Little and the staff at PSA House, particularly around it. I'm very mindful around the reform program to make sure that's the communication and why we're doing it, and try to clarify any concerns that they have and the reasons why we're having change, because change is not normally accepted well by anybody, so communication is critical. So I
Thank you. And just finally, in the short time I've actually got two questions, but I'll just have time for one. In relation to Aboriginal deaths in your system, I heard from one of the ministers this week that there was a review of some sort being undertaken. What does that look like? What's happening? Because I'm sure it's incredibly distressing for you as the Commissioner now.
It was. Coming into this role, it was very concerning to me. I had conversations with the Secretary, with the Minister. The Minister directed I undertake a Commissioner's review because of the number of deaths. The profound consequences of death impacts all, not only the staff responding, the families, everybody. And the numbers were very concerning to me. So through that review and the report's nearly finalised, I had drafted some terms of reference to ensure that we looked at the natural and unnatural deaths and why they were occurring. And as a result of that, there were 26 recommendations, but it was directed by me that I wanted to make sure that we targeted five things that we can make a difference on the here and now, that we can change, that can greatly assist to prevent or mitigate any of those concerns. And they centred around, the peer support program, enhancing the peer support program, enhancing the leadership and for all our staff and the training, to strengthen that internal capability when we're actually managing those vulnerable cohorts. Improving connections, for people entering and gaining access into the custody, and the importance of the family contact to get that down to 24 to 48 hours, so that they can have that immediate contact. Enhancing the cultural initiatives, so that we can expand that across to with the introduction of Aboriginal community mentors and elders, and the cultural programs to the 2 remand centres in particular, and increasing the therapeutic responses to the risks of self-harm and suicide, and complement the current practices. And that there are some financial requirements to this, and submissions are being prepared for government and put forward, and we put that forward as it is a priority and remains a priority, and that is running aside of the anti-ligature program and of those things as well. So yeah, it's a high priority for myself.
Thank you very much.
Yeah.
Thank you. The opposition.
Thank you, Chair. This is for the Building Commissioner. Since its establishment, how many building defect disputes has the Building Commission facilitated through the existing mechanism?
We have about 9,000 complaints each year at the moment, and the Building Commission has been in existence in its current form for a little over, for nearly going on 2 years. And the previous year it was about 7,000. So our complaints team has generally settled around 50% of those internally.
Okay.
So about 3,500 in the first year and about 4,500, and we're on track for a larger number of complaints this year.
Okay. And how many of those disputes are successfully resolved both internally and externally?
Well, those 50% are the ones that are completely resolved between the practitioner and the complainant, typically, or between the builder and the complainant. Where matters aren't resolved at that phase, there is an option for it to be pushed through to the tribunal.
So how many ultimately do proceed through to NCAT?
I'm not sure how many matters go through to NCAT. NCAT has advised us, I believe, that 5% of the matters they hear are building related. Whether or not they've come through us first, a number of matters go directly to NCAT without ever coming across our desk.
Okay. So the matters that are resolved internally, those 50%, that's not to say necessarily that the complainant is satisfied with an outcome. It's just that it's been closed as a matter.
That's correct, but typically we do have a level of satisfaction from the person complaining, but not in all cases.
So are those figures reported anywhere?
We haven't reported those figures.
Is there any intention to do so?
We've put it in part of our discussion constraints that we're looking at doing dispute resolution going forward, because if we look at what level of complaint we can deal with, what might we deal with, what would be better done under a civil sort of matter, all those things are still very much up in the air and things that we're just having discussions about at this point in time. But yes, we want to let people know about that success there, and indeed with more training, are we able to be more successful with that complaints team? Is that something we ought to put more people to, or with better, more effective training, are they able to resolve more matters at that stage?
So with the increase that's occurred from last year to this year, and then your expected increase, are there explanations, trends that you can draw? Why are you expecting that increase?
I think there's a greater awareness of the Building Commission in itself, so people are going through that pathway. I think that's probably driving most of the rise in complaints.
Do you collect any data on that? Like, is there an exit survey that people complete? How did you hear of the Building Commission?
We don't. The complaint is actually lodged through Service New South Wales front door. Maybe there is details around that, but we don't have specific analytics on that.
Okay. Is there anything in place that reduces, in terms of a program or policy, that reduces the financial burden on apartment owners caused by some of the costs and often delays around NCAT that you're aware of?
I'm not aware of any program that's available to them if they're going through NCAT, the costs associated with that.
And is there any cost associated with going through you?
We don't charge for that service, no.
Okay. Do you ever get feedback around that, around costs associated with making complaints?
Frequently.
Okay.
Frequently people who were unable to resolve their matter and it goes through to NCAT or indeed one of the other courts, often gives us feedback that it's an expensive process for them. It's a traumatic process for them, and they feel, aggrieved by the circumstances.
Do you collect that data and put it somewhere? Does that go in a report that is sent to the minister, or?
We keep all of that information on file because that would have started through a complaint. So that is stored, and we we have that information. We do use it for our own lessons learned practices. But
Do you use it to make recommendations to the Minister about how processes could be improved or policies could be developed?
we haven't at this point in time because, as we point out, the Building Commission is not that old in its current format. So we've only really had our teams being more and more effective, better use of data, better collection of data over the last sort of 12, 18 months. And that needs to be trusted and normalised and regularised, and then we can start to form patterns and see where we might be able to better intercede. We do have good analytics where we run risk profiles now, predictive risk profiles against certain practitioners and the like. That enables us to be more targeted in our investigations and our inspectors. But again, that's in its infancy, and it's not something that we, are 100% confident in at this point in time, but it does seem to be giving us very good guidance and quite an efficient way of utilising our inspectorate.
Okay. And in terms of the time that it takes for complaints to be resolved through your internal process, is there an average time that you're aware of?
No, we don't have an average time. They're all very different. Some are resolved very, very quickly within days. We might call a builder, for example, and that builder, just after getting the phone call, is quick to go and make the rectifications, whereas they may not have at the request of the owner or the complainant. So some are very speedy. If it can go on and on, or in fact, indeed, if an investigation commences, the investigations can take a very, very long time.
Do they usually take a long time because lots of people from the Commission are required to engage with those processes?
Not necessarily. There's a lot of complexity to some of the complaints. There's a lot of, often enough, there's more than one practitioner involved, or more than one builder or subcontractor involved. And there's an amount of trying to identify who might have caused the work to be done. Is it a design matter? Is there a fault with the design, or is it a workmanship issue? So there's got to be a complete review done if it gets to that investigation stage. And in many cases, that doesn't necessarily assist the owner, if you like, or the complainant. They may still have to go through to NCAT, but we have the option of taking regulatory action against the person who's caused the harm.
And in terms of the level of expertise required by your staff to investigate matters, how do you manage that if you need somebody who has a different, set of knowledge or skills that is required?
So our inspectorate, the inspectors who go out and look at work, are in various different categories depending upon their specialty, and they are typically from that trade background, and they have further training around their roles, so we're very confident about that. If it goes to investigations, our investigators are very well trained. I think all but perhaps a couple are former police. They have to do continued investigation training, and again, they work in particular discipline areas, so they get better and better skilled at that area, and we've seen the growth and development and the more successful prosecutions as a result of that.
Okay. And I understand that there was a recommendation through the statutory review that mandatory mediation through the Building Commission was recommended. My understanding is the government hasn't immediately supported this recommendation. Just wondering if you have done any work around what a mandatory mediation process would mean for the Commission in terms of resourcing and your capacity.
So that's the exact work that we're talking about doing at the moment. We've started with a constraints paper. We've organised to have an industry engagement session. And the intention of that is to look at various different options. We have spoken with our co-regulators in other jurisdictions who have systems and processes in play around dispute resolution. And so we hope to be able to take some options to government in due course.
Okay, and is there a deadline for when you will actually present that to government?
It's an initiative we've generated, so no.
Okay, are you expecting to deliver in like 6 months' time?
I would hope it's this calendar year.
Okay, and just finally, that engagement process, is that a public process that people can engage with proactively? How are you thinking about your stakeholder engagement?
Right, so we're thinking about a broad range of stakeholders, including NCAT, including members of the judiciary.
Yep.
At this point in time, it's expected to be largely a legal representation at that, in order to come up with an effective proposition.
Mm-hmm.
We have a lot of feedback already from industry about their side of the concerns, and there will be representation from some of those. We have run industry roundtables before, so we expect there to be around about 30 odd people at the table, representing around about 15 different groups. That's the intention. Any larger than that starts to get a bit unwieldy.
Okay, and thank you for that information. Just on building licences and this matter of Mr Cornwall and his 20 weeks of waiting up until this week, when it seemed like he received a call following the budget estimates questions that were raised and some media attention. The reason that the delay was that the delay occurred was apparently because somebody from the Building Commission said that they couldn't reach the reference of this gentleman, but the gentleman said that his reference received a phone call just 10 minutes prior to when he received a phone call to say that his application was approved. So just wondering if you have investigated this and if this is a normal occurrence.
That particular matter, I haven't investigated.
Okay.
The normal time period for contractor renewal or builder's licence spans between 9 weeks and 20 weeks. 20 weeks is where we're at with builders at this point in time. The applications and renewal numbers for this year look like a 31% increase on last year, which is good that we've got more people coming in and applying. We have around about 48 active team members in our licensing team, FTEs, doing the assessment, and some of them are quite specialised. More than 80% of applications that come to us have to be returned because they're incomplete or illegible. So the time for the 20 weeks is commencing from when they first. We don't stop the clock whilst we wait for information to come back. And it would not be the first time that we've tried to reach a referee and they either haven't been available, or the phone number hasn't been correct, or the phone number hasn't been legible, and different people might try different numbers. But we are thorough. The licensing team is dedicated. You are required to be a fit and proper person as part of that test. So they are very thorough about the process of ensuring that referees are called and checked, and that those who go through have the documentation correct.
It didn't seem like this case really had a situation where the submission was it wasn't legible. Illegible? Yeah, sorry. So, yeah, I guess given this case, will you investigate whether some of these delays have been caused by other reasons? I mean, this... obviously,
I do
if this
have
is
every
occurring...
confidence in our licensing team.
Yeah.
Notwithstanding that, I'll take a look at this particular matter that you've raised.
Okay, thank you. Okay, I'll go to Nicole Overall. Thank you.
Thank you very much. And thank you, Chair. I'm not sure again how much time I have. I'll turn to the Fair
You've
Trading.
got 5 minutes.
5 minutes, thank you. Fair Trading Commissioner, again, please. You stated earlier that the asbestos register is voluntary. Can you confirm that the only voluntary component is the initial homeowner testing, and once contamination is confirmed, inclusion on the register has been mandatory under the current Home Building Act 1989?
Yes, no, that's absolutely correct. The program itself is voluntary, but if asbestos is found, then being on the register is mandatory, absolutely.
So you didn't clarify that earlier. So why would you seek to downplay the significant public safety function of this register by not describing it previously to accurately reflect that?
I'm sorry, I wasn't trying to reflect it in any way that was inaccurate. I think the point that I was trying to make is that it isn't a long list of properties that people can look at the list. It's at the moment, as I said, there's 3 on it and you one to come off, and then you would need to know the addresses. But I guess just I do acknowledge the concern that you're raising, and I just did want to reassure that if people want to come forward either before the program closure or after it, we will absolutely give them the support and the assistance that they require. And if you are aware of constituents who wish to avail themselves of the program, please, I would encourage them, and we will assist and support them.
That is, of course, the way that it should be, but the problem still remains that of future instances. And if there is no register that is publicly available into the future, this information, regardless of how few a number there are on it right now, is a concern going into the future. But I appreciate the sentiment of what you're expressing there. We can get to some of that perhaps, but in the meantime, could you please confirm the precise amount of the budget allocated back in 2015?
So this is and I have to get this correct, this is a Treasury question rather than one for me, so I don't profess to be the expert, but it wasn't a budget that was allocated, it was a liability that was provisioned for. Yes. And I understand that was calculated back in 2015 based on the PwC report at the absolute upper limits of the properties that could be identified, and the amount was the amount that you were mentioning before, which was the 278.6 million. But the way that the process works is each year, as we see how many properties come on, as I understand it, Treasury then revises the provisioning of the liability, and so the figures change year on year.
So I've been advised. Would you then be able to, you may need to take this on notice, detail how much of that original figure, how much has been spent at this point in the provision of the program?
Yep, so I don't need to take that on notice. I've got that figure here for you. So to date, the program has incurred approximately $172 million in costs, and that amount includes all of the support and assistance that we have provided to homeowners to have the properties remediated. And it also includes the costs of my staff members in running the program and administering it, and it also includes the costs of the register and maintaining that register year on year.
Yes, so that means that, and again, coming to the provisions that you made earlier, the qualifications about the $278.6 million, there is still around about $100 million that had been effectively identified as part of that report that would be made available for properties so impacted into the longer term.
Yes, so I think in 2015, based on that report, that was the liability provisioned for. But I understand from my Treasury colleagues that as recently as 2020, the provisioning was dropped by, I think it was around $80 million, just based on the fact that the numbers are just not coming to fruition. And I think we should remember that the company that these programs were set up for was actually an ACT company, and so what we saw in the ACT was a much greater take-up, and there are 1,000 properties, as you might be aware, that where asbestos was found, whereas in New South Wales, the company Mr. Fluffy operating here but not based here, and so the numbers were much lower for us, 159, and as I've said, 98% of those now remediated.
There were other companies who were dealing with this as well, and yes, properties in Queanbeyan, Goulburn, on the south coast, which were even the Hunter, which were identified by the report as well. Hence, the upper limit of the PricewaterhouseCoopers report was almost 1,000 properties. When it comes to the ex gratia payments that you had mentioned earlier and the suggestion they will be attended to on a case-by-case basis, is there a framework already in place for that?
Yes, there is an ex gratia framework.
I'm sorry, has the bell gone?
It has, but we've started another 2.5 minutes for you.
Oh, thank you.
Yes, so to answer your question, there is an ex gratia framework that exists already, and as I've said, if there are people that wish to come forward either now or after the closure of the program, we would absolutely give them the support and assistance that they require.
That framework is already in place, and you can provide the detail on how that will work?
So yes, there is an ex gratia framework in place across government. It's a long existing framework.
Specifically in relation to this, to loose fills?
So I'd like to just take on notice whether we would adopt it as is or whether we would look to amend it slightly for the particular circumstances of this matter.
That would be fine. When were, it's probably too broad and you may need to take that on notice, but stakeholders that were apparently consulted about the program and the register being cut, do you have that information, or you would be able to provide that information?
I can take that on notice.
Okay. What about Safe Work New South Wales? When were they consulted?
So they were consulted as part of the interagency consultation that took place ahead of the decision and ahead of the Cabinet consideration.
The date for that?
I don't have that date.
Okay. Would you be able to take that on notice, please?
Yes, I can take that on notice.
Thank you. And what was or has been their response to the closure of the program?
So I would have to take that on notice, but I think that all the interagency responses were as part of the Cabinet process, so I'm not sure that they were. I think they would be Cabinet in confidence.
Otherwise, perhaps it'll be information that comes through with the SO 52. I may be running out of time, but can you please confirm that around 120 jobs are being cut, redistributed, moved aside from fair trading, and that includes those positions linked to this loose fill asbestos program? And was the decision to cut those jobs specifically for the program made before or after the decision to cut it?
We have undertaken a functional review in fair trading. The number of roles in the new structure is the same as the number in the previous one. And I can talk to you about the rationale for that.
Probably best if you just provide that, I would think, on notice.
Yeah, but I mean, it would make sense that if there is a government decision to close a program, that the staff that have been working on that program, that those roles do not exist in the new structure.
Yeah, but I'm asking about whether that decision... Sorry, Chair, is my time up?
Yes, sorry, Ms. Overall. Thank you.
I'll make them supplementary. Thank you.
That's all right. That's totally fine. Thank you. Mr. Tibble, did you get a chance to get across the waivers issue?
Not across the waiver. I did, in response to Ms. Munro's question, if I may.
Sorry, can I do that sort of outside of crossbench time?
I anticipate Ms. Hurst having an answer after the next break.
Okay, all right, fantastic, thank you. In that case, I might go on to some questions that I had in regards to pregnant and new mothers in custody. I'm just wondering if pregnant women and new mothers in custody are given the opportunity to breastfeed their children.
Gentleman, yeah, thank you.
That's actually a question I'll have to take a notice unless I can pass to my colleague.
There are a limited number of women that have full-time custody of their children, but certainly we facilitate, and Justice Health are part of this. There's a plan around women which enables them to express and to provide for breast milk to be passed into the community for their children, and then there are additional visits that are also provided for women. So if they're a breastfeeding mother and they're expressing, they can also feed the child through through a visit, but you can understand if the child's not with the mother full time, then the logistics of maintaining breastfeeding is pretty challenging.
So how much time do they get to spend together in that context then?
The normal visits arrangements for women and at Silverwater Women's and Dilwinner and most of our mothers at birth are at Silverwater Women's, so they have visits on the weekend, but there are additional visits, particularly for very new mothers that are arranged. But I can't give you a specific answer, but I know there are special arrangements made by the governor there for...
if you could let me know on notice
sure.
the amount of time. And if there was to be a birth of a woman in custody, are family members permitted at the birth itself?
I'll take that on notice. I think the answer is yes, but I'll take that on notice.
And this one may also be one on notice, but whether there's an opportunity to take photos of the mothers and their babies? Yeah,
I'll take that on notice, but we obviously have our security procedures, but we pretty sympathetic to mothers at a birth and take a pragmatic approach.
Thank you. We now go into an afternoon tea break. There will be an opportunity to, right at the end of the day to fill up any questions that were asked that people have further information on. But we'll stop for afternoon tea break at the moment, and we'll be back at 3:45.
I can help with that question on the waiver now, if you would like. No?
I think we've gone off.
No, fine.
Yeah.
Thanks.
Oh, we're still on, but I think we'll do it later on. Thank you. Great. Awesome. Welcome back. So, Mr. Tibble, now if we could get back onto the waivers, I just want to make sure we all had our afternoon tea.
Enthusiasm
No, I
in
appreciate
seeking
enthusiasm.
to respond to your question. So, in relation to the waiver question, what is important to, I think, expound upon is that the matter actually was reported to the police. So we could not begin our investigation until that police process was complete. The matter, we were advised by police in December that we could now proceed with our own internal investigation within DCJ PSI. That is what we're doing, and that is well underway.
Okay. When do you expect to conclude that investigation?
Can I say imminently?
Okay.
But I can't be more definitive than that.
Okay. Okay, thank you. I'll probably have some follow-up questions then next budget estimates.
Fine.
We've got
Absolutely.
some outcomes
Yep.
of that. Thank you. I'm going to head back then to pregnant women in custody. At the last estimates, former Commissioner Grant made reference to a working group operating at the time called the Pregnant Women in Custody Working Group. And that working group had apparently been asked to develop and implement dignity-focused strategies which support and improve the custodial environment. Could I just get an update on the development of those strategies and the operation of the working group?
Chair, while my colleague's coming up, do you just want me to, I'll just give you some other information on your earlier
Thank you,
question.
and sorry, just to remind anyone coming forward to bring their nameplates as well, just for Hansard as well. Thank you. Sorry, continue.
Just to add a little bit more information to your earlier question. So what I reported in my evidence was correct, that special visits are allowed for birthing mothers both at the hospital and in the correctional centre. We allow family members to visit, and we encourage partners to be present at the birth. We allow photos. The only caveat is where AVOs are in place, so there's obviously that restriction that's done on an individual basis. We encourage breastfeeding where the child's not with the mother, which is most common, and it's Justice Health who store milk and arrange for it to be picked up by the family or delivered.
Thank you.
So in 2024, Corrective Services did establish a pregnancy and custody working party. My understanding is that its purpose was really to identify practical improvements rather than a strategy document. The working party is now concluded, but I can tell you about the things that it did deliver.
Thank you.
It delivered an enhanced nutrition for pregnant and breastfeeding women so that we could ensure that they're meeting their dietary needs. It delivered improved bedding, including thicker mattresses and body pillows, and that was done in partnership with our Corrective Services industries. It delivered a multi-centre virtual pregnancy support group, which brought together Justice Health midwives, allied health staff and Corrective Services staff to provide education, reassurance and peer support across centres. And so these measures, together with the reforms that have been scoped and proposed in the draft women's strategy, are really aimed at strengthening the health, the safety and dignity for women in custody, particularly pregnant women.
Thank you. And so that working group now is no longer...
That's right. It's concluded.
It's
yes.
concluded?
Yeah.
And when that working group was together, did it include women with lived experience in this space?
I would have to take that on notice. I don't have
if you
the
could find out
composition
for me,
of the
thank
group.
you. At the last budget estimates, former Deputy Commissioner Grant indicated there was no specific psychological support for women who may have their children removed while incarcerated. Is that something that is being addressed or was brought up by this working group?
In terms of the working group, I'd have to take that on notice. It was something that was raised as part of the consultation for the development of the women's strategy. Mm-hmm. As you know, we have the co-located caseworker program within Corrective Services where we have child protection caseworkers embedded in our correctional centres to support women who have had their children removed. The question around specific supports has been raised in the broader context of mental health support for women in custody. So I'd have to come back to the committee in terms of whether this group touched on it, but it is included in the women's strategy.
Thank you. I've got some questions to, well, this is continuing in corrective services. I'm wondering how many Aboriginal and Torres Strait Islander incarcerated individuals have an NDIS plan, or if they all have access to NDIS support.
I might have to take that on notice. I don't have that to hand.
Thank you. Could I just sort of broadly get a bit of an understanding around what corrective services are doing to ensure that the needs of adults with a disability are being met once they're within a custodial centre?
Yeah, so when people come into custody, as part of our screening process, we screen people for a disability. And sorry, can I just clarify, was it an intellectual disability you said, or just a disability?
Just a disability more broadly. Yeah.
We do screen people for a disability, and then referrals are made to specialised services for further assessment and specialised intervention. We do work very closely with Justice Health to make sure that the physical and the cognitive and also the medical and security needs of people with a disability are both identified and met. And obviously the focus is on making sure they're safe, supported and able to access the services that they need. We do have a specialised disability support service within corrective services, which is staffed by very experienced, highly qualified staff. They also work very closely with staff to help identify disability-related needs, help staff to adapt the way they work with people with a disability to make sure that the way we're working with them is appropriate. They provide advice on adjustments, support planning, ensuring that people are linked to the right services while they're in custody. In terms of NDIS, obviously that's determined by the Commonwealth, not corrective services, and packages can't be accessed once a person comes into custody, as you know. So that's something that we do support people to put in NDIS applications for when they're released to custody. And then we're also working through some of the recommendations from the Disability Royal Commission around how we can better identify and support people with a disability, particularly those who are vulnerable and may be more likely to experience, more punitive practices in custody, like segregated custody, because of their behaviour and staff not understanding what's driving that behaviour.
Thank you. And have there been any reviews into the custodial operations policies and procedures to ensure that they are inclusive and accessible for individuals with disability or mental health diagnosis?
That's for staff or for
incarcerated individuals.
I'll hand to DC Taylor to answer as well. I'm not aware of any overarching review, but our statewide disability service does work specifically with our operations teams and the policy team to make sure that adjustments that need to be made for people are represented in those policies and procedures. But I'll hand to DC Taylor.
We've just established a project within my area to review all of our custodial operations, policies and procedures, which includes disability. So that's going to work in the next 12 months, covering all our policies and procedures, which is a project that's overdue, but one that we've resourced and kicked off. So that will roll out incrementally once we start working through it. But our disability is one of the priority areas, just to make sure that we're meeting the needs of people that are coming in, and the more complex people that we're now managing, including those with greater and more complex disabilities.
Thank you. I'm glad to hear that. Is there a policy relating to the use of restrictive practices on persons with a disability within custody settings, or is that something that will be included within the review beyond the usual sort of restrictive practice used on other inmates?
Yeah, look, our policies and procedures ultimately respond to risk, and particularly around violence. What underlies those behaviours may often be disability, and to my colleagues' comments around, training our staff for people that may respond in particular ways. We have a growing number of autistic inmates who, present violence in the community, which probably, get some of them into custody, and those behaviours continue in custody. So we need to manage the risk, and our restrictive practices enable us to do that. But what's important for our staff is to respond appropriately for the underlying drivers of that, so that we can mitigate ongoing violence and harm to staff and harm to the individual when we understand where that comes from better. And there's probably some of that we need to lift into policy better.
Yeah, thank you. I've got some questions in regards to lockdowns, and these are somewhat specific, so they may need to be taken on notice. I'm just wondering, in the last quarter, which 3 prisons were the ones that had the most lock-ins or lockdowns?
Yeah, look, I might take that on notice if that's okay.
Yeah, totally. And the other questions I have, which I'm happy for you to take on notice, is how often did they occur? How long did the lockdowns themselves last for? And were incarcerated people afforded basic rights during those periods, including time out of their cell in fresh air?
Okay, we'll respond to that on notice.
Thank you. I appreciate that. I've got some questions about the new Crimes Administration of Sentences amending bill that passed in November last year. Since the lowering of the burden of proof for inmate disciplinary processes under the Crimes Amendment Bill, I'm just wondering how many inmate disciplinary matters have been initiated.
Yeah, Chair, I think if you don't mind, I'll take that on notice.
Okay, the number is 25,000 a year.
Okay, so we go.
And that's since the bill has changed.
Yes, so whatever pro rata is for that period, but we'll give you a full answer on notice.
Yeah, thank you, because I'm trying to look at the difference between before and after the bill.
Whether
So,
there's an increase or a decrease.
Yeah,
sure.
Thank you, exactly. Thank you so much. And I've got some other questions. I might just read them out so we can put them on notice because they're following on from that. But how many matters have involved a visiting magistrate? And a breakdown.
That's Neil.
That's Neil.
Yeah, thank you. And a breakdown of figures for both Aboriginal and non-Aboriginal people. And how many times approval was given from a visiting magistrate for the purposes of conducting disciplinary matters. Could I also ask, I might have some more on that one, but I'll come back to it in a moment. The ASTL inquiry, which we've spoken about previously at estimates. At the last estimates, Minister Chanthivong referenced having tasked Dr. Hannah Tonkin to develop the corrective services policy regarding women in our facilities to ensure that it's independent of corrections and provides the government with the appropriate advice to ensure that our strategies and our practices support both female inmates and female officers as well. Could I get an update in relation to the publication of that and the work that's done specifically in that space?
So to clarify, I believe the Minister was referring to the women's strategy.
Yeah.
So as part of the development of that strategy, Hannah Tonkin, as in her capacity as Women's Safety Commissioner, provided, strategic leadership and oversight of the strategy, as did Professor Eileen Baldry. So, as we mentioned earlier, the publication of that strategy is imminent, and it will be published once it's approved.
Thank you. The Minister also talked at last estimates in regards to the women's strategy that the development and the implementation of the reform would be in partnership with Aboriginal Peak Services. However, it became apparent at the last estimates that the women's strategy was already developed in its final stages of approval. Can you confirm whether Aboriginal Peak Services and ACCO's have been properly included in this process, and which organisations that they were?
Yes, we can definitely provide you with a list of who was consulted. We consulted with a large number of community organisations, including ACOs, to ensure that we really had 3 points of focus for the strategy. One was on women and their experiences, the other was staff and their experiences, and then the third was our service partners and their experiences. And we have a big focus on how we can improve the access of women to community service providers while they're in custody to support their transition into the community. So listening to the voices of partners was really key, not only in terms of the services they know they need to provide to women, but also what they need from us as an organisation to facilitate that access. And that is also included in the consultation report. We have a section on that in that consultation report on the voices of our service partners, and we publish on that the list of community organisations that we consulted. We've also developed a specific governance framework for the women's strategy that will include an Aboriginal reference group, so that we'll have leadership input contribution from Aboriginal community organisations as well.
Thank you. And so how will those Aboriginal peak services be involved in the implementation once the strategy sort of becomes publicly available? What will be sort of the avenue that they will work on in regards to that?
So it will be two ways. One will be through the governance mechanism. So they will have an opportunity to provide input and consultation on elements of the implementation plan that we're developing within corrective services. And then we also have specific projects relating to service partners that we intend to develop in partnership with those community organisations.
Thank you. And recommendation 30 of the Astle inquiry advised that the women's strategy should also include the development of a sexual misconduct policy and associated training for corrective services staff. Was that included in the women's strategy, and can you give me any kind of information in regards to how that will be incorporated at these early stages?
It wasn't specifically included in the strategy, but my understanding the policy has been finalised and the training is commencing tomorrow, I think, or has commenced.
Okay, so that's happening separate to the women's strategy.
Yes.
Can you tell me a bit more about that and how it's going to run?
I can give you, I'll take that on notice.
Well, Mr. Tidwell, you might have some information.
Do you have some?
Yeah.
Sure. So the government has provided funding for additional staff to deliver specific training to staff who work in female correctional centres. A mandatory sexual harassment training for all corrective services staff was rolled out in February 2024. Currently over 11,000 staff have completed the training, which was developed by an independent legal firm, and the development of a professional supervision framework for staff working with female offenders is part of the women's strategy as per the developed through the governance process that we have in place. And this will provide reflective practices for staff and is expected to be developed by the end of, is imminent, and a pilot commenced at Silverwater Women's Correctional Centre in July 2025.
Thank you. And so was that just training rather than a policy as well as training?
That is the training, but I think on the question of policy we can come back. That is certainly being dealt with within the complete response to the 31 Astle SCOE recommendations.
Great, yeah. If I could get some more information about any sexual misconduct policy that's also being created, that would be great.
Certainly.
Thank you. As at August 2025, a service provider was about to be appointed for the advocacy service for female inmates, which was recommendation 20 of the Astle inquiry. Can I get some more details about the service that's being provided in regards to advocacy for female inmates?
Sure. So that service commenced in November 2025 at Dalwinia and Silverwater Correctional Centres, and it was in response to Recommendation 20 of the Special Commission of Inquiry. The service is operated by Legal Aid New South Wales, and that was awarded through a competitive tender process, and they are partnering with Aboriginal Legal Service to provide that. So they provide women in custody with a trusted and accessible and a confidential advocacy service, which includes general advocacy and legal advice, support to navigate systems such as housing and childcare, and a culturally safe and secure pathway for raising complaints without fear or barriers. So it was designed to be gender specific and gender responsive, but also culturally appropriate, and intended for the women to be able to build a trusted relationship with those advocates.
Thank you. Opposition.
Thank you. I just had a couple of questions for the Chief Scientist. I don't know if you have any, but perhaps we can release him from this room.
Yes.
Thank you, Professor. Last budget estimates, I asked you about the Emerging Tech Fund and that it had combined the two Biosciences and Physical Sciences Fund. Is that now operating as that single Emerging Tech Fund?
It is almost in the sense that it'll get announced next week.
Okay, very good.
So it'll be launched next week.
And in terms of the scope of the fund, that has been expanded, I understand.
Yes, in order to cover the major items in the innovation blueprint.
Okay.
But it will still cover the main, also physical and biosciences, and it will be run using a very, very similar model.
Okay. And what is the value of the fund?
28.5 million, I think, over 3 or 4 years. Next year it's 7.8 million.
Okay. Thank you. Is there money coming out of your budget for Sydney Quantum Academy?
Yes, it is.
How much is that?
It's approximately 1.5 million a year.
Okay. Over?
It was for 3 years.
Mm-hmm.
We have about a year and a half left.
Okay. And does that have anything to do with the quantum terminal? Do you have anything?
No, the quantum terminal, I think, I'm pretty confident is finished.
Yes, it is being terminated.
At the same time, we also got a large federal grant for what's called Quantum Australia.
Yep.
And we also fund that from my office. And the work that Sydney Quantum Academy did is now shared between Quantum Australia, which is based out, because they're both based out of the University of Sydney, in effect.
Okay.
Right, one's national, one's state, though.
So Sydney Quantum Academy gets 1.5 million over about 18 months to go.
Yep.
And you're also funding part of Quantum Australia?
We essentially promised to put up funding in order to attract, I think, the 18 million of federal funding that came for Quantum Australia.
Okay, and how much goes to Quantum
1 million.
Australia? Sorry,
1 million in total.
Okay. Also, is the Defence Innovation Network still running?
Yes, it is.
And
it's very successful.
Yes. Is it being funded by?
Yes, it's being funded both by us.
Yep.
And the federal government also kick in money for that. Unusually, it's the one network where DSTG, I think it's called now, also put in some money.
Mm-hmm.
And in fact, investment up until now have also put in money.
Okay. How much was that?
In total, we put in 1.3 million for all of our 3 main networks that we fund, including DIN.
Smart.
DIN also receives, I think, 300,000 a year, maybe $500,000, but it's not my money, from DSTG.
Mm-hmm.
And until this year, I think also got 300,000 a year from Investment New South Wales.
Okay. And the 3 networks are the Smart Sensing Network, Defence and...
Space.
Okay.
We run other networks, but we don't fund them.
Okay.
I mean, as in, we run them on behalf of other people.
Okay, understand. Thank you. I think that was all from me on science. I'm sure I'll think of the thing as soon as you leave, but if there's anything else, I'll put them to you in supplementary, but thank you very much for that.
Okay.
Appreciate it.
Right.
Thanks, Professor. Hope you're doing something useful in the back there.
I'm sure you were. Okay. So I'll just do the rest of this one for innovation. Yep. So on South by Southwest Sydney, were Investment New South Wales consulted on the closure or the end of the contract, the finishing of the contract?
So we were consulted through the program on the value and outcomes that we were achieving from the program.
Yep.
We were informed of its closure.
Okay. So did you provide any financial analysis of the impact of South by Southwest Sydney on investment in New South Wales?
No, we didn't.
Okay. Is that something that, yeah, okay. In terms of the Innovation and Productivity Council, do you have responsibility over the IPC?
Yes, my team does.
So when were the members of the IPC contacted to say that they were no longer members of the council?
So all of their terms were due to end in December last year.
Yeah.
Regardless, the Minister met with council members in December to inform them that this review would be undertaken to that broader engagement with the innovation community.
Right.
And that as a result we would pause recruitment for the next term of the council.
Did Investment New South Wales or the Minister direct the IPC to conduct specific work in the last year, the last 2 years, the last 3 years?
So I would describe it as more of a collaborative process with the IPC and the chair of the IPC putting forward recommendations with respect to work that might add value.
Okay.
But ultimately the decision, and obviously, the strategies that we've been developing and publishing, we asked to inform the work of the IPC, but ultimately a decision of the IPC as to the work it undertook.
Okay, so the Minister didn't provide any particular direction on a specific report? Okay. And just in terms of the legislated responsibility, what's the advice from Investment New South Wales to the Minister about the operation of the council and the Minister's responsibility for it?
Yeah, so obviously the legislation has some quite clear requirements in it with respect to numbers of members and frequency of meetings and the Minister's role. In my advice to the Minister, I've taken quite a practical approach, which is that having been asked to do this review of engagement with the innovation ecosystem, that it wouldn't be good value for money to the state to run a recruitment process, nor would it necessarily be fair to the people putting applications forward for a body that may ultimately change. So my advice has been practically that the pause is reasonable.
So what is the function of the IPC in engaging with the stakeholder community?
So they are there to represent the stakeholder community and, as you described it, to commission work that will provide insights. Now, obviously, through each of those engagements, they engage with the community in developing their reports.
Right. So this review of stakeholder engagement, how did that come about? I mean, there has been so much in terms of reviews and documents, and I would argue not much detail about the implementation, but this is just another review that the community has to deal with. And I'm just curious about, did the Minister ask you to conduct a review of stakeholder engagement?
So yes, and if I trace it back, obviously one of the 5 areas of action in the blueprint is around engagement and making it easier for stakeholders to engage, both in the delivery of policy but also in receiving and engaging with the programs. So this review really responds to that.
Okay.
But yes, we were specifically asked to undertake this review.
Okay, and should we expect a review for every pillar of the innovation blueprint before things happen?
Not necessarily. As you know, a number of the specific actions in the blueprint are funded, and per your discussion earlier, are due to be launched this year with multi-year funding streams attached.
In terms of this review of engagement, how self-reflective is that review designed to be? Does it concern how the Minister interacts with the stakeholder community?
Yes, it does. If I might ask Dr. Oldenhoven to join us, she might be able to give us more details around the specific questions that will be asked of the community as part of that consultation, which we now have a number of roundtables scheduled over the coming weeks.
Gosh, it seems like the stakeholder community have engaged in many, many roundtables, and I suspect they feel incredibly well engaged with, though perhaps not very well listened to.
Sorry, I'm just going to pull up those questions. So we have a stakeholder engagement plan for this and a set of questions for them about how the IPC works, what kind of mechanism that does, what the work is about. I can get those specific questions.
It is obviously broader and looks to the overall engagement that we have.
And so it's not just about the IPC?
It's about how we do innovation advice broadly.
Right.
And so what other mechanisms are there that already exist?
Okay.
And so like other informal groups. So yeah, it will be self-reflective, but it will also look at other things that are around. So I know we've got like the Waratah Research Network, where that looks at how we do advice on research and innovation within government and with the universities. We can look at that. What other groups are around that exist already? So I don't know if there's tech council groups or other groups like that. So we're going to look quite broadly at what's available.
Okay, and I'm just curious about this IPC as an engagement tool. From what I understand, it has not been a body that is designed to go out to the community and necessarily be a kind of port of call for the community. It's about doing research, and yes, obviously engaging when research is required to gather information. But it just seems like if the IPC is being characterised as an engagement tool, that seems a little disingenuous.
I think it's an engagement tool with the community to understand kind of the key factors around how we do innovation.
Okay.
Some of those reports, like the scaling.
But the Minister hasn't asked for any reports to be done, so it's, yeah. Okay. Is there a deadline for this review to be delivered?
So we're working on that at the moment, and we have planned roundtables coming up soon,
Yep.
and we're trying to get it done as soon as possible in the next month or so.
So the roundtables get done in the next month, and then when does the review conclude?
When we've completed going through the results of those, and we have to see what the extent of that consultation is.
Okay, so the review is going to be based on the roundtables and desktop research and...
Desktop research, interviews with IPC members.
Okay, and so is there an actual date that you're expecting to deliver this to the Minister?
We're trying to do that as soon as possible.
Okay, but I mean, there must be some timeline that you have on your computer that is
we're trying to do that.
So,
Sorry.
what is the date?
Yeah, we're trying to do that by April. Yeah.
Okay, by April. Okay, so before the budget, presumably.
I don't know if I have a...
Okay. Okay, thank you very much for that information. I appreciate it. Has Investment New South Wales been involved at all at trying to keep CSIRO in Everleigh?
We have had some conversations with CSIRO about retaining that space.
Mhm.
Obviously, it's a key part of Tech Central.
Yeah.
Yes.
So what have those conversations resulted in?
So productive discussions to date. I'm not aware that CSIRO have made a final decision.
Okay. Is there any funding on the table to try to entice CSIRO to stay?
No, there is not.
Okay. Is there any support in kind? No.
There isn't.
So what kind of, why would CSIRO
stay?
Well, obviously we are engaging with them and other potential occupants of Tech Central about the benefits of the local ecosystem. And that in itself, I think, is a strong selling point.
Okay. I'm sure the CSIRO would like to stay, but I don't know that their feelings about the situation are going to be enough. So have you made any recommendations to the Minister that there should be money on the table to invest in their staying put in some way?
No, incentives to attract businesses are not part of government policy.
Okay. Incentives to attract businesses to Tech Central are not part of government policy. Okay. How many desks are available at Tech Central?
I am going to have to ask Dr. Oldenhoven to join us again, because I know that she does have those figures for us.
Hi. So there are about 1,000 desks.
1,000?
Tech Central Innovation Hub.
Yep. And they're all available for startup founders to
Yes,
use?
correct.
Okay. All right, thank you. That's good to hear. Sorry to get you up and down again.
That's all right.
I did have a question. So these are more detailed questions about the funding. So the $4 million to support female tech founders and people from cold backgrounds, is that $4 million that is directly given to those founders, or does that include money that is required to run programs?
So that is running money for running the programs that will be provided then free of charge to the recipients.
Okay, so the $4 million isn't actually going to any founders?
No, it's going to run the pre-accelerator programs, which will benefit.
And that's over 4 years?
That's correct.
And has any been expended in this financial year?
No, not yet. So the process we've been going through is one of running a procurement process to identify the best place businesses to deliver those services, recognising that those different underrepresented groups have different needs.
Right.
So we've run that procurement process. We're just finalising the contracts with those firms, and then we can go out and offer those services to those groups.
Okay, and the $6 million to establish an innovative manufacturing adoption fund, has that been set up, that fund?
No, that hasn't. So that's under development as well, as are the Housing Innovation Network and the Housing Innovation in Construction Fund as well.
Okay, and the $38.5 million for Tech Central, what is the breakdown of that, I mean, in broad terms?
So I don't have a breakdown at this stage. So that will be determined as we finalise the transition into the Tech Central Innovation Hub.
So nothing's been spent yet?
So we have spent some money. I just can't give you a final figure or a breakdown. And also we're still...
Are you able to do that on notice, please?
So we haven't finalised those numbers yet. So I don't have any final figures yet.
Okay.
And in terms of the other programs that will be run that will support the delivery of the Tech Central Economic Development Strategy, we'll announce the amount in each of those initiatives as they're designed.
Okay.
So that's why I'm afraid I don't have a breakdown at this stage.
Okay. On the trade and investment strategy, I was having a look at the figures, about 500 million in export sales and education exports according to the trade statement. With the growth of exports goal of $100 billion added over 10 years, this seems to be fairly substantially under that as a marker in time for 1 year. So I'm wondering if you are, and the same goes for the attraction of investment, $25 billion.
So I think
and $1.4 billion in capital investment.
Yeah, absolutely. So I think we've got two different types of targets in there. One is of the overall growth. So that additional 100 billion in exports relates to total statewide exports. So that went from about 142 to 153 billion in the last year, so about 10 billion in the first of 10 years.
Okay.
The other figures that you're quoting
are...
I
think I got a different answer to this last time, but okay, yes.
Okay, the other figures in there are where New South Wales state government provides direct support to businesses to facilitate. So clearly we target our activities where there's market failure.
Yeah.
The big end of town don't need our help exporting. Small businesses who don't have the skills or expertise or market knowledge, that's where we...
Sure. Okay, so that 100 billion and the attraction of investment is not directly facilitated.
So the 100 billion is not, the 1.4 is.
Okay.
That's the directly facilitated amount.
Because my view on the 100 billion, if it's not directly facilitated, is that it is very, it lacks ambition actually, and that's actually concerning that it's not going to grow more than that. But that's a matter.
We did engage with Treasury colleagues who acknowledge it as an ambitious target relative to their baseline assumptions for GSP growth.
Okay. Well, yes, unfortunately our GSP per capita is falling at the moment, which is troubling in itself. So, okay, well, I'm glad to clarify that. Thank you very much for the information. And I think with 11 seconds left, was there anything else in the... I think that's about it from me. We'll wait until the next one. Thank you very much.
Thank you. And just to let the opposition know, I don't have a full 20 minutes of questions, so I'll run through the rest of my questions and then throw to you in a few minutes. So, thank you. Sorry, I had one last question in regards to the Astle inquiry recommendations, and it might be something that needs to be taken on notice. But just in regards to my last question about the service provider that was appointed for the advocacy service of female inmates, if you're able to advise how many female inmates have accessed that service to date.
I can take that on notice.
Great, thank you.
And if, or the Secretary wants to provide you with the information around the policy, which you asked previously about the sexual misconduct policy.
That would be great. Thank you.
Was that the sexual harm prevention pathway?
Pathway, yes.
So my understanding it's in final consultation.
That's right, yeah.
And you do for release on 28th April.
Sorry, could you just say that a bit louder?
Yes, sorry, Ms. Hurst. So the sexual prevention pathway is in final consultation, and Corrective Services is aiming for its release on the 28th of April.
And that pathway will be an official policy?
Yes.
That's right, yes.
Thank you. I also wanted to find out about any new internal mechanisms enabling inmates to request reviews of disciplinary decisions made by Corrective Services, and how inmates would be able to access that.
We are still working through our policy response around inmate discipline. So whilst there has been change in our legislation, we're still working on our policy response. So we'll give you what we can on notice, but there's still some work to be done.
Okay. Do you have the timeline of when that new internal mechanism might be done?
Okay. End of March.
End of March.
End of March.
Okay.
We have already communicated some of the changes to our staff, but end of March.
Thank you. And has the comprehensive review assessing the effectiveness of the classification, placement and case management processes of inmate across the state, has that commenced yet?
No, that hasn't. That's part of the capability reform, and we're working that up to, that's an extensive program that'll probably run over 2 years. There'll be 12 months worth of the planning in relation to that, and then there'll be funding sought for that, and then so it's intended that it'll run over about 2 years to actually get that, because there's many things that have to be considered in relation to the classification, because the intent is to make sure that we've got people who are appropriately classified so that they can be in the less restrictive environments. So there's a broad range of consultation that needs to take place, not only with the PSA. So,
and so, how long will that consultation process take?
I would imagine that consultation will form part of the first 12 months, as like we'll do that in there, and then we'll look at the implementation following that.
And so that's that full 2 years would be the second part will be the implementation.
That's right.
And will the review include your partners in closing the gap target 10?
Yeah, the review will, yes.
Yeah, they'll include them.
yeah.
Thank you. Last estimates, answers to a supplementary question referenced a report by the New South Wales Ombudsman into inmate discipline in New South Wales correctional centres, which recommended that corrective services review all inmate disciplinary decisions with compensation orders since 2016, and you indicated that review was in progress. Can I get the status of that review and if it's now complete?
It's not complete. I approve the reimbursement of those funds to inmates in tranches. We're well through the process, and I'll answer on notice how far we've got to go.
Thank you. And if you could, if you could let me know the timeline as well around
the completion of that.
Yeah, the completion, that would be fantastic. Thank you. I also wanted to get a bit of an understanding about the outcome of the review and whether the findings will be made publicly available.
We have obligations to update the Ombudsman as to what we've committed to put it in the public domain. I'll take that on notice if that's okay.
Thank you. And if you could also take it on notice whether or not you can provide a copy of the findings to this committee. I know sometimes there's a bit of a different process to providing to the committee. You can request confidentiality and redact certain parts of it as well, if you felt comfortable with that. Lastly, I just wanted to ask how many complaints about denied legal access have been received in the last 12 months. I note that I asked that in last estimates, but I didn't really get much of an answer on that one.
Yeah. Sorry, we don't have that with us. We'll take that on notice.
Thank you. That is the end of my questions, unless anybody had anything that I'd asked which they've got further information on now. No? Okay, in that case, I'll throw to the opposition.
I just have one quick one that I should have asked at the end of the last session. On the data centre strategy that's being developed, is Investment New South Wales engaged in that process?
Yes, we have been engaging with Infrastructure New South Wales, who are leading that process.
Yeah, so what kind of advice or information are you providing?
So we have been supporting through the consultation process that they've been undertaking, but also providing insights from the work of the Investment Delivery Authority to support the work that Infrastructure New South Wales are doing. So, for instance, we are, through the IDA, getting an earlier understanding of some of the potential demand for water and energy that will come down the pipeline, and providing kind of those insights across to Infrastructure New South Wales.
Okay, so the IDA are using you to get to the Infrastructure New South Wales process?
No, just that the IDA recognises that there's a need to both facilitate investment in what is essentially, as you know, a critical digital infrastructure, but also that brings challenges to the state, and hence there's those two parallel pieces of work that are going side by side and informing each other to ensure that we do manage those challenges.
Okay, nothing's been approved through the IDA?
No, the IDA is in its final stages of approvals processes.
Okay, cool. All right, thank you. Thank you.
I'm not sure if this is home warranty insurance. Do you look after that at all?
Sarah.
I'll ask the question, and then could you explain why this type of insurance, to say like an instance of in Port Macquarie, to build 2-3-story apartments, it was quoted to cost $250,000 by iCare for that type of insurance, and it's the only provider that does that insurance. Whereas in Victoria, for a similar project, they'll quote it at, say, $18,000, and in Queensland quoted at, say, $30,000. Why is New South Wales so much more expensive, and what kind of impact is that having on the building industry in New South Wales?
In terms of the cost and the iCare question, that's actually a matter for the Treasurer.
Yep.
iCare sits in his portfolio.
Be the case, yeah. All right, so I will go to underquoting now. How many underquoting complaints were received in 2025?
448.
How many, sorry?
448.
448. And of that, how many investigations were...
Sorry, I should just to clarify, that's complaints and inquiries.
Okay. So it's not two separate. Okay. And maybe you can say how many investigations remain open?
Investigations on foot. So we have, let me see if I have that information. I think I will need to take that
on notice.
On notice.
Okay. And I know you said before there've been 3 suspensions. Are you able to advise how many might have had received warning letters or penalty notices? And I know that you said none of them have resulted in prosecution yet.
Yes, I can. So in terms of the number of fines that we've issued, in 24-25 that was 72 fines. And then from 1st of July 25 to the end of 25, another 22. And then the warning letters, the team's really been increasing the number of those. So in FY25 there were 40, and we've already done in 6 months another 53. So we are sort of starting to see a ramp up. And then the other thing that has actually been a really useful tool is our newly launched name and shame register. Oh, yes. So I think that it sort of amplifies the impact of fines, because in the past we would issue the fine, but that would not be made public. But with our new name and shame register, we issue the fine, and then after 90 days, that fine and the name of the agent appears on our name and shame register. And really what we're finding with that tool is nobody wants to be on it, and obviously the impact on people's business is quite profound. So that of itself is really amplifying the compliance, the fines that we're issuing.
And then when you're doing, say, an underquoting investigation, what would be the average duration of such an investigation?
It will really depend on the complexity
on the type of
the investigation.
Okay.
That's right.
And I guess what's the like with evidence, the threshold that must be met before prosecution is approved or taken to that next step?
So we would either look to prosecute under the existing provisions of the Property and Stock Agents Act, or we have also the option of prosecuting under Australian consumer law for false and misleading. As I was alluding to earlier, the current provisions in Part 5, Division 3, they have certain requirements. So they have to, an agent has to include their reasonable estimate of a property's likely selling price in the agreement. There's sort of requirements around how that estimated selling price, or what we could call ESP, can be expressed. They can't publish an ad that indicates a selling price that's less than their ESP. When they get offers above, they have to keep revising up, publicly revising up, and they have to maintain some written records, and also to provide evidence of how they've reached the selling price. But some of the challenges that we face is, which will be remedied, we believe, by the new legislation, is just around the record keeping requirements for a start. So they're probably not as expansive and extensive and as prescriptive as we would like them to be. And I think if that is remedied, that will make it easier for us to prosecute. But also there's some other sort of technical things which I won't sort of take you through, but it does, there are some difficulties under the current provisions. The other thing that I think will be quite a game changer is at the moment they have to come up with their estimated selling price based on 3 comparable properties, but the only way for us to see that is to send an inspector in, get copies of the files. Under the proposed laws, that will all be made public, so people will be able to see the 3 comparable properties. we were expecting people to come forward and say, well, that's not a genuine comparable property, so that estimated selling price is not legitimate, which will make it a lot easier for us as a regulator to be able to take action.
Yep. So, so you've indicated there is saying underquoting is difficult to prosecute under the current legislative framework, but and you've provided formal advice to the Minister, hence why we're doing this reform process. Is that?
That's correct. So I have a policy and legislation team, and we've, alongside with stakeholders, have put forward advice to the Minister around some of the impediments that we face and some of the potential solutions.
Okay.
I would say, though, upon reflection, sometimes suspending a real estate agent's licence or disqualifying is actually a much more powerful deterrent to the rest of the industry. We're stripping them of their livelihood. Often, if we're suspending them even just for 30 to 60 days, it does mean that clients have to go elsewhere. They lose business. Their reputation is compromised. So whilst suspension is not a punitive sort of tool, it is a protective tool because we suspend licences to protect the public. It does have quite significant ramifications for agents, and therefore some might argue that that disciplinary action, the suspensions and the disqualifications, can often be more powerful than a prosecution where the agent is still in the market. The prosecution may take up to 2 years. A decision is reserved, and you understand sort of what I'm saying.
And you don't know when the bill will be forthcoming, do you?
So the Minister mentioned this morning it was imminent.
Imminent.
Yeah.
Okay. And can I move now to this Strata and Property Services Task Force? Sorry. And I think the Minister said there was 8.4 over forwards, which has, say, 2.1 per year. How much has been expended of that?
So the budget is, we are running against the full budget for that, and indeed I've done a functional review which was touched upon earlier, which actually means that we've got an even larger workforce in our Strata and Property Services branch of fair trading. There's now 146 staff members there. So the budget, the 8.4 million budget, it actually understates the funding that's been put towards it. And as the Minister mentioned this morning, we're building that out. And he mentioned some figures around 17 inspectors and 17 investigators. And I'm pleased to say that actually we've recruited even more than that just very recently. And we're up to now 21 inspectors, 21 investigators. But the total workforce there is 146 people. So a really strong contingent of people who are focused on holding, those that do the wrong thing to account.
Yep. And so how many inspections then have been conducted?
In property, we undertook 400 inspections in FY25, and we issued over 300 fines. And then in the last 6 months to the end of December, we've issued another 100 fines. So that's quite significant. And then whilst we haven't prosecuted for underquoting specifically, we have in the last 24 months had 16 successful prosecutions against real estate agents, and penalties in the realm of sort of $350,000. And we are currently, New South Wales Fair Trading is currently in court as we speak. We have 7 active prosecutions that we have initiated against real estate agents, with another 9 matters with our legal team for assessment. So, it's a very active team. We are sort of unfortunately seeing particularly trust account fraud with real estate agents. We see that quite a lot, and we just need to make sure that consumers are protected and that we act quickly to hold those people to account.
So you said 350,000, is that like the total value of penalties?
So that was the penalties, but the important point to make is that Fair Trading also runs a property compensation fund, which means that those consumers who have been adversely impacted by this behaviour can lodge a claim with us to receive compensation from that fund. And that fund is contributed to via licence fees of real estate agents. And I'm really pleased to say that in FY25 we actually compensated 114 consumers through the fund, and we paid them out a total of $2.8 million. And then in the 6 months from 1 July 25 to the end of the year, we've finalised another 94 claims. So as you can see, we've almost finalised as many claims in the 6 months as we did over the whole 12 months the year before, and we've paid out an additional $2 million. So that's $4.8 million back in the hands of those consumers who've unfortunately been impacted by the wrong
And say
behaviour.
of those, say, enforcement actions, how much of that has, say, resulted in, say, rectification or behavioural change in the agents?
Yeah, look, it's a really interesting question. Often where there's trust account fraud, we would disqualify licences for life. So we don't want those people re-entering the industry. I think, you know, but I mean, we've seen other, I mean, one of the examples that really left a lasting impact on me was a real estate agent who had formed a relationship with a very vulnerable elderly man who had symptoms of Alzheimer's, and she purchased the property from him, said that she would give him lifetime tenancy, but she purchased it at sort of hundreds of $1,000s under the value. So we were able, in that instance, to take her licence away as well. So there's all sorts of examples that we're seeing from the very, very serious, you know, sometimes it ranges to just not returning audits and things like that. So there's a range of behaviour that we're seeing in this space.
So, and those figures sound good. So what other, say, performance indicators does the task force use to measure success?
So it's certainly something that we are developing up. We have our fair trading strategy, we have outcomes in that strategy, and then the property and strata branch has its own business plan with outcomes. So we can certainly share the details, and we really want to make sure, as regulators, often people judge us just by the widgets of the number of inspections, the number of investigations and so forth, and we want to have a much more mature look at that, because it's not just about the widgets, it's about the impacts for customers, and it's about how we protect consumers, and so we really want to be able to measure that in a meaningful way.
And this might be hard to answer, but do you think that the complaint volumes have decreased since the establishment of the task force, or?
We're seeing the inquiry numbers static, but we're seeing the complaint numbers increase. And for me, I think that's, in the first instance, I think that's a good thing, because I think people now have confidence in fair trading as a regulator, that if they complain, we will actually take action. And I think we can expect to see high complaint numbers for at least a couple of years to come, and that's not a bad thing for us, but I would hope that in sort of 3 to 5 years' time those complaint numbers have now come down. And we are seeing a shift, I would say, in the real estate agent industry and also in the strata industry. I mean, the rest of the country is looking to New South Wales and the reforms that this government and this parliament has approved, and looking at the change that's happening here and really trying to replicate the good work that we've done.
Yeah. And is, say, outcomes measurement also part of the task force KPI measurement?
It absolutely is, and we also link in with the Building Commission around consumer confidence in purchasing in strata and things. So there's a whole raft of outcomes measures that we are adopting and will report against.
The building bill, would that be? Yep. Do you know where are we up to, like in terms of drafting, or like is it still on the table?
So the building bills themselves, the government has chosen to proceed with a building reform, which is a shortened version if you will, or certain sub-elements of it. That is being drafted at this point in time, and industry engagement is underway. I was asked earlier about the industry reference group. It's actually 22 organisations that are represented there, and we're in the middle of the engagement period with that group.
And does a regulatory impact statement have to be part of this reform, or?
So the reform is focused on 3 areas. Modern methods of construction, so defining modern methods of construction more in line with typical construction works. Easier planning pathways to make a submission of planning documentation, particularly in Class 2, simpler, and increased penalties for private certifiers under conflict of interest. They're the 3 areas that are covered under the building reforms.
Okay. And then can I move on to say viability of construction? That would still be covered by you?
Viability of, yes.
Yep.
Yes.
Have you undertaken any modelling on project viability in Western Sydney?
Oh, as in the financial viability of it? No, that is not something that we look at, financial viability.
Okay. So then you wouldn't... okay. I was just thinking about assumptions used for material cost inflation.
No, that would not be building commission.
Okay. Okay. All right. And you mentioned certifiers before. And there's the say 50% income cap and statutory review. Has drafting commenced on the proposed 50% income cap?
So for the certifiers' conflict of interest areas, the drafting for the legislation has commenced on that, yes.
And have you provided, say, advice on enforcement feasibility to...
Not at that stage.
Not at that stage. So whereabouts are you at, like...
It's at industry engagement as far as that's concerned. Once we've got the industry engagement, we'll be able to input that feedback into the development of the legislation.
Yep.
And that will go to government.
Okay. And you don't really have a timeline, though, for that?
I don't have a timeline for that. After that, regulation will need to be developed.
Yep. Okay. All right. And trade promotions, who does that one?
That's me, yes.
I was just wondering, when is the community gaming regulation scheduled to be remade?
I'm afraid I'll need to take that on notice.
Take it on notice? And has the department conducted any compliance review of subscription-based trade promotion models?
There has been quite a bit of work undertaken both at New South Wales Fair Trading but also across the nation in our peer group. But again, I'd like to take that on notice and give you do justice to the detail of it.
So probably has legal advice been sought regarding the compatibility with... I suppose you have to take that one on notice as well. I might do these ones as supplementary questions, if that's okay. And I might turn back to corrections, if I could. Yeah, sorry. Got one more after, isn't it? Have you got a question, Molly?
Yep. I have a question about the rising tide protests. Obviously, it's got some implications for trading partners. Does Investment New South Wales provide advice to the Minister about impacts of rising tide and those protests?
Not that I'm aware of, but I'm happy to take that question on notice.
Okay, that would be helpful. Do you do any engagement or planning with, for example, the police on matters like this?
So our role is more engagement direct with businesses and facilitation of industry directly.
Okay. Go ahead.
Thanks. With regard to, say, recidivism or reoffending, how exactly is, say, 12 months reoffending calculated? Is it reconviction, court appearance, or return to custody?
We have a number of different measures. So we have the report on government services, which measures the rate of return to corrective services, which is from the day that someone is released from a sentenced episode of custody, whether or not they come back into custody under sentence within 24 months is the first measure. Then we have another measure which we used as part of the Premier's priority, which was the rate of reconviction for a personal, property or serious drug offence within 12 months of release from a custodial episode. And then we have a third measure which is reconviction for any offence within 12 months of release from a sentenced custodial episode. And then we have a series of equivalent community measures for people who are sentenced to a community order.
Okay, so of the, where you said whether it's property, violent or serious drug offences, do you have any figures on that?
On what the rate of reoffending is?
On
or
each
the
of
breakdown?
those offence, yeah.
Can I take that on notice? That is produced by the Bureau of Crime Statistics and Research, and we can get that and provide that for you.
Mm-hmm. And are you aware, or do you know what proportion of offenders or reoffending occurs, say, within the first 90 days?
That's in the Boxar report, and I can take that on notice and provide that to you.
And does the department internally model projected reoffending risk based on, say, current trends?
We do get a quarterly report from our Corrections Research Evaluation and Statistics team on the rate of reoffending, and in line with that we get equivalent updates on how we're tracking on a range of indicators that are, I guess, proxy indicators for how we expect the rate of reoffending to trend. So the average number of hours that people are receiving of treatment and intervention, that's all provided in our quarterly report.
Okay. So on that, say with, programs, what percentage of, say, the higher risk, and this is, in custody, inmates achieve optimal program dosage? So I think is it 140 hours that they're meant to do prior to release?
So it ranges,
or depends on
on their risk level. I think at the last report, I think I have here, I can provide you, or I might have closed it. I might have to take that on notice, but we don't report it as the proportion that achieve the minimum number. We report it as the average for the eligible cohort.
Mm-hmm. And do you know whether you'll have to take this one on notice as well, whether the percentage has increased or decreased since 2023. So, and do you know what the average waiting time for entry into, say, accredited behaviour programs is?
I'll have to take that on notice.
And are there current, say, capacity constraints limiting access?
To programs in general? Not in terms of capacity. There's always challenges, operational challenges with running programs in terms of ensuring we've got, we're able to retain our highly qualified and trained staff. In terms of the operations of different centres, ensuring that the daily routine is able to facilitate access to inmates to be able to run programs. They're the key challenges we have rather than operational capacity.
And is, like, if you track, say, offenders that have done programs versus those that weren't able to complete, are you able to, say, track reoffenders by program completion versus non-completion?
We don't track it by completion and non-completion, but we track it by what we call dosage, so the number of hours that people complete while they're in custody, and the evaluation looking at the relationship between the dosage and the rate of reoffending shows that the more dosage people receive, the less likely they are to reoffend. So reinforcing that evidence we have from other jurisdictions and internationally, that it's not about completing a single program, it's about completing a range of programs relevant to a person's need with sufficient dosage to help them adjust their attitudes and their behaviour.
And have programs been reduced or suspended in the past 2 years?
I'd have to take that on notice. That could be a very detailed answer in terms of, is there a specific program that you're interested in, or just in general?
Well, I was thinking, say, domestic and family violence programs.
Not that any were suspended. We have just recently developed a new intensive program for domestic and family violence previously we had run a moderate intensity program, our EQUIPS DV program. So we've developed a new one that we're just piloting now.
Okay, thank you. And education, so what percentage of inmates are engaged in vocational or foundational education?
I'll hand over to my colleague.
Okay, sorry.
Sorry, just in relation to that question, I'd have to take on notice in terms of a percentage.
Yep.
But I do have some figures around the total numbers of inmates that have participated in different education programs in previous years. So maybe taking on notice, and we can give you some data across different indicators.
And of, say, inmates that start a traineeship, do you know what the completion rate is?
In terms of traineeships particularly, I'll take the completion rate on notice as well.
Okay. And with regard to, say, First Nation or Aboriginal inmates, what is the participation rate?
I'll take those types of details on notice.
Okay. And because we always also know, re-entering or going into the workforce is important once you are released from custody. Has the department evaluated the impact of, say, traineeship completion on reoffending rates in New South Wales?
Yes, there has been an evaluation done, particularly around traineeships. The Boxer did that evaluation. In terms of the details of the outcome, I'll take that on notice because it was a very significant positive outcome.
Yeah.
I think it was in the order of 10 to 15% shift, which is, in this domain, one of the most sort of significant rate of reduction of recidivism that you'll see. So it was a very, very...
and a higher positive effect for Aboriginal inmates, which is an extraordinary result.
Yeah, yeah. And I was asking about reoffending rates, but do you know what the current, say, Aboriginal reoffending rate is? Sorry.
I would have to, if you're happy to wait a minute, I can find that for you. Okay, so, thank you. So the rate of reoffending for Aboriginal people returning to custody within 12 months is 75%. That's the baseline, right? And the most recent one is 76.4%. So we've had a recent increase of 5.4%.
Within 12 months. So is there like a strategy document guiding operations with regard to Aboriginal offenders?
That forms part of the work we're doing on Close the Gap, which we're doing in partnership with the broader DCJ. We do deliver a lot of programs for Aboriginal people, both in custody and in the community, but the development of a specific strategy will form part of the Closing the Gap work.
Okay. And are you aware, are Aboriginal community controlled organisations engaged in, say, through care delivery?
At the moment, they are in delivering specific initiatives, but in terms of the Close the Gap strategy, the leadership and development of that strategy for DCJ is being co-led with CAPO and Aboriginal community-controlled organisations.
Okay, I might ask more some questions later on that one. We also know housing is important, or with regard to when inmates are released. So do you know what proportion of individuals, and I probably have to go, exit custody with confirmed stable accommodation?
We can take that on notice. Unless you want to answer that. No, we have to take that on notice.
And what about, I know, like, identification documents are hard to come by, so what proportion exit custody without, they have to go and they have their release certificate for identification rather than birth certificates or,
So 80% of inmates are released from custody without photo ID.
Sorry?
80% of people are released from custody without photo ID.
Because there used to be a program for inmates to be able to get birth certificates.
We still have that program. Yeah.
And are they encouraged to...
They are, yes. Yeah. So birth certificates, we do a lot of work to facilitate access to birth certificates. The challenge is around photo ID for people exiting custody and getting that 100 points of ID to get a photo ID.
And is there a mandatory, say, custodial to community case handover process across all centres?
I might hand over to my colleague.
Could you just repeat the question?
Like, when they're being released, I understand, like, an appointment would be set up with, if they're being released to parole, with the Community Corrections Centre. Is that... It's mandatory, though, isn't it, that process?
Yeah, so if we're talking about people being released to parole, there's two pathways to parole. There's obviously a statutory parole order for people with sentences under 3 years, or parole orders made by the State Parole Authority. In both cases, in the period of time leading up to either the release on parole or the consideration of parole, work is done with community corrections officers in parole units to start preparing for release. And in the case of matters going to the Parole Authority, you prepare what's called risk mitigation plan. At a point in time, as things get closer to the potential release date, there is interaction between the parole units that are based in the centres and the relevant community corrections area to which the person is most likely to be released. So going on from your previous question, one of the biggest issues is uncertainty that can attend to the ultimate address that the person is going to. But that process is mandatory.
Yeah, because they do a what do you call it, post home.
In some cases, there'll be
if there is a home to go to,
a home visit to assess the suitability of accommodation. Yeah.
And what is the average, say, community corrections caseload?
I'll have to take that on notice. We do know that there is variation.
Depending on the risk?
Yeah, so if offenders coming onto a caseload are risk rated, obviously, in addition to a parole load for people coming out of custody, is a very significant community-based sentence load. Risk rating is used, so as a process for allocation of workload, the risk rating is used to generate a caseload for each officer. So the actual number of people on a caseload can vary depending on the risk rating. There is also different loadings based on whether the office is in a regional location, and so things like travel and those other logistics have to be factored in as well. So it is actually quite a complex process through which workload is allocated.
Yeah, because if they've got reporting centres or...
There's reporting centres and then the number of reports that have to be written as well. So
okay. And do you know what the current vacancy rate in community corrections is at the moment?
I'll take that on notice.
Okay. And do you know, like, this is probably overall for corrective services, so what are the current sick leave rates?
We might take that on notice if that's all right.
And would you be able to say compared to, say, 2023, like on notice?
We can give you a range.
Yeah. And you probably say, what are the current workers' compensation trends? Would you probably take that on notice as well? Yep. And do you know what the total overtime expenditure for the last financial year was?
Not off the top of your head. We can
take it. Yeah.
And I think have staffing shortages resulted in restricted regimes or maybe lockdowns is a better...
We took a question on notice before around lockdowns, and
Yep.
I think in evidence we've acknowledged that a lot of those lockdowns are a consequence of staffing shortages, which we are seeking to address through some pretty active recruitment campaigns. But that'll come on notice to the committee.
Okay. With regard to, say, I think we asked this question last budget estimates with regard to transgender policy. I don't think it was available on the website. Do you know if that's changed, or what is the current operative policy governing classification and placement of transgender inmates?
It's still in draft.
Yeah, we're still updating our policy.
Still, and do you know how long that will be before it is updated?
No, can we answer that on notice?
Yeah.
Okay.
I know the work's well progressed.
Okay. They might have to do... No. Have you got more questions? Because I'll ask these as supplementary, because if you can take them on notice.
I could ask about, so obviously Minister Chanthivong is Minister for Industry. Is the Minister taking any responsibility for work going on with the forestry industry and the Great Koala National Park?
So, no, that's being led by Minister Sharp, I think.
Mm-hmm. And on apartments, is there a breakdown for, so 406,000 homes promised under the New South Wales industry policy, how many are apartments? Do we know? Do we have that figure?
So I'll have to take that on notice. Sorry, can you just point me to that figure? I thought it was 377,000.
I did as well. Sorry, I've
377 by 29.
Yeah.
Okay, regardless of the figure,
Yep.
Are apartments, is there a breakdown between apartments
So
and
apartments are definitely included in that number. I'm happy to take a question on notice as to whether there is a breakdown.
Yeah,
I'm not
okay.
aware of one, but I'll take it on notice.
Okay, so it would be good to know if there is a breakdown in the target between dwellings that are like discrete dwellings and apartments, and potentially other types of dwellings if they're, I don't know.
Class 1,
Yep.
2, 3,
Sure.
and 9C.
Yep, sounds good. Thank you. And then if there's any delivery against those to this moment, that would be helpful.
Yep, happy to take that on notice.
Thank you. Yeah, I think that's all. Oh, does Investment New South Wales have any biosecurity officers or staff?
Biosecurity, no, we don't. I think that those members are in the Department of Primary Industries and Regional Development.
Yeah, okay. And are you working on claims farming? Is there anybody doing probably fair trading on claims farming?
Can you give me a bit more context?
So my understanding is that there are basically third parties that are finding vulnerable people who might be able to make a compensation claim, workers' compensation claim. And apparently the Daily Telegraph reported that Fair Trading was investigating a third-party claims company which was warning motorists about possible scam schemes.
I'm not sure about that one. I'll see what I can find out.
Thank you.
Yeah.
Thank you. Are there any government questions?
Well, the Honourable Eileen McDonald covered most of ours. So,
That's very generous.
I'll ask if any of the witnesses have any other matters that they wish to clarify.
Just to repeat what I recall as the evidence at Minister Dibb's hearing the other day.
Yes.
On Moree Youth Bail, stressing it is a bail Minister Dibb portfolio matter, but the allocation is $8.75 million for the Moree bail accommodation over 3 years, and it's tracking within budget.
Beautiful. Thank you very much. I appreciate that.
I'm just checking again that there's nothing else that people want to put on.
I have some answers to questions that were taken earlier today, but I can provide them on notice if that's...
Whichever you prefer.
If you wouldn't mind. It was just in relation to the question I was asked about automatic mutual recognition for real estate agents. I mentioned that we'd had 87 eligible notifications, and I was asked to break down which jurisdictions they had come from. So there were 43 from the ACT, there were 6 from South Australia, there were 31 from Victoria, 5 from Western Australia, and 1 from Tasmania.
Thank you. I really appreciate it. Yes?
I was asked about the sentiment survey. We have commenced a sentiment survey. We've got a sentiment survey for our Construction New South Wales courses, which has been running for quite some time, over 100,000 courses completed, and that is 4.3 out of 5 is the feedback high number. And we've only just recently commenced the sentiment survey on complaints, so we don't have a decent data set yet.
Okay. Thank you.
Thank you. Nothing else? Okay, wonderful. Well, thank you so much for your time today, and particularly this afternoon. The committee secretariat will be in touch in regards to those questions on notice and any supplementary questions that may come from committee members as well. But thank you so much for the work that you do, and thank you for attendance today.
Thank you.
Thank you very much.